Well, good evening, all of you fine folks. Good day, wherever you are. Welcome to the channel Law and Lumber. I'm Rob Morton, and though it might not look like it, judging from the hat and t-shirt, I am in fact a practicing attorney and have been practicing law for more than 13 years. And this little show that you have decided to join is called Friday Night Frenzy, where we break down a lot of the things that happen in law over the past week. So, jumping right into things, how are we doing this evening, folks? I decided to try and give a little preview to people who might not know who might not know who we are, rather who I am. So what are you guys doing? Where are you tuning in from? What are you drinking this evening? What are you having this evening? Hi, Rob. Hi, Kristen. How are you? Member of the jury, you're braver than I. Okay, we're getting some people tuning in, saying hello. How was your week, folks? What are you having for cocktails? We have a lot to cover today. A whole lot to cover today. I bit off way more than I could chew. So, on the docket for this evening, we have Sam Bankman-Fried, who has had his campaign finance charges dismissed by the federal prosecution in New York. We have Sam Bankman-Fried, who is facing the possibility of being detained in jail prior to his trial in October because of some, poor decisions on his part. Then we have Bryan Kohberger, who has filed a motion to dismiss the indictment that came from the grand jury in the state of Idaho that brought charges against him for the killing of 4 individuals in Latah County, Idaho. Then we've also got to recap a little bit of the Taylor Schabusiness because, since when do we get a trial that begins and ends in a week? Might as well. That plus, oh my gosh, the Sarah Boone letter. Someone sent it to me, and I feel like we have to read through it because there's just too much. It's just too much. So before we really get rolling with all that stuff, let's see what you guys are doing. What are you up to? How is your week? Only 6 minutes late. I wasn't that late this evening. We have storms rolling in here. So if for some happenstance the stream goes down, that's the reason why. It's not tech issues. I hope I should not have said that out loud. Nope, shouldn't have said that out loud at all. Yep. Nick, New Jersey, and iced tea. Hello, my friend. Tequila in Las Vegas. Where else do you drink tequila? I don't feel like it's a beverage that you quite often choose when not in Vegas or Mexico or on vacation. Sparkling water in Quebec. It's hot everywhere, Vez. Glad to see you here. Diet Coke in Connecticut. Thank you, Lynn. Crazy Cat Queen, Coca-Cola without the red wine. Red wine and Coke. That is something. Our Canadian friend Ian Runkle from Runkle Bailey loves that, and I despise it. We might actually play a little bit of his getting ready because I think I might make a competing getting ready video. I don't know. I feel like that might be a good place to start this evening. So we might do that. I did text Ian. I said, please don't copyright hit me. If I play a little bit of that, I will direct them to the channel. I won't play all of it. But it's just too funny not to play, to be honest. M169, I'm predicting some naughty words when discussing SBF. It's possible. It's certainly possible. Pam Graham, Southern Illinois. It's hot here. Drinking water. It's hot everywhere. It's like 98 degrees when I left the house this morning. It was ridiculous. Law TX. Hey, Robin chat. People chiming in. People tuning in saying, hey, what's up? Cheryl Moran. Hello. Liz McFall, another 100 degree D and 100 degree 100. See, there are words, Rob, and you throw them into a sentence, and when you say them coherently, they make sense. But that's what Fridays do to us. Another 100 degree day in Central Texas. People have had this ongoing debate forever. Now, the debate is whether a 90 degree day in DC humidity, and don't kid yourselves, DC was built on a swamp. It exists as a swamp. It is hot and humid in the summer. Or Florida humidity in a 90 degree day could combat or compete with, say, Phoenix or Central Texas on a 100+ degree day. Having been in both of those territories during that time, I will say it's 6 of one and half a dozen of the other. The heat in DC with the humidity is just all surrounding. You cannot escape it. You walk outside and you are instantly sweating. However, when you are in that level of oppressive heat in the Southwest, my word. every bit of hydration that you had in your system is gone. It's zapped out of you. And the heat is something that just, while you don't feel it from head to toe, it is oppressive. So I don't know. I'm going to stick with my guns and say that basically they're the same. They're just different. They're different forms of torture. Different forms of torture indeed. Danielle, hey, Rob loved you and EDB in the Lawyer You Know chat. It was hilarious. We brought the appropriate amount of chaos. For those of you who did not see, my dear friend Peter Tragos, Lawyer You Know, who is celebrating his 250,000 subscribers this evening, he was reviewing the same Coburger motion that we're going to go through last night. And Emily Baker and I, well, we were very, very curious because one, Peter doesn't stay up that late. And two, well, I wanted to see what he had to say. So we were both in chat. We're just poking some fun, having some good times. But that was a great time. That was a great time indeed. What else we got here? We got White Russian in Florida. It's a little warm for a White Russian, to be honest. I don't know if that's a warm weather drink for me. Eesh, I don't know. Diet Sprite in Houston, Texas. La Croix in Southern California. South Carolina girl. Hey, Rob, I'm from Charleston, South Carolina. Well, hello and welcome to the channel. Are there cases that you would like to cover out of South Carolina? I don't know. There's cases all over the country right now. Irene, listening while my daughter is watching TV and waiting for our pizza. Pizza is a Friday staple in most households, at least in this one. I adore some pizza in the evenings. Doing great. 1 a.m. in the UK with a big mug of iced strawberry tea. Indeed. You are in the UK, as well as a friend of mine, Ian, who is currently on a bus traveling overnight to his next destination. And now he promised me that he would attempt to sleep on the bus. That's not going to go well. But he did say that he was going to nap because he was over there for the celebration of Captain Corey, the celebration of life that took place there, and seeing him dressed up. Well, you know what? Why don't I share that? For those of you guys who had not seen it, let's see. So Captain Corey is wonderful boy who was diagnosed with a terminal. Well, he was in palliative care, and he was a Make-A-Wish. He was a Make-A-Wish celebrant, where essentially Johnny Depp knighted him. He was a wonderful person. He shared his channel, grew his channel. We got his channel to above 100,000 subscribers, and he was a really, really bright person for all of us to interact with. Ian and I both made him play buttons, YouTube play buttons. Ian's made out of leather, mine made out of wood. For those of you who sent me the video where he does the unboxing of those, and the tribute video where he unboxes mine and Ian's next to the silver play button, I thank you for sending that to me. I cannot watch that again. That was an emotional one for me. But Captain Corey had a celebration of life this past week because he unfortunately did succumb to his illness 2 or 3 weeks ago, and the streets of his hometown were lined with people that were dressed in pirate regalia. It was absolutely beautiful to see, and I don't know that I've ever seen something that was really, really that cool. I'm talking because I'm trying to find the photograph that I found, rather the photograph that I wanted to share from that specific event. Here we go. So we had to postpone Trials of the Century behind the scenes video this week because there were more important things that were going on with Mr. Runkle, and that would be Ian Runkle, Runkle of the Bailey, and Steph, the Alter Nerd, both YouTube creators, both wonderful, wonderful people who made the effort to be there in attendance. I have trials the next 2 weeks, and I was unable to make that trip, but you know what was really, really cool about that? That little tie that he's wearing on his neck. So the tie made the trip. So the bromance of the traveling ties continues, and Ian was there dressed head to toe in pirate regalia. I love it. I love the effort. So that made me very, very proud to call him my friend. So that was really cool to see. So Well, my gosh, that took a turn, didn't it? You guys want to talk about some law stuff? Whew, let's see. Got some people thanking for memberships. I will pull those up. I don't get to see them on StreamYard, but I will pull them up. People telling it tequila is an everywhere drink. Tequila is not an everywhere drink. Tequila is a special location drink. At least for me, it is. Diet Coke in Miami from Pat. Still recovering from that one. Cowpoke hot tea. Packing for Pensic War. Okay. Looks like we have a law talk with Mike Raid. Looks like he finished his little craziness and debauchery that was going on. I think they were covering a protective order hearing. If you have not checked out Law Talk with Mike or that channel, you need to. If you need a laugh, if you need law that makes you laugh, and if you need an infectious laugh that just makes you laugh along, Law Talk with Mike, please go check it out. Let's see if we can't catch up a little bit before we start getting to our cases. Andy, the game maker, coming with a super chat. Naughty words or nudie words, asking for a friends. Naughty words. I don't think we're going to use nudie words this evening. At least I hope not. I really hope not. Not with the subject matter we're covering. No way. I really hope not. So, fast forwarding a bit. It was amazing. I did a walk-in college tour in Dallas at 118 degrees, and I was killing it while everyone else was dying. I don't know how you guys do that. There have been several heat advisories this past week. So, Greg, yes, I'm here for the regulations and the wood. Speaking of, well, that was a weird segue, Rob. We had a members only stream. So for those of you who are gifted memberships, not only like do I practice law, but there's a woodworking side. So the lumber side of the channel is the shop side. And that's where I go to find peace. I go to make stuff. And every week I try to do a members only stream where I take people into the shop and we get to talk about stuff and make some certain things. And we had some blanks that we were making for some pens we're going to turn. And we were concerned about how they would turn out. But I'm happy to report the pens, the blanks, have turned out really cool. So that's going to be one pen. Whoop, got another pen. I think this one's going to be my favorite. That's the one that we had trouble with last night. There's a piece of wood in there that was floating to the surface. So that's going to be pretty when we end up turning it. Got two more here. Whoop, whoop, whoop. Come on, focus. Camera. Do your thing. You can do it. There you go. Green and gold and blue. That one turned out great too. We got this one. This was the glow one. I don't know how well it's going to glow. We will have to see how that turns out. And then we have, do you guys remember the Candy Mountain stuff from like, 2 decades ago? Charlie, Candy Mountain, Charlie. Well, I had a bunch of colors left over when I was making a larger blank for like a ice cream scoop or a pizza cutter. I just kind of had to mix them. So that's how this guy turned out. Oh, focus. You can do it, camera. Come on, track. Don't find the face. Track. You can do it. There it is. Oh, yeah. You got it. This one turned out really cool. So yeah, we'll throw those on the lathe some point in time in the future. That's the member stuff. I take the membership stuff. We go behind the scenes, go down to the shop, and we make stuff, and it makes everyone feel a little bit better because life is tough. And when you practice domestic relations litigation and bankruptcy law, sometimes you need a break. You need a break. Suzanne, hi, my dear. Thank you for the super chat. Hi, Rob, drinking white wine in Massachusetts. Looking forward to FNF. Suzanne, thank you very much for being here. I love the fact that you guys are here. And until we get to that lovely 2-hour mark, someone was kind enough to send me these little F-bombs. So we might have to throw a few of these around. But Suzanne, thank you for being here. Very much appreciated. Unit stuff together. Yep. That was my little faith in humanity restored moment this week. I needed that more than you guys could imagine. Ty made the trip. I was there. That tie has gone a lot of places, and I hope it continues to do so. The tie that Ian gave me is sitting behind me, as are all the other things that were created by people that are watching this stream right now or on Replay Crew. We love the Replay Crew. If you guys are here for the first time, please don't forget to like the stream And if you kind of like some of the content that we're creating, feel free to subscribe. So, Fruit Loop vodka in Galveston-ish. Is Fruit Loop vodka a thing? What? What is Fruit Loop vodka? I don't know if I want to know the answer to that. What is fruit? What do you do with Fruit Loop? Well, my ADHD brain just took over because now I'm thinking about when I had Fruit Loops when I was a kid, and I would mix them with Rice Krispies or with Cheerios. And now my brain is in this like old reminiscing deep thought moment that we need to escape from because we have to talk some law. We have to talk some law. And I got to not think about Fruit Loops, Rice Krispie treat. Olivia, thank you for the super chat. Recovering from Beyonce and Sam Hunt, Brett Young concerts, consecutive days. Oh, I can't do. I can't. I struggle after one concert. Drinking good old H2O, enjoying the chat and your company tonight. Cheers. Cheers to you, Olivia. Thank you for being here and for the super chat. Can this teacher get one of those pens? Tanya, I will tell you what. I give away almost every single thing that I make. And I do that a lot during the member streams. So I need to start making a bunch of the more pens because I have stressful weeks coming up and that's going to give me some peace and sanity. So stick around. If you're lucky enough to be gifted a membership this evening, or if you do become a member, I will be giving them away. I've never really been able to sell the things I make. I don't know why. I think part of it is that if I actually had to sell it, or if I don't know why. I do sell larger things that I have made in the past or commission pieces. I just like making it. And honestly, the act of making it and the ability to go and try new things, that's kind of where we end up. I do see you, Kurt, in the chat. Kurt's hanging out in the chat and tormenting the chat. Chat buddies for now. Chat buddies, wherever you go, I go. Thank you, buddy, for being here, tuning in. We're going to have some fun this evening because Mr. Bankman-Fried's been up to some craziness. Terry Zelensky, Captain Crunch and Cheerios is the best. Captain Crunch and Cheerios. Okay. Were you guys cereal mixers or no? I feel like I need to make a poll about this because this is a critical point that we need to figure out. And I need to know if I was crazy or not. Do I say as a kid? Did you mix your cereals or no? The yes is going to be mixing cereals the only way. Blasphemy is the no. Cereal purist. We're going to go ahead and post that poll. So feel free to answer that one. Thank you, Terry, for that super chat and for the chaos. Uncivil law. Went to the gym tonight, lifted things. Woohoo. Uncivil law. My friend, you have put in more days in the gym these past 2 months than I'm very impressed with all of the effort that you've put forward. And he is posting a lot of his community updates on the progress he's making in the gym and what he's doing. It's really, really cool. I love seeing what he's doing for himself to better himself in several respects. I have a lot of friends. I have a lot of friends on the YouTubes, and I honestly really just enjoy hanging out with all of them whenever I can, whether in the chat or otherwise. So before we get too much further, oh yes, Brentwood Chic. You want to do that? Let's do it in the back end of the intro. Let's do that because I'll pull that up during the intro while it's playing. Ian's get ready video with me. Yep, get ready with me video. Yes, because I'm going to need some chat input on how a woodworking attorney would make a competing video. I have ideas, but we're going to see what Ian does with it. Andy the Game Maker. The sexiest stairs ranked in order from sexiest to least sexy. Kurt, greater than Mitch McConnell, greater than Bag of Sand, greater than Rob. Well, I will say that Mitch McConnell, he has the staring function down, and that eye contact ain't going a lot of places, not after what we saw in the news this week. A Bag of Sand, yeah, I can see that. Thank you, Andy, for being here and for causing the requisite amount of chaos. Wherever I am not in a chat, I can always expect you to be there doing your thing. I do have the urine-scented candle that you sent me, and I'm still waiting for the unsuspecting friend of mine who will upset me to such an extent that they get that candle. Someone else has said this before, Fat Thief. I don't understand it. This comment I've gotten a lot. Law and Lumber sounds very similar to John Cusack. Really? Really? I don't know how I feel about that. I don't know. I'm going to take that as a compliment. Take that as a compliment. So, yeah. Now people are chiming in and say, I do, you don't, yes, no. The chat's divided. The chat is starkly divided. People are asking, where was this one? Chat's moving pretty quick. So where was it? Someone asked if the urine candle really exists. It does. You don't want it. You don't want to be anywhere near it. Nowhere near it. Not, nope. Nope, it's terrible. It's sealed up on that shelf. And like I said, some friend is going to irritate me to such an extent. Well, I will take that to their house and I will leave it somewhere without a label, just to be lit in some eventuality. I have to pick the right friend, though, because I can see that going terribly wrong. But some of my friends are practical jokers, so they hopefully get it. Chris, it's my youngest daughter's birthday tomorrow. Caroline is turning 8. She'd love a birthday shout out. Well, Caroline, you are turning 8 years old, so hopefully you're not watching the content on this particular channel because we talk about a lot of things that are a couple of years down the road for you to talk about. But I very much hope that you have the best of all birthdays. Happy 8th birthday. We all wish that we could be so lucky to, live that youth again. And honestly, I imagine that your mom and dad both live vicariously through the youth that you experience in each new year that you achieve. So happy birthday to you, Caroline, or Carolyn, or Caroline, however you choose to pronounce it. I'm going to go with Caroline, though. Happy birthday to you, my dear. Okay, let's roll the intro. On the back end, let's go ahead and check out some of the getting ready. And the Game Maker. I got to get through these before we go. They're Eskimo Bros and Urine Scented Candle Bros. Rob and I are the latter. We are. Oh, Andy is on fire this evening. So, man, has had more energy than anyone I've ever come across in my life. But before we go too much, let's go ahead and get our intro rolling, because on the back end of that, we're going to see what a firearms attorney does when they get ready in the morning. So without further ado, let's rock and roll. Wrong intro, Rob. Wrong intro, Rob. You did it again. You always do it every time. We are professionals. We know what we're doing all the time. We do. We always do. Of course we do. Yep. So, Mr. Ian Runkle, at suggestion from several of you, made a video. And that video was, where was it? There it is. Oh, hang on. You got to tell me if you can hear it. 1. And then 2. Let's see. Oh, I'm being told not to show a certain part of it. I don't remember where that part is. Hang on. Let me stop sharing this for a second and make sure that I know what part it is. Ah, okay. There's a part of this I can't show because I can't show certain things during live streams, which means I have to be careful. How to do this. So we're going to stop at the hot sauce part because Ian clears his house. I can't show the thing he uses to clear his house on a live stream because of YouTube policies. So I do see that Emily's in the chat. Emily, if you have not seen this video yet of Ian, just we're contemplating how a woodworking attorney would make a competing video. So you have to let me know if you can hear the volume.
Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So apparently there's this trend out there of videos called Get Ready With Me videos. They show what you do in the morning, like waking up, your morning routine, any sort of skin or hair care, that kind of thing. And people have asked me to make one. Now, I really don't understand this trend, but I guess I can show you my morning. I think it's pretty basic. It's pretty just what everyone else does. So I guess here we go. So I wake up after, a nice restful 4 hours of sleep, still in my pajamas, but I like to start things off with a little shot of hot sauce. That's the Black Garlic Carolina Reaper, 250,000 Scovilles. So that helps me wake up and get started with my day.
Yep, he's wearing the tie. I have to bypass the next part, so we're going straight into the bathroom. But yes, he wakes up with a tie.
You need to see that, so we'll just cut to after. So after my shower, I just kind of towel dry. Usually I wouldn't put the shirt on until after all of this, but family friendly. This is a really casual day. I don't have to be in court or anything like that. So I'm just wearing a button-down shirt with casual cufflinks. These are little hourglasses, just like the Roll of Law intro. So those are kind of fun. If I had really serious work to do, I'd put on business cufflinks instead of these ones. So just a real casual day. I don't need to dress up or anything like that. I also realized that some of you might have been a little annoyed that I didn't show sort of my shower routine, which products I use. A lot of people were wondering, like, how do I keep my hair? So I'll just show you now. I use, just as shampoo, Hops number 9. This stuff is great for clearing out all sorts of grease or gunk or that kind of thing. And for conditioner, I like to use this stuff here. It's got turmeric in it, which is supposed to be great for you. So you just kind of throw that in there and leave it for a bit and then let it rinse out. So good stuff. All right. Now people wondered sort of what is my routine after that.
This is my favorite part.
My favorite part. To use often I'll do a shave with shaving foam, and I use like a shaving soap. This with just a little brush here. But sometimes I'm feeling more like doing an oil shave, which use sort of an oil to, it works just as well. So that's what I think I'm going to do today. I'm using the Fly by Jing Sichuan Gold, and we'll just throw some of that on. It's just, you can use that as an oil, and then it just... Can
we talk about something for a second? So I understand that Ian's stomach is quite literally made of iron and that he can consume the hot sauces, no problem. He is directly rubbing hot sauce into his pores. Sir, what is wrong with you? Also, I know that didn't feel good. There is no way. Like, really? And it's so close to your eyes. How much did you regret making this? I want to see the outtakes. I need to see the outtakes. I desperately need to see the outtakes. Oh no, Kurt. You can see the change in color on his skin from the hot sauce.
Allows the blade to really sort of do its work. Softens up all of those.
Yep. See, I told you. No, you can see the I've seen that hot sauce too. That's exactly what that looks like. Either he found an identical oil that looks just like that hot sauce, or he really rubbed it on his face.
All of those little beard hairs and so forth. So that's what we'll do. Now, because it's an oil, it gets on your hands. So we'll just have to give that a little rest.
Not on your face.
Okay, now, once you've got that there, you sort of let it sit for a bit. And then I'm going to use my sort of favorite shaving implement, which is this. This is a sort of broadsword. It's got a moose bone handle, and so yeah, that's how we're going to shave here. The other really great thing about using the pepper oil there as a shaving oil is that it really helps you find any of the little spots that you where you may have nicked yourself. Because then you can use then you can just zap them with this thing to sort of stop the bleeding. It's an alum stick. I did pretty well. I'm not feeling any places where I cut myself, but so that's a good thing. Also helps train you to really make sure that you are doing a careful job. Now, that's not sort of the end of my skincare routine. You've just, got to shave. So might as well carry on and just do some things to help yourself look great. So I like to apply a little bit of this. This is just whiskey. It's a Japanese whiskey. You don't have to use Japanese whiskey. Scotch is great. Any of those. If you're in a pinch, you can use something like Jack Daniels, but really you want to use something a little nicer if you can. So you just
whiskey,
brush that on there. Now you're going to want to leave that for a minute, and then you want to rinse it off. And the reason why is because if you don't, people at the courthouse or on the bus or wherever, they start getting really judgy, and you don't need that in your life. So we'll just leave that for a little moment, and then we'll just rinse that right off because, as I said, you just don't need people making that kind of judgment. It is what it is. People can be judgy. So we'll just
like when you put hot sauce,
clear that up a little bit.
In your face.
All right. So make sure you put the cap back on it because this stuff is you don't want to waste it. I also like to at this point, usually I'm sort of running out of energy a bit.
No,
so
it's a
I'll
group
take another
intervention.
shot of hot sauce. This is the last dab from the hot.
All right, what this man is about to do. I have had this hot sauce. I have a very, very high heat tolerance for hot sauces. If you don't believe me, I did the Hot Wings challenge, Hot Ones challenge on Ian's stream. What Ian is about to do is to literally take the last dab, which is the hottest of hot sauces. Well, I'm just gonna let you watch it, and then we're gonna stop because I'm gonna let you guys go back and watch the end of it. And as I'm doing that, I'm gonna go ahead and put the link to that video in the description of this one because I need people to see this because Ian wins the internet for this video right now. He just does. Let's see. Get ready with Runkle. Where was it? Get ready with. I'm adding the description right now. Video link. Because Ian, no. Bad Ian. Let me just find that link again. All right. While I'm doing that, just observe this person.
Hot ones, it's the hottest sauce on their thing, so it's pretty good for helping give you that little bit more energy in the morning. If you want, you can take a second. There you go. This stuff is also great if you just want to apply a little bit of that. So we'll just put that on. Let it sit for a bit. And again, you're going to want to let it sit for a moment and then rinse it off. So we'll just...
No. That hot sauce is debilitating. I know that even Ian, after doing that, moved expeditiously from that bathroom and was hurting. But yeah, so that's getting ready with me, the firearms lawyer edition. So here's the fun thought experiment. What would we do? The woodworking attorney. So I have some ideas. I think that the woodworking attorney shaves with a chisel, because I could probably actually pull that off. Not that I have to shave too much. I would trim my beard with, would I trim my beard with a hatchet? Or do we shave with a hatchet? I don't know. Or trim my beard with a pull saw. Just trim it. I don't know. But this gave me so many ideas. Where was he? I thought the videos didn't allow videos of self-harm. He didn't look in pain. But I'm thinking I can use a Japanese pull saw to trim the beard. We can shave with a chisel or a hand plane blade. We can sharpen it up too. And that's how we start our mornings, is by sharpening our chisels, and we shave with that blade. And then, we use some shellac to, do up the hair and get that up and going. I've got ideas. So if this is the way that we're taking these getting ready with me videos, I'm half tempted. Maybe not brush my teeth with a drill, but I do have wire brushes that I use in the shop. Wood oil is beard oil. I mean, Lindsay, it's possible. I don't know how it would work, because a lot of those have drying agents. I guess I could just use a plain mineral oil. That would look really weird, though. Japanese saw, mini plane, whiskey, glitter. The glitter we already get. No wire brushes, Emily? Why not? I'm not going to really brush my teeth with it, I don't think. I could, you know what? I could make a comb, like literally make a comb and use that comb that I just made. That would be fun. Wake up in the morning, make a comb, and comb your hair with the comb you made. Laura Liani, Japanese saw, mini planer, whiskey, glitter. The glitter we already have from the different mica powders that go into the different resin blanks. Oh yeah, Emily, if you didn't see these already, the pens that I'm turning now, that's the most recent set of blanks. So new pens, be fun. But we've got the glitter. Oh no. I could use resin to... No, that's just a terrible idea. If I used resin, practice my closing arguments to the robot jury. Yep, I could do that. That's fun. These are fun ideas. Kristen M96, thank you for that one. Kara Savage, no, you need the glitter lipstick from Girardi. Go full unicorn with it. My word. That's the unicorn lip. No, I'd probably have to use what, Emily, what are the ones that you use now from Jen Girard? Objection is one of them, or something like that. So, I mean, that's always possible. Wood shavings as exfoliant. I mean, yeah, it's possible. I mean, the possibilities are endless with ADD. Yes. Yes. I am now down this rabbit hole. And this is what Ian did. This is what drives me nuts. This is what he did. This was an ADHD task for him. And the thing is, I never should have seen this. I should have somehow prevented my brain from seeing the fact that this existed on the internet. Because that's what my brain is doing right now. And now I am so lost and confused. But yeah, Ian, I need to know how bad that hot sauce actually hurt when it hit your face. And I know that some of that pepper got up in your eye. But yeah, unicorn onesie, or it's all for naught. It's probably what I'd wake up in, because I do have the unicorn. I have so many cufflinks. Cufflinks are a thing for me. I actually have different ones that mean different things, and I have lucky ones that I wear on certain days of court. Makeup and the unicorn onesie. My word, you guys are of the same mind. It is wild. Thank you, Brentwood Chic, for that. Glue as hair gel. Nope, that sounds awful. So does the epoxy as hair gel. Unicorn PJs, tongue oil. My gosh, see, this is the chaos that I expect. Send you my collab. Yep, I need the objection lip with the mirror and the thing. We can do it. If you're going to do it, go all in, I guess, right? Sanding block to exfoliate. We could do that. That probably wouldn't feel too well. But now my brain is in the world of, what does a woodworking attorney do when they wake up in the morning, and how funny can we make this video? The possibilities are endless. The possibilities are absolutely endless. Beeswax works for cutting boards too. It's food safe. See, the thing is that the stuff that I put on my face is far less harmful than the stuff that he did for his. But you know what? That's our friend. That's our friend. Please go check that video out. It just gets better. It really did. It just gets better. Dry shampoo is sawdust. Didn't they say that dry shampoo is bad now or something like that? Why did I see that in the news at some point in time? Also, Shein is getting sued. They're facing a big lawsuit right now. So when that gets rolling out, to pull that up. Nanner, can you impose Ian's face in your bathroom mirror at the end? I don't know. I don't know if that's possible or how I would do it. Maybe. I'm going to say maybe. I don't know. Torin 3, 2 weeks until I can start your braids, streaming occasionally from Pensick until then. Hope EDB liked the purple, yellow, white tortoise braid that you made. Torin, that is very kind of you. Thank you, my friend. I'm sure that she did. You do some amazing work. If you guys haven't seen what these braiding things look like, they're really cool. Check out Torin 3 on YouTube. Really cool channel. He walks you through how he makes these braids. And I love creative people and seeing everything they can do. It's really fun. Kind of like this exploratory thing that we're thinking of. Shein clothing is fast fashion. I don't know if it's pronounced Shein, Shine. They're being sued. But yeah, fast fashion, super cheap. Anyways, what do we say that we don't actually start talking about some law stuff? Oh no. Let's end the poll. End the poll. The cereal poll. Do you guys mix your cereals or no? The two options were mixing cereals is the only way. The other option was blasphemy. I am a cereal purist. And right now, with 1,188 votes in, this poll is shaping up. I didn't expect this. I thought there was going to be more. Q-tips make great, or drill bits make great Q-tips. Said no one, but I can see in a pun that might actually work. So it's possible. Yeah. Now my brain is all over the course. Scrambled eggs with the drill. Use the shark board for breakfast. See, Ian started something. And I feel like it's only going to get worse. So, yeah, Lori Leanne, thank you for that one. This is now a competition. This is now a competition. I didn't know I needed it, but I do. I did. So ending the poll about the cereal, you guys mixing cereal or cereal purists, I am disappointed because I mixed cereals as a kid, and that was the only way I knew how to do it. But out of the 1,200 of you that voted, 72% of you said that it was blasphemy to mix your cereals, that you are cereal purists. 27% of you said that mixing cereals was the only way to go. I am disappointed. I'm disappointed. Anyways, why don't we start talking about some law? Swoop got me to start therapy, so I have to grift for her. She did a great documentary about Sheehan. Oh, I didn't know that. Okay. Cora Savage, check out Swoop and the documentary that she did on Sheehan. Interesting. I also want to take a look at that lawsuit because I wonder how they're going to do with that one. Anyways, let's go ahead and do a quick swoop to our first topic of the evening. I know it's only 46 minutes in because, reasons, but swoop. And new swoop. I still like new swoop. I'm still a new swoop fan. So the first one that I wanted to cover this evening was, do I want to do Coburger first? I didn't think about this. I didn't think this through because I wasted the poll. We're going to do a quick one real quick. First topic, you guys got to help me. Got to help me. Coburger. SBF. Naughty. Jail possible. SBF charges drop. SBF campaign finance charges. Sarah Boone letter. I don't know if we spell indictment. Or call it MOT to dismiss. We're just going to call it MTD. MTD indictment. We're going to do a quick one. And we'll catch up on some super chats while that's pending. Schabusiness. You guys really want to see Schabusiness again? Oh, no. Well, I want to do a recap of that one. That's going to be a quick recap. And we're going to do that a little bit later in the evening because I need to get through some actual substantive law stuff first. Becky G, wood shavings and coffee make instead of grounds. Ooh, I like that idea. That's a good one. Diane Titcher, thank you. Please don't hurt yourself. It's not worth it. I won't. I actually am very careful about this kind of stuff. Very careful. Despite what my chat likes to say. Opposite of amnesia, you have to include a nod to the broken bed video. Oh, that just got even more interesting. Is anyone taking notes of this? There's been too many comments to even think about. I'm gonna have to think about this again. We might talk through this on a members only. Sin N. You should play a short clip of Cusack and let the chat decide. That would get me a copyright hit faster than you can imagine. It's going to be interesting. Razam, glad to see you're here. Hey, Rob, how you doing? Now I need to rewatch John Cusack's 1408, one of my favorite movies. John Cusack has a lot of good movies that I think are very, very underrated. I always enjoyed him. Either way, I'm now going to be perplexed as to whether I do or do not sound like John Cusack. Diane Tincher, thank you for the super chat. I find it refreshing to have a trial begin and end in 1 week, even if it was a horrific nightmare of a trial. It actually was indeed a horrific nightmare of a trial. So let's see what we've got as far as the poll is concerned, because we actually went real quick. SBF's going to lead the naughty words. It might not. We'll see. All right. So we're going to let the votes go for another 60 seconds. And I'm with you guys on the Schabusiness stuff. So Taylor Schabusiness, we'll just do a brief recap. We'll do a description of the recap. So Taylor Schabusiness went to trial today this week in Wisconsin. She was adjudicated. Final adjudication hearing held her competent to stand trial on Friday of last week. That was the date for that final adjudication. There had been debates along the way as to whether she was or was not deemed competent to stand trial. The charges that were brought against Taylor Schabusiness was first-degree murder, so essentially first-degree homicide, intentional killing of another person. Then there was dismemberment / mutilation of a corpse for the purpose and with the intention of disposing of evidence or concealing the evidence of the crime. And then there was the third-degree sexual assault. The allegations occurred in that order. So first there was the actual intentional homicide allegation, which was an allegation that Taylor Schabusiness on the night of February 22nd, leading into the 23rd of 2022, was engaged in what began arguably as a consensual sexual encounter with a certain Shad. Why am I forgetting his last name? Shad. I remember the first name because it was so easy to remember. I'm not going to look this up either. I'm not going to cheat. Therian. That's right. Yeah, Shad Therian. So what began as, we can assume, arguably it was a sexual encounter involving chain choke collars of the type that you would see around a larger dog's neck, resulted in Taylor Schabusiness being on top of Shad Therian while he was stomach down on a mattress in the basement of Shad Therian's mother's home. Mother and mother's boyfriend were upstairs, though they did not hear anything throughout the evening except for footsteps coming up and down the steps. Shad's younger sister was also inside the home. Shad's younger sister, I believe, was 16 at the time, also did not hear anything. Taylor Schabusiness, what began as perhaps a consensual sexual encounter, actually resulted in Taylor Schabusiness strangling Shad, and he did not survive that particular encounter. Taylor Schabusiness then went upstairs into the kitchen and began grabbing knives. And in grabbing those knives had one specific intention, and that was to essentially dismember the body. The head was the first thing to go, but after the head was removed, she then engaged in some rather inappropriate behavior with the body while it was still there on the bed. Now, this might seem very, very, very deranged. And in fact, it is very deranged. It is a disturbed mind killing. It really is really, really, really bad. But Taylor Schabusiness's attorneys challenged that she was not competent to stand trial. Now, competence to stand trial is an interesting legal standard. It's very different than what we would assume or we would equate with being competent or mentally sane. Essentially, if you can engage in a conversation with your attorney, if you can understand what's going on around you, you are competent to stand trial. Taylor Schabusiness clearly understood what was going on around her. Actually, in the last competency hearing, Taylor Schabusiness's attorney from the public defender's office turns to Taylor Schabusiness and says, "I've consulted with my client and she has said." That's pretty much indication that your client's competent to stand trial. She can participate meaningfully in her defense. So that took place on Friday after several evaluations. There were two court-appointed evaluators. One was to evaluate competency. The other one was to evaluate whether there was NGI eligible or on the table. NGI is after adjudication of guilt. NGI can basically say that person, while guilty of committing the crime itself, actually having physically done the actions that involved, is not guilty by reason of insanity. They were not able to comprehend that what they were doing was unlawful, and they were not able to conform their actions to law or to what would be lawful actions. So that competency hearing went forward on Friday, and then on Monday we began the trial. The trial began in earnest, and I mean, this judge in Wisconsin, I love this judge. This judge is fantastic. The trial was scheduled to go for 4 total days. It went 4 total days, both phases. Wisconsin bifurcates their trials when you have issues of not guilty by reason of insanity. So first is the adjudication phase, the guilt phase, whether or not the action took place and whether the state can prove that the actions took place with the requisite degree of intent. So the state puts on their evidence, 3 total days of evidence back and forth. That includes jury selection. It includes opening statements, all prosecuting and defense witnesses in those 3 days. The judge moved things along speedily, but also fairly. Didn't cut anyone off, let them plead their case, let them demonstrate their case. They did a good job, both sides. The prosecution I found to be remarkably competent. They didn't extend well beyond their grasp. They stayed within the bounds of the law. The defense attorney really didn't have much to work with because Taylor Schabusiness engaged in several post-arrest interviews voluntarily after being read her Miranda warnings, laying out the specific details of what she had done that evening that involved dismemberment, taking different parts of the body, placing them into boxes, in different containers, removing them from the household, and then, darn it, she forgot the head. She actually said that. She forgot the head with a look of surprise in the interviews. The interviews, well, at least 90 minutes of the over 5 hours of interviews. Why are you talking to the cops? 90 minutes of that interview was played for the jury. And after you watched that interview, there was no question left remaining as to whether this person did or did not do the thing. The level of descriptions that were given, including the location of where everything was within the home and outside of the home, the acts that were engaged in to result in those body parts being located, how certain elements of the body were disposed of, namely the blood in the basement, because there wasn't a whole lot to be found. All of those things were described in tremendous detail by Ms. Schabusiness voluntarily to the police officers that arrested her, including certain sexual activities that, well, if you're going to be a criminal defense attorney, you need to be able to say these things out loud. And this criminal defense attorney had an issue doing that. Prosecutor didn't. Prosecutor did fine. A dildo was used inappropriately with the corpse on several occasions. And Taylor Schabusiness took breaks in between dismembering to take a nap because she became tired, thought that the arm grew back in between the nap periods, continued to cut away, went through, I think, 6 or 7 knives, ended up with some lacerations on her hands and some blood on herself, cuddled with the body in the interim, performed fellatio to the body, and ultimately, with the head that was in the bucket, added the victim Chad Therian's, his twig and berries were added to that bucket. And she forgot the bucket, left it behind. Very, very disturbing facts. Very disturbing indeed. These are the things that happen sometimes. Apparently, I didn't know that. Prosecution was able to put on evidence that Ms. Schabusiness had searched for, made several searches on her phone. That was the one part I was kind of uncomfortable with. Was the searches for Jeffrey Dahmer that were allowed to be introduced. It wasn't just the searches. It was a lot of the videos or pictures, memes, etc., that were included, that the prosecution was allowed to include in that. The judge deemed to be relevant. I don't think the judge is off on that determination. I think it was a bit excessive. But the jury was able to see all the different searches that were on the phone. Danielle, I do see your comment in the chat, and I actually don't know that I agree with this. Nick Ricada suggested she was overcharged with murder 1, should be murder 2. The thing is, Nick's determination, I did watch that. Nick was curious because the state had charged her with intentional homicide. And he said that she lacked the intent to commit the homicide because it began as a consensual activity. And the homicide was an accident instead. However, that depends on what you are deeming intent. I think when Nick said that, he mistook intent as we commonly think about it. That I didn't mean for this to happen as the legal burden for intentional homicides. Intentional homicides don't actually have to be with a malicious mind. You don't have to physically intend to commit that murder in that instance. There can be circumstances that would lead to suggest that you knew and did it. And that the act in that moment. What he said, the reckless. I thought Wisconsin's reckless statute was a little bit more flexible. In either regard, her own interview, she said that she originally did not want to kill him, but knew that what she was doing was killing him and continued to engage in that behavior. That is not just a reckless disregard for something that might kill somebody. That is knowing that what you are doing is killing them and continuing to engage in that behavior. That is intent. That's intent. When you know that what you are doing, not just a disregard for what might, but when you know that what you're doing is killing somebody and you continue to engage in that behavior, that is intent. So I don't know that they overcharged it. The third-degree sexual assault charge they tried to throw out because of the order of events that transpired. And you know what? If you're a defense attorney and you have to make this motion, and I will tell you, you have to make these motions. If that motion is available to you, you are required, you are ethically bound in zealous advocacy for your client to make that motion if it is available to them. If there is a motion that you can make up or that you can make that says that you could not commit sexual assault because the person was not a person at the time the assault was committed, because the person had predeceased the assault, that you could not be charged and convicted of sexual assault of an individual. I thought that motion on legal merits alone had some legs to it. I just realized what I said. Don't take it that way. I mean, that motion had a little bit of weight behind it. I think that there was a way of reading that motion that made sense. It just felt really creepy when you read it. That motion was denied. Taylor Schabusiness on day 3 of the trial was convicted of all 3 charges, then proceeded to the NGI phase of the trial. Same jury. They just don't have to return a unanimous verdict. They have to return 10 out of 12. So 5/6. Yes, 5/6, 10 out of 12 by state statute. Civil, you know, who didn't have legs? Who didn't have legs, Kurt? I don't know if I want to hear the answer to this one, but I'm going to ask it anyways. Yeah, Julia, I see you here. Nick gave a better fake close. Her attorney struggled, and we'll get to that in a second. The NGI phase of the trial was essentially a last-ditch effort to basically say that while you have adjudicated my client guilty because she did the things, she should be found not culpable, meaning that she did the things, but she should not be held criminally responsible for doing the things because she wasn't able to form the requisite intent. So it's essentially attacking the mens rea of the crime itself, the mental element of the crime. She couldn't form the intent because her mind could not process and conform to societal norms or to the law the way that they end up playing out. I'm sorry, I'm reading the chat. Do we define murder one or two another? Yeah, I see that. Talking about leaving the gun versus beating someone to death. I'll have to look at that again. But I really think the state appropriately charged that the state-appointed attorney for the defense. I'm not going to look at the chat for a moment because I need to finish this while my brain is still processing. There really wasn't a whole lot. Out of the doctors that had evaluated Ms. Schabusiness, I believe there were 4 total evaluations, if not 5. There was one doctor who was hired by the defense that found that she should not be held culpable for these actions. And the doctor's methodology in this was basically, if I were to summarize, I met with them. They behaved weird compared to the other people I have met with. I'm a PhD, said 9 million times. And based on that meeting, this person is, and I believe that she actually used the word insane. I don't think she gave a formal diagnosis, although she embraced one in her report, but she really didn't offer a formal diagnosis, just said the person was insane. It was weird. Then the prosecution gets up because the burden of proof in the NGI phase is on the defense because you've already been proven guilty of having done the thing. Now you are asking for affirmative relief from the court, which means that you have the obligation to prove that you should be entitled to that relief. So the defense gets up, and the defense, this time the state, that was confusing. Defense presents their expert witness. We're going to keep the names the same. The prosecution gets up and says, here are the other experts, both of whom were court appointed to perform these evaluations. One was on competency, the other was on NGI. Those experts came up and testified about as beautifully as any psychotherapist I've ever seen testify in expert capacity. And just, I've never seen such a clear decimation of a case. I mean, this was worse than Dr. Muffins destroying Dr. Spiegel and Dr. whatever her name was. This was worse than that because the defense's expert gets up and literally says, I met with him a couple times, She threw a chair at me. No one's ever done that. She's insane. Literally. It was wild. I don't think I've ever seen a witness do that. And the worst was she walked directly into every single argument and got combative and argumentative and defensive. The last thing you want is when your expert is on the stand, they're going to be cross-examined, but you don't want them fighting and saying, I'm a doctor, I know better. That's what this doctor came across as. The prosecution then just laid that entire defense to waste, methodically, eloquently, succinctly. I mean, it was a class in how you elicit expert testimony. Jury was out for, I think, 51 minutes, 52 minutes, something to that effect, and came back. And rather than, just meeting the 10 out of 12 burden they needed, they came back unanimous in deeming that Taylor Schabusiness was not eligible for an NGI disposition, that she was, in fact, sane and was and must be held to account for her actions, not going to a mental facility and instead going to jail, where she will still get treatment, but incarceration. The entire trial lasted, as the judge promised, 4 days. It was the way that I am used to seeing trials done, the way that trials should be done, not these 6 or 7 week trials, and we're arguing about things that aren't relevant or aren't there. And yeah, the defense counsel by the end of it just felt beat up, and he looked beat up, and he looked tired. And this was something that had me feeling for that defense counsel for a bit, because you don't get to choose what facts you have to argue as a defense attorney. And once you are appointed to represent that client, your ethical obligation is to make every step in furtherance of that client's interests, which is to be freed. That defense attorney did the best they could with what he had. I think that his heart wasn't in it. I think he didn't believe the arguments he was making, and that came through. And that sucks. It sucks, because that was my one criticism of that defense attorney. And it's a criticism that is going to have multiple facets to it. That closing sucked. The questioning sucked. It was every element of his litigation, every element of his examination of witnesses, his arguments. They felt so half-assed. And I can understand why. It was a heinous crime. It really was a heinous crime. And the person that you're sitting next to, who, by the way, assaulted her prior defense counsel, which is why this was new defense counsel, the person you're sitting next to just, well, if there were ever someone who I didn't think was eligible for NGI, Ms. Schabusiness, based on her behavior and demeanor in those, and I'm not diagnosing, based on her behavior and demeanor in the post-arrest interviews, the methodical and analytical method that she described what was happening in that night, it was messed up. It was messed up. The defense did what they could with the facts that they had, but you could tell that he didn't want to be there. And the problem is that if you can tell he didn't want to be there, the jury can tell he didn't want to be there. And it's just a challenge that all defense attorneys face. It's hard. It's hard. So, yep. That's my take on the Schabusiness case. It was 4 days of, well, that interview, man, I can't. And people wonder how attorneys can acquire a rather dark sense of humor, or where our jokes might come across as inappropriate, or how officers might acquire a dark sense of humor. If you watch that interview, imagine that as one interview of several that you have watched throughout your career or participated in throughout your career. And let's give a little grace to some of those people that have to sit there and watch that over and over and over again. And people are asking, can she claim ineffective assistance of counsel? Nope. Ineffective assistance of counsel is a very high standard. What was it? I forget when the case was, but there was an attorney who was falling asleep at counsel's table and had to be kicked awake by the bailiff on several occasions. That was still not ineffective assistance of counsel because the attorney asked a few questions. This attorney asked questions of every single witness, presented the arguments, the motion alone trying to dismiss that sexual assault charge, and all of the arguments made. It is not ineffective assistance. There's no chance at that argument being successful. I mean, I don't mean no chance because there's always like a 0.001 no matter what case we're talking about, but no, that's not ineffective. That was good. Yeah, I see people ineffective. You can sleep through the trial. It's not enough. Yep. There are attorneys who have shown up drunk to trial and it wasn't deemed ineffective assistance because they asked questions or they appeared attentive to the jury and made arguments. So no, this is not getting set aside on ineffective assistance of counsel. And yeah, I see it, Emily, and I see you, Kurt. It's not happening. I agree, Kurt. And Emily, he did his job with what he had. He did. Tough job. And he didn't want to be there. He's got other cases he has to deal with. And now he has to cooperate with the pre-sentencing report. So they're going to do a PSI, pre-sentencing investigation, and they'll put together a report. That report is going to be due in to the court 2 weeks before sentencing. From my understanding of Wisconsin law, this is an automatic LWOP, life without possibility of parole, based on the charges and the fact that she had priors. So sentencing is not going to be anything to really be interested about, with one exception. One exception. The one exception on the sentencing issue is that Taylor Schabusiness has the right to speak. And having already been found guilty, and with the understanding that, that's already the ball game, is she gonna make a statement? I don't know. Victim impact statements are going to be there. If she does make a statement, this is going to be pretty fascinating, because I don't know. Emily, I see there was a court TV interview with defense counsel. Let's see if they actually have that. That's the interrogation. There's the verdict reached. Oh, they did. They spoke to Chanley. How long is this interview? It's 11 minutes. You guys want to watch a bit of it and see how the defense counsel did? We can watch some of it. Let me see. All right. We'll check in with Chanley and see what's going on. We're going to watch some of this. Share the screen. Screen shared. So let's see what our defense counsel has to say. Everyone wave to Chanley. Say hi.
Joining me this morning is the defense attorney for Taylor Schabusiness, Christopher Freilich. Thank you so much, Chris, for being with me. I want to first begin with your reaction to not one, but two unanimous verdicts this week against your client, one for the murder of Shad Therian, and then also denying and rejecting the fact that she suffered from a mental disease or defect at the time.
Yes, good morning. Obviously, we presented our best case. We had defense experts, forensic psychologist provide some testimony, but at the end of the day, the jury made their decision, entered their verdict that found her not to have a mental disease or mental defect.
What was your client's reaction to the verdicts?
I think she was really, I don't know if she necessarily understood what was going on. I think she was suffering from some mental health issues, some impairment, and the plan is to go and talk with her today to fully discuss what happened at trial.
I get that you're preserving the defense on appeal. I'm going to chalk it up to that. He's preserving the defense on appeal. He doesn't want to say anything that would put that at risk. Because she clearly understood what was going on during that trial. And I don't, she responded to different remarks in a very appropriate manner. I mean that it was clear by her response that she comprehended what was being said and the gravity of what was being said. And she would nod, gesture, react. She would lean over to her attorney and speak at instances. So I think she knew what was going on. Maybe her muted response was the fact that she had a stun band wrapped around her chest. Yes, there was a stun band around her chest. So
I do know that you had a competency hearing right before the trial started. You were hoping to show the jury that she was not competent to stand trial. Were you able to effectively communicate with her through the process this week?
yeah.
Yes, I was. I was able to talk with her.
There it goes.
As you saw during the trial, she didn't write notes, although she was able to interact with me. I think that she's a young lady that has many problems, many mental health challenges, and that's difficult.
I do know that when the judge wanted to inquire of her right to testify or to waive her right to testify, you asked the judge to include an extra inquiry about her being pressured to or not to testify. Was that just out of precaution, or was there some other reason as to why you wanted to have that included?
It's usually standard. I was surprised
that's kind
the
of
judge
a standard
didn't include
practice
it.
to make sure that.
Yeah, I was surprised the judge didn't include that. Are you under duress, or has anyone pressured you or coerced you to make this disposition? I was surprised the judge didn't ask that directly, and I thought it was a good follow-up. It meant that he was actually listening along. But Chanley's asking tough questions, man. If you're defense counsel and you got to appeal this thing, I mean, do you acknowledge that she was competent? When you engage in the colloquy of whether she understood that she had the right to testify or not to testify, did she seem to understand what she was being told? Whew.
That the defendant, the client, doesn't feel that they're pressured to make a decision either way, that it's their choice. So I felt that might be a good colloquy for the judge to have with Miss Schabusiness, and the judge did that.
Now, viewers, we were only able to see her on camera in the courtroom. And of course, I was able to see her in person being inside the courtroom yesterday. But what more can you tell us about Taylor Schabusiness from working with her?
Well, I could tell you that she's had a difficult life. I think she's got drug addiction issues. She's got underlying deep-seated mental health problems. She has family of origin issues, dealing with some abuse. She was involved in an abusive marriage where her husband hit her in the head. So she has many challenges that will have to be sorted through, and we're looking forward to the sentencing hearing in September to address some of these issues with the court for the court's consideration in determining what kind of sentence she is to receive.
Indeed. And of course, we were able to see which your expert did address some of her reactions inside the courtroom, laughing at times, smirking, staring at the camera, and in previous hearings even attacked her former defense attorney. Were you ever worried of that, first of all? And what do you make of her reactions and odd behavior inside the courtroom?
Some of those behaviors
There we go. That is not the present attorney on the screen. That is her former counsel. Let's go ahead and catch that one again.
Behavior inside the courtroom.
Some of those behaviors I thought were bizarre and odd. No, I was never concerned about any issues with regards to my safety. I think that if, as a lawyer, if you have a good rapport with your client, communicate with your client, and the client knows that you're doing everything you possibly can, then you build trust. So that's kind of the perspective that I took in the case. I did watch the video where she had that apparent incident with prior counsel, but it didn't even wasn't a consideration in my case. In my representation, I wasn't.
Yeah, I was in there. Ooh, that's so interesting. Last night, when the verdict was read, she was flanked by 2 deputies who did not take their eyes off of her just in case she made a movement. She was not handcuffed. And you mentioned some of the video that you've seen. We witnessed a video of her what looked like
Not handcuffed, but a stun belt around the chest is that's your next best option.
she was making like a gun or pulling a trigger on a gun inside the courtroom when the judge was speaking. Did you notice that at all?
That's an interesting question. During the trial, I didn't notice it. I know that I would look over periodically at my client frequently, but I did not see that. But later on, I did see that on the video. It's hard to decipher what that was, who that was intended for. So that's my comment on that.
This had to have been a difficult case for you. It's probably one of the most graphic trials that we've covered at Court TV with all the gory details. As an attorney, how did you prepare in representing her in that way and for your own mental health?
Yes, well, I've been a lawyer for 33 years. I've handled
Seen a lot.
homicide trials in Sheboygan County and have other matters, handled lots of trials. This was by far one of the most graphic, complex, and difficult cases I've ever been involved in. From the graphic, gruesome photographs to the motions that I filed lots of different motions addressing many different legal issues. So I started right out of the gate with attacking some of those problems that I saw that I outlined in my motions. And I essentially worked on the case every single day.
So I appreciate that we can have a discussion about this, but in the chat, we're not going to diagnose people one way or the other. We can comment on their behavior, but we're not going to get into the realm of diagnoses. That's just not a place that we're going to go. Mental health issues are remarkably complex. I would say that anyone watching this trial knows that there is something that it needs to be explored, but jury found their finding. And then 2 quick questions. The peripheral. Someone made a comment about whether the peripheral, he would have picked that up, the hand gesture. No, when you're an attorney and you're in that room, when you're looking at your notepad and you're focused on testimony, you block everything else out. And then Julia 543, I see the comment you made. Is it a rumor? Nope, that was real. That was there. It was on. She had a shock belt around her chest. She adjusted it quite. You could see her adjusting it, and it was actually confirmed. So it was there. Not the easiest kind of case to handle here. Just a few more minutes, guys.
Got my materials organized into binders, read all of the reports, organized the reports, got experts involved. I know that at least for a motion hearing, we had a pharmacologist and conferred with him because of the fact that, methamphetamine use was prevalent in this case. Also conferred and consulted with a forensic psychologist because I knew that mental health issues were very prevalent in this case, and then just had numerous conferences and meetings with my client and prepared for trial. And that's what we did. We put on our best case. We did the best job we could. We vigorously fought for justice and for her rights and advanced our legal position at trial.
You did mention the pharmacologist, James O'Donnell, I believe is who you're referring to, and the judge offered you a chance for a Dauber
I know,
hearing
that was weird.
to assess the admissibility of his testimony, and that was something that you did not choose to have. Tell us more about that decision, and do you regret not pursuing that?
Good question. I had the same one.
No, we initially had Dr. O'Donnell, James T. O'Donnell from Illinois, hired as a defense expert, and he testified at the earlier motion hearing, I believe in June, with regards to drug usage and how that would impact consent to waive Miranda rights, consent to submit to DNA, consent for other issues. And then at the trial, there were some...
Wait, so you used him for pretrial motions in limine, trying to exclude parts of the interview. But here's the question. When they submitted a report, when they did their review, did they extend that expert diagnosis or finding further to go back in time to the moment that the incident occurred? Because basically, if you have an expert that's arguing that the person, in their expert opinion, based on your review of the interview, the tapes, and everything that took place, was not capable of forming the requisite mental state to consent to the interview or to knowingly waive those rights, that does not then follow that a day earlier, they didn't have the capacity to conform themselves to behaviors that are acceptable under the law. They're different things. There's a distinction. So now I can start to see why the judge had issues or had original concerns about this witness testifying. But he gave him an opportunity, to put him on and try to make the argument. He just waived the argument.
There were some areas of opinion that he was not able to necessarily opine or give opinions on because, he's a pharmacologist. And so a lot of the information that we were able to provide was bore out through the forensic psychologist. So because of the court's colloquy and based on our own analysis, we knew that voluntary intoxication was not a defense. And so ultimately we decided not to call him as a witness at the trial because we also had
what is next
Dr. Lighton who
go ahead.
We had Dr. Lighton to testify on.
All right. That kind of wraps us up there. We know what he's going to say next. You know what? Very, very, very standard, not surprising press conference given after the fact. I think that press conference tracks 95% of most press conferences after a attorney has lost a case. He's in an uncomfortable position. He can't really say too much. You still have possible appeal issues. You've got to go forward on those. Just what a disaster of a case. What a disaster of a case. And, well, quick justice. 4-day trial, guilty, not, guilty and culpable in 4 days. So Monday through Thursday, and we're good. Okay, so based on the current poll that we've got, where do we go next? Let's see here. We go from this topic to the Coburger indictment. Interesting. Let me do, yeah, we can do that because we're talking about felony trials. And we're going to learn some history, please. Do you want a cleanser? Laura, you want a cleanser? We're not going to do a Wingstop cleanser, but we can do a cleanser. We can do a different topic cleanser. We're going to swoop to a different cleanser, and we're going to talk about whether a certain behavior, well, we're going to talk about whether someone's going to be liable for something. Because WWLTV, where is WWLTV located? Well, we're going to find out. I stumbled across a story that had me asking all sorts of legal questions. A
man in the CBD sets a booby trap inside his truck after he was broken into 8 times in just 3 months. Good evening, everyone, and thanks for joining us. I'm Sheree Skips.
Okay, so can we decide what the legal issue is that we're going to be discussing here? A man sets a booby trap inside of his truck that has been broken into several occasions in the past few months. What type of booby trap? And is there liability? And how do we feel about it? Because, yeah, is this New Orleans? Either way, this is some, yeah. What's a booby trap? A booby trap is essentially something that's going to go off or something that's going to trap the idiot that's deciding to do the thing. It's the F around and find out of self-protecting property, basically. Walk over top of a board, the board's loose and you fall down.
And I'm Katie Moore. Thanks for watching tonight. The video of what happened to that would-be thief has been watched thousands of times across New Orleans. And in tonight's top story, Devin Barlotta speaks with the man who set the trap.
There's still glass on Constant Street where Sunday morning Brendan Batt found the broken remains of his pickup truck window.
There's nothing you can do about it.
Again.
6 in the past 2 months, 8 since January.
This time the cameras positioned outside his apartment building showed this.
6 times. Your truck has been broken into 6 times in the past 2 months, 8 since January. Are you kidding me? I would think of something too.
A white car pulls up beside Batt's truck. A person gets out, bashes in Batt's driver's seat window, hops in, and then shortly after,
just ruins my property, and then something happens to him that he didn't like.
A flashbang rigged up on a tripwire in the truck explodes in the would-be thief's face and scares him off.
It's not pleasant.
Yep. You heard that right. A flashbang. So that would-be thief isn't going to be hearing anything. Oh, no. No. That's not what that is. A flashbang is not just a big flash. A flashbang is essentially, it's an explosive. It just doesn't have projectiles. So
pleasant for this device to go off like near your face or near your body.
It's a 12-gauge round with no projectile, but it does shoot gunpowder and is very loud. Batt has been unapologetic 2 months.
Because I don't want to walk out to a broken window and not have it detonate.
Batt, who is a veterinarian in Metairie, says he did test runs with the device to make sure no one would be severely injured and doesn't encourage.
How does one test drive or do a test run on a flashbang inside their car? Why does one do the test run? Well, several reasons why one does a test run on a flashbang when you put it inside the car, to make sure that it doesn't actually do something lethal or cause serious bodily harm. But yeah. Okay.
Encourage others to set them up. But he does encourage security cameras. He believes this video and its viral spread will bring this person to justice.
I back the blue. I'm a proud supporter of the NOPD. And, you know, they put this whole case together and they're going to get this guy. And that's something that doesn't always happen. But everyone can set up a camera and everyone can kind of defend their own property in that way.
He says, though, he's not stopping and will be setting up his tripwire until further notice.
It's that little bit of
Well, now we have reached like the legal question, because there's two parts of this that are F around and find out. One, the ingenuity. Sir, a flashbang that you tested and configured to go off when your car was being broken into. Very, very smart. Well, rather, you thought through that as far as the engineering is concerned. And I wonder if you have military experience, because my mind thinks that you might, especially because you kind of knew the ordinance, what to use with it, what it would do, the potential lethality of it. I mean, it's creative, and it sets up the lovely little F around and find out with regard to breaking into property. But as you guys know, you can't, well, wait, there's an exception. Texas, I think you can use lethal force to defend property, but I do believe that at least in most states, you cannot use lethal or deadly force to defend property. But would that be lethal or deadly force? I don't know. If it went haywire, if it went sideways, I don't know. Innovative is the word. Thank you, Lynn. That's very, very, yes, innovative. We're going to go with innovative. Very innovative solution. Innovative. And Nikki Crayons, I see you guys. Very good. So for those of you who don't know what a flashbang is, essentially gunpowder, no projectile. Contained, very loud, very bright, very hot, but if it's contained, not very, very hot. Essentially, that person who broke into that truck isn't going to be hearing anything for quite a while. They probably also aren't going to be able to kind of moderate and stand up and walk a straight line for a period of time, because their inner ears are probably just really uncomfortable. And standing upright and walking straight line, not happening for a while. Is it like a firework? Yeah. Someone in the chat earlier said, like, imagine an M80 going off inside of a car without the explosive bits. But yes, that level of volume, that level of light, big bang, big boom, very, very bright. Now, this is where the F around and find out goes both directions, because you can be found liable for actions that you take that are excessive and disproportionate to the action that you need to actually defend the property. You can't use lethal force, and you actually can't use force that's disproportionate to the loss that you might sustain. So there could be some prosecutor, I don't know if there would be, but some prosecutor that finds that this is way excessive and wants to prosecute this type of behavior. So you deterred that break-in. I don't know. I do like the fact that he's advocating for cameras. Dude, I saw that and my head went to the liability like all over the place. He should have used glitter, like a glitter bomb. I don't know that that would have really dissuaded the perp. I think the fact that that hearing loss thing, that's going to dissuade that perp from breaking into several cars in the future. And I imagine that a lot of cops are probably laughing quite a bit. And honestly, I bet that dude, because it looked like there was a driver in the car that dropped him off. I bet the driver had a laugh at him. So I thought that was interesting. Bewildered cat. This is a good one. Or was it? Most places, you can't add hot sauce to your lunch to prevent it from being stolen. So why would you be able to use flashbang? Lunch is not really worth a whole lot, and you can poison people with hot sauce. Vehicle, worth a lot. Also, someone can mistakenly pick up your lunch versus you don't really find yourself breaking into a car by mistake. Not that often. So I don't know. Yeah, it's pretty interesting. In any event, that's our palate cleanser before we start moving on to some other complicated stuff. Let's catch up on some super chats, make sure that we're not falling behind on this one. Peggy Reardon, a friend Booby trapped his car due to the radio being stolen. Often he put a sign in the window. Person broke in, was cut up from razor blades. Interesting. I wonder how much the disclosure worked in that regard. The law is often interesting on this one. It varies from state to state. So I'm not going to opine on what how Louisiana law would treat this. Because like I said, the law varies from state to state, but there's only a certain amount of force that you can use to defend your own property. And booby traps, they're viewed kind of skeptically. Now, I think the ingenuity is remarkably clever. And do I think this guy, this would-be thief got the F around and find out, or got to find out part of the F around? Uh-huh. So, like, there's an F-bomb. Hey, it's an actual F-bomb. He fucked around and he found out. It's an F-bomb. There we go. Oh my gosh, that was appropriately used. F-bomb. That's one of them. I have 3 more. So, F-bomb. Cut from razor blades. Like I said, ingenuity. Pretty intuitive or innovative. That one. KC Cat, I'm way behind at 1.5, but maybe make pens and things. EN2 for fundraiser for Captain Corey Foundation. Just a thought. That's a wonderful idea. I think I'm going to incorporate that. Peggy Reardon, thank you for the super sticker. Hemplin, Texas has this. Chat become woke between TS needing hugs and love, not guilt in prison. Now this vehicle owner should have put the vehicle in a garage. No, I did not say that. Hemplin, Texas. No. I'm concerned about his liability. That's it. This would-be thief got to find out part of the F around. And assuming that flashbang was appropriately set up as it was, I am finding this to be rather humorous rather than that. The only caution I'm giving is that now that you know that the police have seen this video of someone breaking into your truck and continue to do the flashbang, if it works, great. Just not legal advice. Just not legal advice. That's it. So Hemplin, Texas, no, I'm not saying that you can't do stuff like this to protect your property. Joshua, thank you for the super sticker. Much appreciated. Nerd Virgin Counselor, we've actually had associations purposely move conferences out of New Orleans this year because the car break-ins have ramped up significantly over the past couple of years. It's freaking wild. So we don't see as much around here, but I have heard some really horror stories about rental cars in particular. Lori Leanne, this is in regard to the Schabusiness case, and I apologize for not pulling these up earlier. Bipolar friends in the chat, hold your hands up, hold your heads high. This is not you. It is a misrepresentation of bipolar. It could add to the stigma, but we will not allow it. Too many hugs. You guys, that's why I said don't diagnose. There are people that are struggling with mental health issues, and they are being treated for it, and they are not Taylor Schabusiness. So continue your treatment, continue down that path, keep doing what's good for you. Keep on doing it. You're not Taylor Schabusiness. Margaret, who's in charge of the shock wrap? The bailiffs were. That bailiff had eyes on. Crazy Cat Queen already Schabusiness. I don't doubt he believes, as I do, that she had some level of mental health issues. Correct. Just not NGI worthy. I would agree with you. I wouldn't be surprised if she has brain impairment from all the substance abuse. I'm not going to diagnose, but I wouldn't be surprised either with that level of substance abuse. I think she said she did 52 hits of meth that night. 52 is a very specific number. She said it, not me. Keltos, thank you very much. Thanks for the great vids. Handsome Rob, thank you very much, Keltos. Risa Chu, as requested by a friend, since vampires need to be invited in, would a warrant be sufficient for a vampire police officer? Thank you lots. No. They would need to consent to the search for a vampire. I think that's a lot of thinking right now. I'm going to go with yes. Laura Leanna, replay crew, take notes of GR. Good. Getting ready with me ideas and comment after. Good idea. Please comment. If you haven't liked the stream, please do so, by the way. And if you haven't subscribed, please do. We do these kind of breakthroughs as much as we can. The Lauren included a naughty book as a nod to your members. Well, we read slightly inappropriate books. I mean, appropriately inappropriate, like what was the one from last night on the members only? Would you like to play with my balls? Is written as a children's book, but just not. We need to decompress. Azam, thank you very much, my friend. Robin Chad, I have to leave for Peter's 250K subs celebration. I'm sure a lot of you did, but I'm glad, and I'm glad for Peter and hope he's doing great. I'm sure you'll still be here after that. Probably accurate. Probably accurate. We still have 3 more cases to cover. Ryan Man, why do I see booby traps are illegal? Because they are indiscriminate. Yes and no. Yes and no. What if you installed on an AI-driven system that could measure response versus threat? Well, that then opens up a whole lot of questions. Oh, I don't know if I like this. So the booby trap question is always raised in law school as a spring gun scenario, where essentially, simple concept, a shotgun pointed at the front door of a house. Person opens the front door pulls a string pulls the trigger of the shotgun goes off, aiming at the person who's entered the front door. Okay, that is the law school question of booby traps. Now, it's very clear to see how that could be deemed unlawful. It's indiscriminate. Whoever walks through the door, whether for a legitimate purpose, unlawful purpose, or by mistake, is then met with a lethal force. Simple example. Now, carry that forward with the example of the hot sauce in the lunch. Or, if you have a favorite beverage, you put soap in it instead of the beverage. Things that you would view in terms of a prank. That stuff on the other end of the spectrum. Simple prank, no risk of injury, all in good fun, right? Then there's this realm of stuff in between. I would say that a flashbang in a vehicle is on that realm of, I think, lawful, not legal advice. I think it's on the lawful side of it. It leans towards that because you have eliminated a lot of the deadly force threat. And as far as being indiscriminate or not, the only way that that flashbang goes off, arguably, is when someone has committed an unlawful act of entering your vehicle. Arguably. So that's where my head goes with that analysis. But I can see that analysis changing if certain facts get moved in one direction or the other. So from the moral standpoint, the person breaking in, do I have sympathy for them? No. From the legal standpoint, do I want to see this guy be found liable for that? No. So I would, that's why I'm saying that. That's where my remarks are aimed. Thank you, Ryan YYC. Cashette, thank you very much. I saw the masterfully done wooden YouTube plaque you made, Captain Corey. Rest in peace, Captain. Rest in peace indeed. Fair winds and following seas. You have a woodworking storefront or take requests? I don't. I don't have time or capacity. I am a full-time attorney, and I do this as a side, and the woodworking stuff is a hobby to keep me at peace. I don't have the hours to be able to do that. I make stuff from time to time and give it away. That's about as close as I get to it. But you know what? I'm gonna start finding friends that I can start sending people to that have requests. Friends that I trust who make stuff that I have seen. That's one thing. Maddie Retman, Milwaukee has a gang called the Kia Boys that steal Kias. There's a YouTube documentary on them. Interesting. Irish Rover, the flashbang would not be set to lethal as the guy would not want to destroy the inside of his truck, just enough to scare. Correct. That is correct. Let's say, hypothetically speaking, that there's a malfunction in it and it does cause lethal injury because things go wrong, things go sideways. Let's also say the person is a little bit too close to the flashbang when it goes off and it causes not just lethal but permanent damage. Look, the age-old question is, do you remember the case of, what was it? The would-be thieves that fell through the skylight and fell onto the kitchen island and cut themselves with knives that were left out. And they were able to somehow sue the homeowner and recover. There's other examples of that. It's not the one-off case where that happens. And that's why when that guy gave the advice of set up cameras, I don't recommend doing the flashbang to your own vehicle. That's why that advice is probably the way to go. Cameras, because the risk, you do incur a certain amount of risk when you set stuff up like that. So that's where a lot of my comments were. That's where they were aimed. So anyways, yes, I have seen that Kias, Hyundais apparently are also on that list. It used to be Honda Civics and Honda Accords. So, all right. what do we say we do a little bit of discussion about Coburger? There are real examples of that throughout law. They're wild. They don't make sense. They're all over the place, though. Every state has their own bad example of it. Yep, burglar in a chimney. I mean, there's all kinds of stuff. It's really pretty terrible. All right, let's talk Coburger. We'll do a history lesson too. Old Tweet. Okay, Bryan Kohberger. So, Bryan Kohberger. Kurt, you're going to appreciate this. I do see that you're still in the chat. Where are you? Oh, you think you know a guy that you see him shave with hot sauce in the face? Yep. Let's tell Rob some jokes. So I see in the chat. You're going to appreciate this. So Bryan Kohberger has filed a motion to dismiss the indictment against him. And a lot of people are very, very concerned about this. And indictment came from the grand jury. And let's go ahead and pull this up. And we're going to do a little bit of a history lesson. Yeah, why don't scientists trust atoms? Because they make up everything. Kurt's in a mood today. I appreciate it very, very much so. So we're going to do a bit of a history lesson while we talk about this. How many of you guys know what a grand jury is or why a grand jury exists? I actually want to see this. I want to see responses in the chat. How many of you guys know? We are going to find our documents. Let me see. There we go. Magna Carta, Article 52. Where are we? Let's see. Forgive me for one moment. Let's see. Where was it? All right. So, what is a grand jury? A grand jury is essentially an agent of the sovereign. And when I say that, what do I mean? It's an agent of the people being essentially the embodiment of the sovereign's will. And where does it come from? It's an inherent power. It's not something that really existed. And it was established as a constraint against the sovereign by the people, where essentially, if someone wanted to prosecute you for a crime, or if a crime was going to be levied against you, it actually dates back to biblical times, and the book of Deuteronomy, I think, was the first reference to it, where it would be a gathering of the judges of the various tribes. I think. But essentially, you would impanel a group of several, and that group of several would act as a buffer to determine whether or not you would or would not face charges. And that became embodied in the Magna Carta. It became embodied in English common law. And it essentially, under English common law, I'm trying to pull up the actual language from it. Think. Come on, Rob. Where is this? Because I didn't pull this one piece up. I just remembered it. And now I'm just jumping off of memory and trying to remember the specific passage of Magna Carta that I remembered, because my brain ends up remembering certain things, but not all of the things. Article 52 of the Magna Carta. Let's see. All right, so the medieval criminal trials, the original clause 39 of the Great Charter of June 1215 reflected a privilege negotiated by the barons against the king to ensure that their disputes with the king, mainly over land, would be settled after advice from men of their own rank and status. So essentially, it would be creating a second panel, a second group of individuals that would pre-vet, that would predetermine whether you could or could not face a charge. The reason, and the fear was that there would be a sheriff, and the sheriff would have the ability to just charge you after you trespass on the property. They would say that you committed a murder, and they would have no basis to say that, but they would charge you. They would deprive you of life and liberty. They would essentially bring you up on these felonious charges, and all of a sudden you would be waiting in jail, incarcerated until your trial, which under old rule was essentially not a great circumstance for you to live through. And it was a way that there was a pre-vetting of that, where the sheriff would have to submit this to a panel of judges, individuals, a jury of sorts. And they would have to pre-vet the evidence that the sheriff had. The sheriff would say, here is what we have as far as evidence, and we now wish to charge this person. Give me a warrant of arrest to go out and do it. Now, people are referencing Salem, Massachusetts. Yes, exactly. So in Salem, Massachusetts, during the Salem witch trials, there would be these grand juries impaneled. And these were, they were learned men. They called them learned men at the time. The learned men would essentially gather, and then the chief prosecuting officer at the time would submit to that group of learned men the evidence that they had gathered. In the Salem witch trials, they would say, here is the testimony of this young girl who was an afflicted. And that young girl would get up and they would give their song and dance, and they would quite literally song and dance. And they would explain how they were afflicted and how they saw the face of, John Putnam, and they saw these faces, and they were the people that had afflicted them. And the grand jury would vote before that prosecuting officer would have the authority. The grand jury would vote, and they would say, yes, here is your warrant of arrest signed by all members of the grand jury. And that gave the prosecuting agent, the agent of the state, the power to go out and issue that arrest. So it was a pre-vetting. But the example I just gave you shows how it's been misused throughout all of history. While it's a pre-vetting, the grand jury is subject to different rules. So the grand jury is both a harness on the power of the state, in that you're supposed to go to the grand jury before you actually go out and charge someone with a felony, but it's also an agent of the state. You can use the grand jury because there's different sets of rules, things that you don't have to do, things that you can do if you so choose. It's just a little bit different. It's a little bit different. MLS, if you're in the chat and if you want to jump on for a bit, you can shoot me a DM. You can help me chat about the grand jury, because I do know that you know a bit about this. I like the history stuff of it. So how does it become a part of U.S. jurisprudence? Well, U.S. jurisprudence adopted this from English common law. English common law adopted from Old Roman law from Old Jewish law, et cetera, et cetera, et cetera. There was essentially a panel of individuals that would authorize the prosecuting agent to go out and commit the arrest and then charge this person with something that would deprive them of their life. It used to be limited to constitution or to capital offenses, and we embraced it and adopted it in our Fifth Amendment to the Constitution. And we'll pull this up. Amendment to the U.S. Constitution. And now this is going to be with regard to federal. And we're explaining this because a lot of people don't understand grand juries. Steve, if you're here too, man, you can jump on anytime you want. I'm talking grand juries. We're talking grand juries. And I like the history part of this, but I'm not a criminal defense attorney, so I'm always welcome to have people on to help me as I help others. So, like I said, you guys are free to shoot me a DM, or if you want to shoot me an email, you can shoot it to lawandlumber@gmail.com, and I'll see if I can't send you a link over. So, the Fifth Amendment of the United States Constitution adopted this. This idea of the grand jury to essentially act as a buffer between the state and you, the charged individual. And it was meant for felonies. So Fifth Amendment U.S. Constitution, no person shall be held to answer for a capital or otherwise infamous crime. And now we start to see where we get questions. People are saying layman terms. It's a way of putting this. Sheriff couldn't go out and arrest you because they didn't like you. Not for a felony. If they wanted to hang you, they had to go through some system of checks before they had the ability to go out and arrest you to try to hang you. That's what this is. So, that was the wrong pipe. That was definitely the wrong pipe. It hurts the soul, but not really. So, no person shall be held to answer for a capital or otherwise infamous crime. And now you see some of the questions and why law is so complicated. Because what is an otherwise infamous crime? Unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, where in actual service in time of war or public danger, that's because the executive is in charge of those already, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, double jeopardy clause, nor shall be compelled in any criminal case to be a witness against himself. There you go, right against self-incrimination, nor be deprived of life, liberty, or property without due process of law, of which a lot of these other things are part of it, nor shall private property be taken for public use without just compensation. So the Fifth Amendment has a lot of these lovely laws that we have in place, or these protections, among them being the grand jury. So no person shall be held to answer for a capital or otherwise infamous crime. How do we know what the hell that is? Well, we know what the hell that is because we knew what it was when they wrote the Constitution. So this then begins part of the discussion about why the Coburger stuff is interesting. And remember how I said that the grand jury was just kind of inherent, the concept of grand jury was inherent in the establishment of a sovereign. It was a way for the people to protect themselves against the overarching power of the sovereign, but it also became a method of abuse for individuals acting on behalf of the sovereign. So the grand jury essentially gets impaneled to vet the evidence before an arrest is made. We adopt it. This is the federal standard. What is a capital or otherwise infamous crime? Capital, pretty easy. If they are going to take off your head, that's a capital offense. Otherwise infamous crime. How do we know what that was? We know what it was because we knew what it was back then. We knew what it was back then because, well, we looked back to English common law. That's what established what a capital offense or an otherwise infamous crime was. How is all of this relevant to Bryan Kohberger? Remember how I said this was adopted by the Constitution? The Constitution is what establishes the concept of the grand jury in U.S. jurisprudence on a federal level. Well, the U.S. is an amalgamation of states. We're a republic. Each state is an individual sovereign. Each state has their own individual state constitution. Some states' constitutions adopt the concept of a grand jury. Some do not. Idaho adopts the concept of a grand jury. So in Idaho, you have protections against being indicted or charged with a felony, and that protection requires that it be submitted to a grand jury. And now we have a lovely question of law that's being asked, and that is raised by Mr. Coburger himself in his most recent motion. His most recent motion, share the screen. Stop that screen. Share other screen. So Mr. Coburger has filed a motion with the court. Here we go. Motion to dismiss the indictment on grounds of error in the grand jury instructions or in the alternative remand for a preliminary hearing. So what used to be the case, did Rob notice yet? Did I notice what? That Peter was here in the chat and that Steve Gosney was here and that MLS Law sent people over? I did. You guys are awesome. Thank you for being here. I really do appreciate it. We're talking some different stuff. I did notice. And right now the chat's got me distracted all over the place. I'm everywhere on this one right now. My brain, guys, this is what happens. ADHD is firing on all cylinders. I'm so distracted. And we're just winging with it. Because right now, Idaho State Constitution, let's see if we can't find the exact provision of the state constitution that impanels the grand jury. Oh, look at this. This is wonderful. Wonderful. The Idaho State Constitution. So here we go. Constitution of the State of Idaho. Like I said, states embodied this within their authorizing documents, their Constitution, which was laid out in the formation of these individual states. That was to govern how the state would be handling itself prospectively. You guys are about to meet a guest that we haven't had in a while. Rather, I don't know if he's ever been on this particular channel. Okay. So, as laid out in the Idaho Constitution, prosecution is only by indictment or information. No person shall be held to answer for any felony or criminal offense of any grade. So here we go. This is the framework that we're operating under. For any felony or a criminal offense of any grade, unless on presentment or indictment of a grand jury or on information of the public prosecutor after a commitment by a magistrate, except in cases of impeachment, in cases of a cognizable by probate courts or by justices of the peace, and in cases arising in militia, and yada, yada, there we go, all the other stuff. So there's the rest of the Fifth Amendment, which is embodied in Section 8 of the Idaho Constitution. And coming to join to the rescue, talking criminal law, is Mr. Steve Gosney.
Hey, I was reading the reading the law.
You were reading this.
Hey, thank you, Mr. Rob, for the invite.
How you doing?
This is an honor. I really I'm an admirer from afar. We've been on a couple laid back newses together, but
we have. We
never
have
actually. I don't think we've been streamed together before.
I don't know that we have either, and I don't know that you've had the privilege of meeting another friend of mine who's graciously donated some time to us this evening, Peter Tragos.
What's up?
Oh, the lawyer you know.
He's
Better than the lawyer you don't know.
Hey, I guess so, right?
You know what? I actually think that's a logical fallacy. I would rather the lawyer I don't need to know.
Don't do that's true. That's a good point.
But if you need one.
I will say that I'm already outclassed in the looks department, so I will just have to get back on my natural wit and charm.
Oh, come on, Steve.
Which
Cut
is not.
out, bud.
Look at
That'll
these
be easy
guys.
to
Look
be-
at these guys here. This is studly. Here, at least I should put on my hat.
Oh, there you go. God bless. Yes, that is an awesome hat. I need that. That's awesome. All right. So now, Peter, I know that you've read Mr. Coburger's motion to dismiss the felony indictment. I know you had thoughts on it. I think I mirror your thoughts on it. Steve, have you had a chance to read the motion yet?
I have not read it. I was explained it to him on the laid back news by Andrea Burkhardt, who is, I think, the go-to lady on this case, and she's actually going to be in the courtroom following it. So she explained some of the issues, and it was fascinating as a law nerd and as an criminal appellate lawyer. I was like, ooh, that's an interesting theory, you know? And she was getting bombed because I think in the motion itself, it says, nobody has adopted this logic, but we're still right. And boy,
Yes.
that's a lawyer out of my own heart.
It's wonderful. But Peter, you came over from 250,000 subscribers. So congratulations, my friend.
Thank you, man.
Did you win the golf tournament or no?
I did not. I birdied 2 out of 4 holes and lost, which is fine. It's fine. It's just more money for the people. That's all.
It happens. So
Boy,
Peter,
you
you
guys
were
are heavyweights. See, I'm just a hard-working public defender here in Florida. Are you from Florida, Mr. Lawyer? You know,
I am. Yeah. Yep.
Which part of Florida?
Tampa Bay area. I live in Clearwater.
Oh, love Tampa Bay. That's
Where are
a
you?
great city. I'm from Daytona Beach. I work in the 5th District Court of Appeal, Appellate Division for the Public Defender's Office.
I
Very
don't know
cool.
how the two of you haven't run across each other, actually.
I've seen Lawyer You Know. I haven't been introduced, so I'm honored.
Yeah, I think it's interesting that you're in Florida, you're an appellate criminal lawyer, and this issue is something that I think has 0 chance of winning.
Right.
And so I would like to hear what you have to think about it, because if people don't know, appellate lawyers are really the ones that get into the weeds on novel issues that, especially criminal, nobody throws a Hail Mary pass or shoots a long shot like a criminal defense lawyer in a case like this Coburger case. So let me just ask you this. What do you think would happen? How many calls do you think you would get if you were an Idaho appellate lawyer, and all of a sudden the judge says, you know what? The burden of proof in grand jury proceedings should be beyond a reasonable doubt. So every lawyer over the past 100 years that's done a grand jury indictment and has instructed the jury on the law that it is probable cause or something less than beyond a reasonable doubt has instructed them incorrectly. How would that affect prior
it's
criminal
more than
cases?
hundreds of years. Did you know the concept of the grand jury went back to biblical times?
I did not.
That's
Book of
true, but
Deuteronomy.
for legal purposes, although I have been known to cite Magna Carta in my legal briefs. In fact, I just did in the case I just argued before the 5th DCA. I argued a Magna Carta issue for an excessive fines clause argument I'm making against. Well, are you familiar with the $50 a day cost of incarceration in Florida?
Mm-hmm.
So I'm challenging that on excessive fines grounds in the 5th DCA. The oral argument is posted over on my channel, and
cool.
I'm hopeful. In fact, if I lose on the 5th, I will go up to the U.S. Supreme Court, Florida Supreme Court, U.S. Supreme Court. I fully briefed this issue, and I'm excited about it. But the question on the table that I was asked was what now? Was
if the burden changed and everybody's been doing it wrong forever with grand jury indictments,
centuries.
That's fair. That's fair enough. But I will say that is it a procedural question or a substantive law question? So, whether or not it is retroactivity would be a different question. So I would expect that the lawyer, they would have some way of characterizing it so that it would not be retroactive, so as not to invalidate the previous grand juries.
Would it be considered retroactive if he's saying originally this is the law and it was wrongfully just said by a judge one day that it's probable cause? I don't know that it would be retroactive. I think it would look that they've been doing it wrong and this is the law.
I understand that, but the judges would have to opine on that. The question is it procedural substantive? But I don't, knowing the appellate law, assuming that they would bite into this argument, which may be logically correct, if they were to bite into it, they would probably say, okay, maybe it is correct and we're changing the law going forward, but as of the prior cases, this is going to go unaffected, and they would probably explicitly say that in their opinion and justify it with enough words to buffer it so that it would remain uncorrected until further lifetimes have passed and it becomes irrelevant.
Do you think that would be fair? Like if you represented somebody or they came to you and said, Coburger gets beyond a reasonable doubt for his grand jury, but my guy a year ago didn't get that. That's not fair.
But you didn't ask, so you waived it.
It's fair. It's a fair point.
It's not fair. Actually, I have an article right around in my head, but that's what appellate judges love to do to wash their hands of injustice, is say, well, you, Mr. Defense Lawyer, didn't do your job. You're incompetent because you didn't argue it below. Therefore, you consciously waived it, even though you had no idea the issue was even on your radar. But they use that as a
Steve, it's worse than that. You didn't raise it at every single opportunity that you could have till the end of time, going back to the original arraignment.
Exactly.
But the foundation, so you guys made the comment that I think is really interesting. So it goes back to the interpretation of where the grand jury gets its authority, and it's constitutional in nature. And Fifth Amendment basically lays out these criterion that you can't be held to answer for a capital or otherwise infamous crime, right? So we had this body of law that existed in English common law that defined what charges we would require a grand jury to present. And arguably, back then, English common law, we had a standard that we were going to apply. Idaho adopts similar language. No person shall be held to answer for any felony or criminal offense of any grade. Now, that's pretty intense. So Idaho has to submit every criminal charge to a grand jury? There's no way.
Or on presentment time, or on information by the public process.
Okay, so then you can do public prosecutor.
No person shall be held to answer any felony criminal of any grade unless on presentment or information. So no, it is either or. Grand jury can indict for any crime. Information can indict or can charge for any crime except for capital or crimes of what the language is. But usually in Florida, we've limited it down just to capital offenses, which are offenses that are punishable by death.
Yep. And now you got to translate what an information is. Information is essentially a written complaint.
Yes,
says these
all
are-
it is
these are-
a
these are the
document
facts that
signed
lead
by
to
a
the charges.
prosecutor. Now, the only real well, there's two advantages to the grand jury process. To the defense, I would say. Number one is it slows down the wheels of justice just a tiny, tiny little bit. It puts a little grain of sand in the way of the overrunning train of injustice that's running over clients, right? So it slows it down so that you can't, because otherwise any prosecutor can, at the swipe of a pen, charge anything at any time on anybody. All right, now, so the grand jury makes them go through some amount of process that slows that down. Number two, and that is that if they have to get it right out of the grand jury, because if the grand jury indictment so it's a grand jury indictment, and information is the document signed by the prosecutor. But if you have an indictment, that cannot be amended by the prosecutor unless it has gone through the grand jury again. So a lot of times what will happen is prosecutors screw up their informations, and then there's a lot of liberal laws that allow them to amend it on the fly. But if there's an error in the indictment, which comes from the grand jury, it's much more difficult for a prosecutor to fix that error going forward. So that's a technical advantage that very rarely comes to bite, because usually they get it right on capital cases.
Simplifying it even further, the prosecutors that has the pen that writes the thing that says this is what you're charged with. When they get to court, they can take the pen, scratch out a line because they have the power of the pen. They can revise it at court at that moment. The grand jury holds the pen in these felony cases. Prosecutor can't get to court and say they don't have the pen. They can't control it. They can't go back and amend it. So it has to go all the way back to the very, very, very beginning, and you have to re-impanel a grand jury, present the evidence, and then try to charge again. That's the
But
most
the
simple way
likelihood
that
of
I can
that
explain
happening is so very minuscule, because usually the capital prosecutors that are going to grand juries are the best prosecutors and have their ducks in a row, and it's sort of standard issue murder language. So generally they're not going to make that kind of error. But you could, for example, have a date issue, perhaps. Now, dates are generally not part of the information, so it's not a substantive part of the charge unless you do what they call a statement of particulars. So assume that they get the date wrong. You do a statement of particulars in Florida, and therefore the date then becomes an element of the crime, and the date is wrong on the indictment, and you can catch them with their pants down at a jury trial. Theoretically, that would be a good defense, a good way to get it. But I've never seen that happen.
This is a good segue. It's a good segue because theoretically, you're right. Theoretically, there are things that we can do. Theoretically, if you read the law as black and white, this can possibly occur. How many trial judges go with that interpretation when it means disrupting the apple cart?
None. In fact, they're obliged to follow the appellate law. The question is it preserved? So what they're doing is they're preserving this issue for future appellate review.
Correct.
And I would say, as an appellate lawyer, I don't like them preserving this issue on this case, because this is such an infamous case that your facts, and you have an opportunity to make bad law. So if you're going to make a constitutional swing, like, for example, I'm doing with the excessive fines clause, I've got a case that is ridiculous on the merits of the facts of the case. And it's the kind of case that I want to take to the U.S. Supreme Court, because the state looks stupid when they argue it's not excessive. Because basically somebody got, well, in law, a lawyer, you'd get this because you're a Florida man. And that is, the guy got 22
Poor
years
choice of words. Poor choice of words.
What?
Poor choice of words, Steve. He's not a Florida man. He's a Florida man. He's a Floridian. You don't want to be a quote Florida man. The Florida man ends up on the paper somehow.
I'm a proud Florida man.
Especially me. I'm a Florida State man, if anything. Okay, I'm a Florida State man.
God. One of these, not one of
right.
these.
Oh yeah, no. Yeah.
My wife's one of these. So.
That's great. Smart man.
I will say that. What was it? So yeah, the case in this one was a guy who violated his curfew by 30 minutes and got 22 years in prison for the violation of curfew on his probation. And in that case, he has over $400,000 in costs of incarceration for 22 years in prison, which exceeds his entire ability to earn from the time he gets out of prison until he retires. The amount of his fine exceeds his lifetime expected earnings. So those are the kind of facts I want to take before the appellate court. The quadruple homicide in Moscow, Idaho is not the case you would want to pick to bring these kind of issues forward. Do you understand what I'm talking about?
I got you,
your
Steve.
cases?
We're going to keep you focused. And this is the ADHD brain that's recognizing when someone's on an ADHD loophole. We're going to keep you focused, bud, because we're going to get to the Idaho, the Moscow. We're going to get to this one because we got to make it to this motion. And Peter is up past his bedtime, and he has been kind enough to share time. You're free to jump off anytime you want, my friend.
I do want to mention just a couple things about the Coburger situation, because I understand the arguments of, oh, it's not fair. Oh, you didn't raise it. But thousands of clients have had these same lawyers, maybe not under the exact same circumstances, but under situations where they could have made this argument and didn't. So I think that the ripple effect, if the judge were to grant this motion, is insane. And that just is piling on top of why I think this has absolutely no chance to ever be a winner. And it also just logically doesn't make sense with how we come up with our burdens of proof in our criminal justice system anyways. Just my opinion on it, as somebody who's been on the defense side a lot longer than I was ever a prosecutor.
Yeah, I'm inclined to agree with you on a lot of that. I actually made the comment yesterday when you were reviewing this last night. I basically said, if this were a paying client, you would never see this motion. You wouldn't see this motion. Like, while it could be filed, the likelihood of its success is so far removed. And if you have limited resources and what you can bring to bear in defense of your case, is this where you spend those resources?
Okay, can I make a counter argument?
Oh, I'm scared. Yes.
Always.
This is, I believe, at least a possibility, if not a probability, of a death penalty, right? This is a capital case.
Correct.
In a capital case, you raise all defenses and all motions. So it's a different, death is different. And I'm doing a death penalty case right now. And if it was a regular appeal, my list of issues might be 2. But because it's a death case, I have over 19 issues I've identified. And there are no Anders briefs. So you can't say there's no issues. You must merit every capital appellate brief. And so same thing with the trial attorneys. The same sort of burden is on them. When you have a client who is facing death, how much due process is due? It's maximum due process because it's the maximum penalty.
Should they file a motion that it's cruel and unusual punishment, the death penalty?
Probably, and they probably will.
Yeah.
They will.
Standard.
So, I mean, they've got to file, if you're going to hit everything, you're going to file thousands of motions in a case, right? You got to draw the line somewhere.
Not thousands, but there's a collection, and we
no, I said if you're going to find everything that has as much merit as this motion, I think I could probably get to 1,000.
Well, okay, good point. Good point. He makes a good point. But I don't know if you do death cases, but in fact, I'm going to a death conference over in your area. Well, actually, it's in Disney World.
Steve, you got to work on this choice of language, my friend. You have to work on this choice of language. You're going to a death conference, Florida man. You're now 2 for 2, bud.
It's true. Can I say it's a death conference? It's called Death is Different. Anyway, I'm going to be over there, and this is one of the things we talk about is these standard motions we do, because the Florida death penalty statute is so defective in so many ways. And we're trying to point it out, but our jury committee is filled with prosecutors and they don't want to hear what we have to say. So we have to do it the hard way through the federal system. So we have to federalize everything and create a big block of motions. Now, whether or not this is one of those motions that the people in Idaho have thought this is really a winner, it doesn't smell like it to me. I'm agreeing with Mr. Peter Lawyer, because I think it's such a long shot. It's not where you'd want to focus your efforts. I don't know. I'm not convinced, but somebody had an idea and they filed it.
What Steve just highlighted, as far as a lot of the motions and what Peter was as well, is that this is one of the contrary arguments to the death penalty that a lot of people don't really factor into their equation, is the number of motions that get filed, the number of arguments that get appealed, the number of appeals that are granted and reviewed, the massive expense that exists on this end of the table is really wild. And Steve, yes, you may do it, my friend. You are allowed to shill your book. You're allowed to shill your book.
Okay, well, thank you. I have actually written a book on this very topic, and it's called Death Penalty Debates, Net Positive or Net Negative. And it's basically trying to understand the costs and the benefits of a death penalty in a fair and reasoned way, because most people aren't involved in the death penalty, and so they don't know all the ins and outs. But you're making exactly one of the points that's in there, which is the cost associated. And that's a question that I often get, is why is the death penalty so expensive? And this book it fleshes out. I put a whole section there to answer that question. And one of them is because not only do you have to have the best lawyers, the highest trained lawyers involved in this process, it also requires every argument to be made. If you have due process, which is part of our Constitution, in a death case, which is the maximum penalty, you must have maximum due process. And it requires mandatory, any death sentence imposed in Florida or any state, there's a mandatory death penalty review by the Florida Supreme Court, or the Supreme Court of the country. So, and that's one of the reasons they hate it. The Supreme Court of Florida doesn't like it because they're choked with death penalty cases because it's mandatory review, and they have to write an opinion on it. And it's a very complex, like this case I'm doing right now. It's probably going to take me 3 months on one case. And, you know, I could be doing, you know, 10, 20 cases in that same time. But because it's a death case, because they're trying to execute a citizen of our state, it requires maximum due process. So if you have questions about the death penalty debates, available only at stevegosney.com. Hey, man, Law and Lumber, you're a hero for me.
Okay. Well, let's get to the motion. Unless, Peter, you want to jump off. I know you've been streaming for a while, and we're past like a lot of normal operating hours. But
yes,
I am
going to take off. I'll make it back on another one where I have a little more time and it hasn't been such a trying day as today was. Steve, really nice to meet you.
Nice to meet you.
Maybe I'll meet you in person here since we both live in the great state of Florida. Rob, the video I did today was a golf video. So there was a lot of people in the chat saying, why is Rob scared? Why is he hiding from you? Why is he dodging you? So I think that's something you're going to have to think about and discuss.
I have not been posting good scores. I'm in the 80s right now. I'm not happy with it. Upper 80s.
Dude, I'm a mess. I'm a mess right now.
Okay. Winter is coming.
Let's get the game fine-tuned, and then we'll match when we're both at the peak of our powers.
I like this idea.
All right.
I like this idea. All right.
See you
Enjoy
guys.
your evening, bud.
See, I'm such a girly man compared to this guy. Look at this guy. He's a stud, man. I'm just
no, you're not.
Man.
Come on, Steve. You got
come on. This guy.
You got
a good-looking man.
You got all the brains, my friend. All of the brains.
Well,
all right. So here's the actual substance of the motion. So the motion dismissed the indictment on grounds of error in the grand jury instructions or in the alternative remand for preliminary hearing. So all of the different interlude, Mr. Coburger is making this particular motion and seeking to either dismiss the indictment or, in this matter, to treat it as a presentment and remand for a preliminary hearing before a magistrate. It just automatically, it feels like a stall tactic. The motion is made on the grounds the grand jury was misled as to the standard of proof required for an indictment. Well, that seems like a rare thing because we've been applying the standard for a long time. So here's the reference to the existing law. And I do like when briefs are written this way, where they lay the issues out immediately. So the Idaho Constitution, Article 1, Section 8, set the standard of proof for a grand jury at beyond a reasonable doubt based on the plain language of the statute. Legislative history also supports a beyond reasonable doubt standard. Idaho Supreme Court cannot adjust the standard of proof as it is substantive right. Right now, these are two assertions that are pretty damn bold.
No, but those are good assertions. And this is something that a lot of lawyers miss this, including judges, and that is that the Constitution is superior to statutory law, to case law, to regulations, to rules, to procedural rules. The Constitution is superior to all of those things. So if the Idaho Constitution sets, I would have to read, I want to cut and paste that, but I can't. The Idaho Constitution, Article 1, Section 8, sub 191107 IC. I don't know that site, but Article 1, I would want to read that section. Does that lay out a standard of proof?
You can, pull up that code section. If you find it, you can link it to me.
And I'll
all right,
look it up.
1 second. Okay. So the failure to properly instruct the grand jury as to the standard of proof as grounds for dismissal of the indictment. That's a bold assertion. The grand jury was erroneously instructed with the standard required for a presentment. Thus, the court should treat the indictment as a presentment. These are very bold propositions because it's really, every lawyer has their back up right now. They're kind of going, this is against the flow. I don't know what this is. So the Idaho Constitution says, and then here's the portion from that relevant statute.
Okay, yeah.
So 19-1107, the grand jury ought to find an indictment when all the evidence before them, taken together, if unexplained or uncontradicted, would, in their judgment, warrant conviction by a trial jury. So
Okay.
all of this is
I get it.
turning on this last
I get
little
it.
sentence.
Yeah.
If it would warrant a conviction by a trial jury, it's a whole lot of caveats.
No,
The
no, no,
statute
this,
was-
this is not a good motion.
It's,
I don't agree
it's
with
rough.
This is a law review article that somebody wrote that they said, this is really a good, this is clever, aren't I brilliant? And I'm a professor of law and I'm going to criticize. And I'm all for that. I've written lots of law review articles, so I'm all for the academia. But the problem here is all the qualifications. What you just said is exactly right on point. Because
you have to make the arguments connect with other arguments and then other arguments and then other arguments, each one requiring a different level of interpretation before you get to your overall conclusion. The longer you have to make that argument,
right. Well, let's read this. Here's the problem with it. Okay, the injurer ought to find an indictment. Okay, so the grand jury indicts when all the evidence before them, which is controlled by the prosecutor, so they don't have to give them all the evidence.
Ham sandwich
together, and then here's the thing: if unexplained or uncontradicted, so they have to accept. See, this is the problem. The prosecutor
accept it as
gives
true.
the grand jury exactly what they want to hear. Doesn't have to give them the whole story. Can only give them the side that they want to present, and they have to accept that as unexplained or a contradiction. So buy into that. Would in their judgment, which how do you subject it? So they're reading into in their judgment a beyond the reasonable doubt standard, but that's a long shot. I don't agree because I think the qualifications take away the beyond the reasonable doubt standard.
Then that's the thing. It turns this last application of conviction by a trial jury. So statute was in existence when the Constitution was adopted. So the Constitution was adopted, but the statute already existed prior to that. Provisions of the Idaho Constitution must be construed in light of the law prior to their adoption. That's pretty standard, straightforward interpretation of law. If the law existed prior to its adoption, for the Constitution, it exists. We look back to it, kind of English common law argument. In Clark, the Supreme Court found a statute in force at the time of our Constitution was ratified to be controlling in its interpretation. Okay. So this is a premise I'm willing to accept. If the statute was in existence at the time the Constitution was ratified, and you say there's a Supreme Court case law that adopts it, that's not the complicated one. So let's move past this particular argument to the next one. Where was it? Oh, this was kind of the background that we talked about. Thus, what the language meant must be color court interpretation. This is the section that authorized the establishment of a grand jury. It says that is the barrier between you and being charged. If it were not clear from that, the framers' general intent behind the section was to ensure that either grand jury or magistrate stood between the prosecutor and the accused. Yeah, it also has become kind of a bludgeon in the past, but sure. Thus, it stands to reason that standard of proof in effect at the time of the adoption, this part. Thus, it stands to reason.
Well, okay, well,
does it?
Maybe, okay, let's assume, but where is the beyond the reasonable doubt standard coming from that they're implying, even if it is in that trial statement, it's qualified by the if believed and that there's other two parentheticals. So, I mean, it's an academic exercise.
And that's the thing. That's what it feels like. It's just the entire time. However, that does not provide much information as to what standard would warrant a conviction by a trial jury. Now we're in our second layer of argument. We are argument inception. This is now argument inception. We are now at the argument within the argument, and thus begins the wildness that we begin. The interpretive statute must begin with the literal words of the statute. All right, I'm with you. Conviction by a trial jury. Okay. Statute must be construed as a whole. If the statute is not ambiguous, this court does not construe it, but simply follows the law as written. Good. I wish courts would do that more often. We've consistently held that where statutory language is unambiguous, legislative history and other extrinsic evidence should not be consulted. Go on. Yada, yada. We're not going to go outside the bounds of the statute. So now it says we're going to look at the statute.
See, read that. This is the problematic sentence. The plain text sets a standard of proof that would warrant a conviction at trial. Yes, but with the qualification that if believed, and on the other, there was if believed, and there was one other parenthetical that took away the strength of the beyond a reason. They're not weighing. They're saying they've got to take this, and if believed,
entirely, without any shadow
swallow
of doubt.
that big old egg, which is, and they leave that out. They only say this, which, you know, it's clever, but it's, you know,
Exactly.
clever.
So then we're basically saying we adopted it verbatim from these other states. We are now in like the third layer of inception, where we're now going to other states to help interpret our state. And we're going to back to cases that were, what's this case? This one is back in 1862.
Well, I like old cases, but yeah.
I do too, but that's where this motion leaves us. So now we're in the legislative history. This should give you a pretty good understanding of how much merit this motion does or does not have when you're citing legislative history as the second prong of your argument.
I really,
you're stretching.
I hate legislative history. That is very weak, because that is just discussion.
Yep. And now we're in a history. The history of this formulation show. Oh God. So here's my question for you, Steve. Without going through all 23 pages of this motion.
23 pages? Oh my goodness. It's a law review article. This is an academic, somebody who's coming in with a law review article who wants to say, hey, you should raise this. And as a death penalty trial lawyer, they're like, okay, well, we should better raise it because it's on our, it's something we can raise, so we will.
So now, let's say hypothetically that Coburger prevails. He's not off the hook. Like, this goes back to a grand jury. Even if he wins, it goes back to a grand jury. So, or it is a presentment. Now he has a prelim in front of a magistrate, right?
Yeah, see, I don't know about that. I mean, see, I'm not sure. That's a good question. This is a very Idaho. It seems there's some Idaho procedure that I'm not familiar with, and I'm not an Idaho lawyer. But yeah, it seems like if they were successful, what's the remedy? The remedy would be re-indictment.
Well, yeah. Walk me through the thought process. And I need 1 second. So give me 1 second. Then can you walk me through the thought process? I'm still listening now.
No. Yeah. Well, the process would be, okay, so let's assume that they're right. And the judge or the appellate court. So like, I don't think the trial judge is going to grant it because he has to follow the precedent, the law, and there's no precedent. So he's going to overrule it. But then they take it to an appellate level in an interlocutory appeal through something called a writ. So they'll do a writ of prohibition, say, on this. And then the appellate court rules and agrees. Magic. They were right. They need a grand jury presentment. Okay. So the indictment gets struck and it's sent back below to re-indict. All the prosecutor does is re-indict given the new legal standard, and you're back to square one. So it doesn't seem to me that you really get anything, even if you're right on this motion, as a matter of remedy. For example, when I'm doing appeals, sometimes I'll have a really good issue that doesn't get me anywhere, and then I'll have a weaker issue that gets me 5 years off the sentence. Well, I might put the weaker issue first because that gives my client real remedies rather than just something that shuffles the chairs on the deck of the Titanic, which is kind of what it is. Hey, Tia, you got a good chat. You got a nice chat here. You've got an educated chat, Rob. I'm impressed. Look at your chat. These people, they know their stuff. I think it's because of the way you go through this. You've got some educated chatters. I
love my chat. My chat's fantastic. They're wonderful, wonderful people.
Yes, I need to tell Chelsea this is a Martin D41. So, see, I love chats, and your chat is smart. I'm watching them, and they're asking smart questions. I'm like, ooh, that's a good question.
Well, the thing is, it is, and they ask me questions, and a lot of times I get caught off guard. I don't know the answer to, and I end up sitting there going, oh, but it just it works. Yeah. But I don't see where he's getting with this.
Emily, well, again, it's because it's a death case and they're supposed to raise all.
You're going to make every argument you can.
Every argument you can. I don't really agree. I don't really agree with this particular strategy for the reasons I enunciated. Is it doesn't get you anywhere. Is this a big issue that's rattling around Idaho, or is there somebody on the defense team or are they playing? Maybe they're playing for time. That could be too. It could be a delay tactic.
The other part of this is the potential consequence of if this is deemed to be a substantive legal requirement. Let's say the Idaho Supreme Court comes back and by some stretch of the imagination says that as a matter of substantive law, every indictment must follow a instruction and finding by the grand jury that it was proven beyond a reasonable doubt. Now retroactivity is in play, right? Because now you're substantively modifying.
Right.
And
well, and
hypothetically
this is the
speaking,
parade of horribles that the state will bring in any appeal.
This is a big parade of horribles, Steve. This is not a small parade of horribles.
You say that, but although I will note that there has not been a death penalty case, I think, in Idaho in 10 years. So I imagine Idaho's death row is quite small. So the number of people this would affect would be very minuscule, even if it was substantive.
Yeah,
that would be my comeback as a defense attorney, saying when they trot out the parade of horribles and all that, I'd say, there's 5 people on death row, so we got to retry 5 cases. Well, at what cost justice, right? Give them life sentences. That's what I'd say.
It is. I just don't see why. I don't get it. Other than just you need to cross every T, dot every I. I took a second there and made sure I said that right.
Let's say again.
I took a second there between you need to make sure I said it was the correct statement of crossing every T, not dotting every T and crossing every I, which I've done in court before. Yeah, you just got to be careful with it.
I just go with the passion. See, I mean, it's funny. Have you ever read yourself back on an appellate transcript?
Dude, no, I'm sorry. So yes. So as a trial attorney, you learn really, really early on. As a trial attorney, you learn really early on that you need to be careful about your words. And rather than use or things like that, it is sometimes better to just take a pause, because when you read your first transcript of what you are saying in closing arguments or in questioning, holy crap, it's embarrassing.
Yeah, it is.
So
I remember I had this one closing that I did. It's probably one of my best closings I've ever done. I will say that I'm old enough now and I've done enough cases that it's like I don't care so much. I try to avoid the uhs and the ums and the briefly, Your Honor. Those are my pet peeves. But I had one case, and I was so proud of this closing. I had a person who became a judge later, so it was the best closing she's ever seen, right? And I'm like, oh, this is great. I'm going to use this as my example to teach my trial attorneys in our trial division, right? And I got the transcript because I got the appeal, and I actually won that. There was 2 felonies, and it was knocked down to 1 second-degree misdemeanor, and I appealed the misdemeanor to the U.S. Supreme Court. But when I had this case, I said, this is a great closing argument. And I printed it out and I got the record on appeal. It was the most incoherent mess that I've ever seen. I was like, this is just terrible. It read terrible, but it felt really good. It was one of those, because I talk with my hands, I'm dramatic. I use a lot of gesticulation and passion, and that just doesn't come across on a written record.
No, it doesn't. You just seem very you just seem all over the place. So because we haven't had enough attorneys on, we're going to bring on another one.
But look at left-handed adventures. See, I told you have a brilliant chat. Hubby just told me there's 13 people on death row in Idaho.
I told you, man, the chat, Emily has taught me this fact, that the chat is the best bunch of research attorneys that you can ever hope for. And the number of people that are in that chat that are really remarkably smart, intelligent, and have their own specific expertise is remarkable at any given time. There's 2,600 people watching right now. Reminder, if you are watching, please like the stream. And if you wouldn't mind, subscribe to myself, this channel, and all of the people I've had on today. Steve Gosney, MLS Law Show, Peter Tragos. Please, that would be great. But
hey, Rob, how we doing? Steve,
how are you?
The MLS,
not too bad.
LLS are getting, I think we're partners in press coverage.
We are partners.
Did you guys both get press passes?
So I reached out to the court on the Sarah Boone case.
I'm going there next.
Yeah.
Ooh, yeah,
so I reached out to them because I wanted access to the media pool. I didn't want to have to rely on Law and Seaward and those. And they said, sure, fill out this lengthy questionnaire. So I did. I had to do links to my YouTube channel and my website and all this stuff. And they said, congratulations, you are now an official member of the media. We'll get you press passes issued by the court. You can pick them up in 2 days. And I was like, cool, but I'm not in Florida. But I know someone who is. And so I reached out to Steve. I said, hey, would you mind picking these up? And what we can do is I can add you as a member of MLS as well, and get you press credentials. And would you come up with your title, Steve?
Yes, I'm the senior trial correspondent for MLS Law Show.
You son of a bitch! You got to be.
Hey,
so we're getting
why not?
Press passes, and we'll have access to the
I don't.
media
You know
pool.
what? I don't know if you guys can hang out with us anymore. If you're actual legitimate press right now, we're alt media.
Yeah.
I don't know if you guys are allowed anymore.
MLS is official. Steve's official. We're all good.
We're official press. That's right. I better have some respect around here. And I did work in Flagler County. I was a prosecutor in Flagler County, Florida for 6 years.
What have I
I hope you
done?
don't hate me for it. Did I prosecute anybody you know? Your chat is saying, did you work in Flagler County? I'm like, yes.
Well, maybe we don't go too much into the Florida man stuff. We're just going to keep it there. So, anyways, Mr. Helm, would you like to introduce yourself to the chat who has not had the opportunity to meet you before?
Yeah, my name is David Helm, MLS Law Show. It was Michigan Law Show, and then we shortened it, and now it's Michigan Law Show, Law Show. We're trying to figure out what the MLS actually stands for now. But I am a licensed practicing attorney in the state of Michigan. I'm in Southeast Michigan, but I'm all over the state. And I've had my YouTube channel for about 5 years. I started it as sort of a promotional thing for the firm. And so that's why my name is out there and everything. I don't hide my name. And I watching Rob and everybody, starting with Rittenhouse and Emily D. Baker and everything, and with the Alec Murdaugh case. And I was like, you know what? I'm sitting here while I'm working and watching these trials. I could just stream them on my YouTube channel. That's easy enough. And then all of a sudden the chat started to grow. And I found out that it is kind of a lot of work, but it's a lot of fun too. So I've been doing it.
It's cool. You get really good questions and you realize how much you love talking about law. Like lawyers are weird. We're a weird bunch. You put a bunch of lawyers in one room and they will find something to talk about. And usually it's debating things that everyone's going, what the hell are you guys talking about? And come to find out, there's a lot of people that are somewhat interested in that.
Right. And I make it a point when I do my trial coverage to emphasize the fact that the defendant is absolutely innocent unless they are proven guilty. And I pull out the shortcomings and I say that's a horrible defense or whatever it may be, or this is, shady stuff that they're bringing. And what I'm trying to do is educate whoever wants to listen to me. And I don't know why people want to listen to me, but my chat's growing and everything, and my subscribers are growing. So that's great. That we need to look at this critically. And my first stream was actually a really interesting case. I heard, jealous ex-boyfriend murders, new lover. I was like, oh, that's got to be a cool little case to follow. And it turned out to be the Zachariah Anderson case. And that was a shady conviction. And so I got a lot of, and Zach's brother came on to do an interview with me. And that actually was kind of a good case to get started with. But that was a really bad case. And so I started, kind of focusing on what are we really talking about here when we're talking about jury trials? The jury is the last line of defense against a corrupt government. We have to convince our fellow man to put us in jail, and you got to take that seriously. So I talk to everyone out there as if you were prospective jurors, and really, what does it mean to be a juror and why is this important? So that's kind of my focus.
That's awesome.
So yeah, and we have some fun doing it too. So it's been a good time. I've been doing it since like March. It's this live trial stuff anyways.
Shall we transition to a topic that I think both of you because you're the Florida person?
Sure.
All right, I'm going to swoop, then we'll be right there. I think I might have just devastated some people.
What is that? What was that? You got to clue me in.
That is the swoop. There's the old swoop. So yes, the unicorn. for those of you who are new to the channel and don't understand what the heck is going on or why there's anything in the background over here, during one of the first times that I was ever doing a live stream, it was listening to Elaine Bredehoff explain how Amber Heard was a setback for all women, etc. Now, I'm a domestic relations litigation attorney, so I litigate domestic cases all the time. And I knew that was such bullshit, and it was pissing me off because it only meant that fewer women were actually going to come forward because it was dissuading them from actually, or making them think they needed more than what they already had. So I reached out to grab a stress ball, and it happened to be a gift that I had for my niece, and it was a unicorn. Chat realized I had a unicorn stress ball, and they said, "Is that a unicorn?" I said, "I guess it is." I put it in the background. Didn't realize it was still there. Chat saw it every stream, so unicorn just kind of started becoming a thing. And then I make stuff in my shop, and I encourage people to go make stuff because it makes you feel better. There's too much shit going on in the world. If you get down in the shop, Steve, you make music. I know you do that. It's the same thing. It's a very therapeutic process. So the chat started making stuff and sending it to show me that they were engaged in their own version of self-therapy. So I have a little robot jury back there of all the different participants that usually appear on here. So that is the unicorn. So the chat calls themselves the Sparkle Farts. I didn't choose the name. They chose it. They are the Sparkle Farts.
Well, there's a chatter unicorn glitter fart. Nice. Are you related to glitter fart?
I am not. I didn't
know
that.
You know the chatter goes with Flux all the time. She's a big.
I didn't know that. No.
It's funny, the chat, and the chat is like a dynamic of this that I never anticipated. The chat is like a whole universe in and of itself. They have their own rules, they create their own names, they have their own social structures. It's kind of an interesting thing.
You're right. That's something I didn't expect, and I've really enjoyed. I'm really a chatter in disguise. That's like I was a chat lurker, and I got called out by Bronca, on Ricada's stream. He's like, Gazi, because I knew Bronca on a number of cases. I dealt with him as an expert because he's the guy on self-defense, right? And I have dealt with doing criminal law. I've like interacted with him multiple times, and I was watching. I don't know. I think it was Zimmerman, because I thought I was going to get that appeal because that was in my jurisdiction, right? So I'm like, I better watch this trial. And Bronco was the only one making any sense out there. So I was like, and I said, "Oh, you're a good guy." So he's recognized me in the chat. He's like, "Gazi's the chat. Get him on here." I'm like, "Huh?" And here I go in the rabbit hole.
Yep. MLS getting shout outs. Lefty Lulls. Thank you for the super chat. MLS Law Show is the best channel. You get to hang out with me. So,
yeah, it's funny too because like the chat follows you around, So yeah, he's one of them. He's got his own channel too, but yeah, they follow you around everywhere. It's awesome. Chat is kind of cool. And I have to say, since Emily is in the chat, Emily D. Baker, my wife doesn't listen to my streams, but she listens to Emily.
Yeah, my wife.
Yep.
My mom listens to my streams.
My mom does too. Yeah, when I say inappropriate things, she's always
I get
she pop up in the chat.
Oh my God.
My mom does. She popped up in my chat today. I was streaming the Ethan Crumbly thing.
This is some of the books that like my chat will send me to just read, like in the members only in the shop.
Nice.
Yes. So nobody likes a cock block.
Beautiful.
And I will read these. And there was one occasion where I was reading one of these inappropriate books, and my mom dropped a super sticker. And I was like, "Oh, shit." Because the book I think I was reading was called Hung Like a Horse. It was uncomfortable. But every now and then, she will make herself known. And usually it's at the most embarrassing moments of all time. Right. That's what mothers do. That's what mothers do.
It's neat because I'm, expanding this world and getting to know different lawyers with different specialties. And, like Law and Lumber, we're just starting to get to know each other. And it's fascinating because there's this expertise out there, and I just learn a lot. I get to know these people. It's really fun. And so thank you for having me on. And the chat is just wonderful. Like you said, the knowledge base and the discussions and the world that's going on there while we're talking, it's really neat. It's a neat interactive forum.
It really is. We try to have fun, and we make learning fun again, because I think that's probably one of the coolest things about education is finding a way to educate people that, look, the best law professors I ever had were adjuncts. They were practicing lawyers, because when they tried to teach me, there was a clear passion in what they were explaining. They loved it. They really loved it. And it was infectious. And when you're talking about something you love doing, and we have a bunch of lawyers that are debating and arguing back and forth, and just you get into a rhythm, and you start to see that you can still have these dialogues that are complex, controversial. We could be screaming at each other or yelling at each other, telling we're idiots, but we still respect one another. And
right. Well,
you
and
have
that's
to have
you've
that.
got Natalie Wisco
Huge.
in your comments, and she's a great lawyer who's somebody I
Mhm.
look to up there in Wisconsin covering. And then Emily D. Baker, somebody that I don't really know, and somebody that, you know, I need to expand this circle because I know that everybody has their sort of their audiences. They like your style and they're attracted to different people. And so these are circles that you just kind of keep growing out and finding different people. So that's and Vices and I go
Literally, is everyone going to show up in chat tonight? Like,
This
everyone's
is
going to show up in
everybody.
chat tonight.
Well, I was calling out Rekieta on his grade of the defense attorney in the Schabusiness trial. And
We covered that earlier. Let's move on. We're gonna, because we already let's move on. As I know, Steve, man, you love a rabbit hole as bad as much as my friend Ian Runkle, and gotta reel you guys in.
You're the man. It's your show. Go ahead. Lead me on. Keep my face in the direction.
An individual that
This
is
one.
currently facing trial. Trial is presently set for October 2nd. That will move. There is no way that trial is going forward because they're still trying to find an expert that can be compensated, that will accept the compensation that the JAC will provide to provide an opinion that says that Ms. Boone was suffering at the time that she closed her husband into a suitcase, laughed at him, boyfriend in the suitcase, laughed at him, then went to bed, having forgotten the boyfriend was in the suitcase, in theory, but only having drank like 2 glasses of wine based on her interview, or a bottle maybe.
Yeah,
Well,
she
yeah.
She drank way more than that.
The interviews are interesting, to say the least, as is her desire to be heard. Really emphatically. So this, I think, is letter number 4 or 5 that she has written the judge. And this is the most recent.
Letter 7, but I think this is the 4th one that's been
published.
Yeah.
So, no, Tianina, I see your chat. I see your super chat. I do. And I do believe that they call themselves the harem.
They do.
Correct?
I did not. They named themselves that. Yes.
They named themselves. They named themselves. Just like Emily's chat named the Wood Daddy name. We don't choose the names that are bestowed upon us. Anyways, so Ms. Sarah Boone has several opinions about how her defense should be going and likes to articulate those opinions to the judge at every single turn. This one was rather interesting, though, because where her previous letters seemed to suggest that she was frustrated at the coverage that she was getting, or the media was covering, this letter was expressing a different frustration. So, hand delivered 7/21/2023. Revisions made 7/20/2023. Original not uploaded to date. Second attempt to make public, like everything else in my case, including all of my other letters. Freedom of speech, period, mine, period, all caps. June 29, 2023. All for your review, critique, judgment, understanding. Try it. That's the try. It was in parenthetical after fully underlined, all caps, understanding. All caps, underline, clarify, to become or make clear. Jesus. So we need to update the dictionaries in the detention center. Clarify, clearness, per the Merriam-Webster's dictionary. Okay, Ms. Sarah Boone, where do I even start? Through the officer inmate grapevine and a letter I received from my, quote, fan mail, and usually the only way I find anything out regarding my case, since there is, all caps, underline, no communication from my current attorney. Now 10 weeks of complete silence. And yes, my 6th attorney, which I will clarify momentarily. I was made aware that my last letter was featured on the news locally. Realistically, meaning globally. Apparently, my very legitimate, lawful, all caps, underlined, real questions and concerned, I asked and am still caused a stir on top of the already engulfing whirlpool my case has become and made out to look like, which is not. Hence, my previous questions from said letter. I am trying to protect and maintain my truth. Well, maintain that in private, because to the extent that you are articulating your truth in these letters, they will come back to bite you in front of the jury. Parenthetical beginning, which no one knows, and parenthetical. Since no one else will. However, I can and keep some of the illicit ugliness at bay. Mismanagement at its finest in everything. Oof. Why wasn't I included at all? Why wasn't I asked prior to being highlighted so I would know what was said or asked or criticized so I could rightfully defend myself? Well, several reasons. Because you're, 1, in detention. 2, you should await your trial to actually choose whether or not you wish to testify in your own defense. And 3, it's newsworthy. So,
Rob, can I ask you a question? Have you had
Please.
a client like this?
No.
I have.
You're in private practice, though, right?
Well, let me take this back. I don't know. That was a really quick no. I've never had a client write something like this to the judge.
No, that's not what I mean. I mean, have you had a client that thinks this way and has expressed it to you? Like, why aren't you telling me anything? Like, I have a client right now.
Yes, I have.
That's like, I say, hey, listen, I'm going to send some subpoenas out. Once I get a response, I'm going to put together sort of a kind of a cursory argument or a position. And I'm going to reach out to, this particular one is a probate thing. So the GAL, and this is what I'm going to do. And then, a week goes by. Well, subpoenas take like 28 days, a month, to get turned around. Right. And so, she sends me an email, or a text. How come you haven't said anything? I'm like, because I don't have anything to update. Yeah, I'll let you know when I get something. A week later or a couple of days later, she's like, I would really love communication from you without me initiating it. And what are you trying to hide? And you said you were going to send out a subpoena. And it's like, listen, do you think I'm working for the other side? What what's going on here?
Yeah. Or
that
why
kind of
haven't
thing.
we filed motions? Why haven't done it? Look, there are not enough hours in a day for a full legal team to file every motion that every client wants to be filed. It's just not possible.
Right.
And
it's not. And
the law
nor
try
is
to
it
explain
advisable.
that.
Nor is it advisable.
Correct.
You pick your battles. Like a motion to suppress is not there in every case. But
Correct.
they always want you to file a motion to suppress, a motion to squash.
It's always the motion to squash.
Yeah.
So always the motion
about the motion to squash. Yeah.
Well, a motion, and then there's the motions in lemonade.
Motions in lemonade.
Motions in lemonade. There's the motions to, what's the other one they use for the compel? Motion to
And then there's always like
or
the
something like
motion
that.
to dismiss, because they just dismiss this.
Yeah, dismiss this.
Yeah. Oh, sure. Yeah, of course. Murder.
Well, and it's the credibility part. So it's difficult. So yeah, I can see that there's conflict, and you have those clients. What the frustrating part is generally speaking, those clients orient those questions, that brain dump, that emotional outlet, to me. They usually vet that to their attorney. That's fine. That is protected. That is privileged communication. 1000% send me those emails. And yeah, I am a private practicing attorney. And when those clients send me those emails, I will bill you for every 6-minute increment of time that it takes me to read the emails.
Yeah.
Because I am not your therapist. I love, and I want to see you get the best outcome in your case as is humanly possible. But I tell every single client, I'm not your therapist. I can recommend several of them that are very, very good.
I always say I'm half as qualified and twice as expensive as a therapist.
Yes.
But see, it's private practice lawyers, so you have a good defense, and that is you just send them a bill.
Yes.
Time it took to read your 50-page letter. 3 hours.
It's
charged
amazing how
money.
those phone calls and emails slow down after that first invoice goes out.
Right. As a public defender. Oh, and the worst thing, and this is why people wonder why sovereign citizens are worse than sex offenders. And it's because
Oh my God, that's a statement.
I know it is. And I'll tell you, I would rather represent a sex offender than a sovereign citizen because they like to choke you with law and case law that is just irrelevant. And sex offenders, at least they're focused on their issue. They've studied the statute and they've clearly I went to subsection B and not subsection C. Right? So they're at least giving you some guidance about their crime. Whereas sovereign citizen folks, they're just pulling stuff out of the thin air and says, well, this is admiralty law and this is the civil law.
As far as client management, I would agree.
Yes. So that is the caveat that I'm going to add to Steve Gosney's brain jumping to that portion, realizing that we are all attorneys and we are thinking there from a legal standpoint, not from a practical standpoint, as someone jumping in the stream might have just heard Steve Gosney say sexual offenders are better than sovereign citizens. No, we are talking about from a client management standpoint where we're trying to determine which law is applicable to their case and how to defend them in court. Yes, that is the context that needed to be added to that statement, Steve.
Sorry, this is what you're here for. You're the host. You got to keep me in line. It's very hard. I will say I'm a hard person to keep in line.
So yes, context does help us very much in these discussions. As such, the context here is largely that Ms. Boone just, all right, so she,
But
so
what's
she's
the
very
point of this? What is the
frustrated.
point of this letter? There is no resolution. We read this in MLS Law Show, and Chandler Remington did it in a beautiful female voice. But it was it's a rambling brain dump of nothingness. There's really no objective here.
Well, the objective is quite simply it's this. It adds to the assumption of what everyone wants me to end up being and thinks that I am. This is the my truth part. Now, she doesn't go into what that is. She just says everyone's theories are idiotic. Everyone's opinions are empty. Everyone's accusations are false. And that the entire world is ignorant of the truth being her truth. And that her private case details, ma'am, this is a felony that you are alleged to have committed in the state of Florida. The state of Florida is prosecuting you, which means the whole state, the body politic, has an interest in seeing how this process plays out. This is not a private case.
Yeah, I think this acted more, like you said from the beginning, all of her stuff, she was upset that things were being made public. And this one, she intended to make it public. I feel like it's more of a press release than anything else.
And she's learning. The last one was more that way too. So
yeah,
the last one,
gradually
she authored it to the world. She's learning.
Emily's injecting a little bit of wisdom here. The video doesn't help her much.
No, it really doesn't. And what did I actually saw that clip got reshared. I think it's like a 60-second. They have a small snippet of it. Let me see if I can't find that one. There's one clip they pulled from her cell phone.
The one that she filmed herself?
The cell phone video.
Yeah, there's two of them. There's a 2-minute one, and then there's like a 30-second one. And
those that and here's the thing. There are currently mental health professionals evaluating whether or not they will choose to testify under oath that to a reasonable degree of medical certainty in their experience and under their field that she was suffering from
battered spouse syndrome,
which is under circumstances a very appropriate defense. I have made this comment before. I have made this comment before that family dynamics and interpersonal dynamics in cases of complex domestic violence are so fact specific and unique to each individual case. This is not some broad thing that we can approach and say whether this categorically is or is not a thing. Every case is so unique and the dynamic that exists is so personal that honestly, I've made the statement about protective orders too. The people that need them don't get them. The people that get them A lot of people ask for them are the ones that don't really need them the most of the time. They're just, the system is weird when it comes to this type of law. But
so my understanding, though, just with regard to the battered spouse syndrome, it's not recognized by the DSM-5.
correct.
And the fundamental idea about it is that you have an individual that's been so abused over time
Yep.
that the mere verbal argument is almost, I guess, so violent that they're justified in some sort of self-defense kind of thing.
It was a legal defense first before the mental health experts tried to categorize it as a diagnosis. So the legal defense itself was to attack the mens rea.
Right.
It was to attack the mental state that existed in the offending party at the time that they were engaged in that behavior. It's essentially what's the not the
diminished
rage killing,
capacity?
the
Is that
diminished
kind of
capacity?
the
No, it's not that approach. The heat of passion, where you are so overtaken by something that takes place in that particular moment that you no longer are present.
There's a difference between first-degree murder and second-degree murder, and that is second-degree murder is a heat of passion killing, whereas a first-degree murder is a premeditated killing. And
combine that with self-defense.
The problem, though, is that she's already charged with second degree. She's not charged with the intent.
I know.
And also, there was no like it was tried a number of years ago in Michigan, and it was a woman who was, claimed abuse and stuff, and her husband was like really angry at her, and she shot and killed him in the kitchen. He wasn't physically attacking her at the moment, but she felt so scared because of past trauma and things, and that didn't work. But let's assume that is an acceptable situation. You don't see that in those cell phone videos with Sarah Boone.
That's the point that I'm making. So the battered spouse syndrome defense is a hybrid of the self-defense, criminal defense, and so the self-defense of justification, and then the crime of passion attacking the mens rea. They were not intentional in that moment. They lacked the capacity to form the requisite intent. And then it's also just whatever intent they did have prior to that act was to defend themselves, even if it was by a proactive action. Whether you believe that or not, what I will say is that's where a lot of this diagnosis stems from, is the recognition in the law that certain traumas can exist beyond that. Now, like I said, whether or not you buy that, in general application, the Sarah Boone evidence that we have thus far, that cell phone video is 2 minutes of her sitting on a couch, lecturing him moaning inside of a suitcase to please let him out. And she is, I don't know how else to describe it, like just taunting him the whole time.
It's a horrific
drunkenly
terror. If it's a horrific video, I pulled the jury instructions on Florida's second-degree murder statute, and I think it would be helpful to hear exactly what it is. Okay, and it's under the statute number is 782.04 sub 2, and obviously all murders has the element of a victim is dead as the actus reus. You have the death was caused by the criminal act of defendant. All right, well that's good. But number 3, now listen to this carefully. There was an unlawful killing of victim by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. That sounds like it fits it to the T. And I'm proud of Orlando for not overcharging this like they did in some other cases that were very high media. That sounds to me to be the appropriate charge. It's not overcharged. And that sounds like an imminent dangerous to another, demonstrating depraved mind without regard for human life.
Yep.
She's going to rely on the first, we'll say, minute and a half of that 2-minute video. But listen to the last 30 seconds.
Oh.
And she's shh.
Yeah, no, thank you.
Well, it's a horror show. And I mean, I don't think this is another one that's one of those guilty all the way, no defense. And one of the reasons she's going through, actually, you've got a couple super chats, rumble rants, whatever. I see that they kind of go to this question. And that is that I really feel like she's going through lawyers because the lawyers say, okay, what's your defense? and she has no defense. She's ranting incoherently and self-centeredly. And so she says, why don't you call me? I'll meet you. You send me a letter when you have something you can answer. In the meantime, I would suggest you plea, because your actions fit second-degree murder to the T. We need to focus on mitigation. We need to focus on other stuff. But she's a hardhead, and she's like, well, what kind of lawyer are you? Why don't you wave your magic wand? And they're like, okay, I'll see you.
It's the magic wand lawyer. They want you to take what they view in their head as the defense.
Yeah, why don't you file a motion to squash?
And match it to the law.
And then you're like, well, why?
Yeah.
What should I squash? What is my limiting? What am I limiting? What is exactly you want me to do that's legal, that's even has any chance at all? There is none. I mean, and I think this is one of those cases. But she's demanding, well, what am I paying you for, even though she's appointed, right? It's like, so they just like, well, to hell with you. I'm not representing you.
Now, the contact stuff, like she has developed a reputation. I think that once that lawyer makes the first contact, second contact, third contact, that lawyer creates barriers between himself or herself and Ms. Boone. Now, is that the right call? I don't know. I would like to think that I would have
practice.
I would like to think that I would be able to continue to meet with that client. I'd like to think that I would be able to do that, but I have not had a Sarah Boone.
I understand, but you're a private lawyer. These are court-appointed lawyers. All right.
Yes.
So they're paid for by the jury, not public defenders. These are people that are private lawyers who are taking it on for a smidgen of money because they're on a list and because they really want to help people. And they come and they encounter this woman. She doesn't listen to them. He's making a minuscule amount of money. And I had a great lawyer who trained me. I did civil law for 6 years. I did civil litigation. And his advice to me was, you make more money by the clients that you turn down than the ones you accept.
You do.
Okay.
Did you watch Schabusiness at all, Rob?
I did.
The defense attorney was completely disconnected from his client.
His heart wasn't in it. Yeah.
His heart wasn't in it. And I tried to explain that earlier today. And I think you might have been streaming, but I tried to explain it earlier today that I felt for him like deeply, because you saw he's going through every motion. He's doing everything. He's asking questions, even though he doesn't have a question. He's doing everything he can, just walking through the steps. But none of him believed what he was saying, and it came across.
He didn't believe what he was saying.
No. I gave him a C- on Gosney asked me and I say it because for me, in my mind, a D is failing, even though I know a D is not failing.
Well, Vices gave him a C-.
I gave him a C-.
Gave him a C-. MG Law gave him a C-. Nick Ricada gave him a D-, and I gave him a low C.
Nick gave him a what? A D-?
D-. Well, we had a little dust up about his abnormally low grade outside the mean, and I was poking at him. So I did that was my stream at 8:00, was grading the parties. And so
I'm gonna fail him for 1 point. Yeah. And it's the point that you guys might not think about. And I played the interview he did after the conviction. He did an interview with Chanley from Court TV.
Oh, I didn't see that.
I didn't either.
Really?
So do you remember during
an interview?
Yeah, the competency evaluation and that last hearing date on Friday before they went to trial. And he looked over and he says, I've consulted with my client and she wishes to proceed.
Malpractice.
During Chanley's interview with him, he went back and forth with Chanley, basically saying how she was engaged and that he was communicating with her, and it was about the Fifth Amendment waiver, or the Fifth Amendment acknowledgement, like the back and forth. The expression that it was knowing, that it was intelligent, it was all of these things, and he is kind of jumping onto that as well. That appellate record on the issue of competence is now shit.
I watched the Friday hearing with Vices, and sitting there, right? He's arguing that she's not competent to stand trial, right? That's his position. She can't, and one of the big things is that she can't participate in her own defense. And then at the end of that, he turns to her, talks to her. I've conferred with my client. And I said, that's malpractice. He just committed malpractice in front of the entire world.
I don't know. I don't know that I would go as far as to say malpractice. I'm not going to say that because that word carries an extra sting to it. What I will say is that his grade on that particular issue, losing that issue, that's a loss of that issue on appeal.
Well, and that's why I think it's malpractice.
Well, except that maybe the competency question wasn't as definitive. Who gave the suggestion of incompetency? It was the defense lawyer. Then there's when that generates, at least in Florida, that generates a process by which she's evaluated for competency, and then it comes back. Obviously, she went to trial, so she was found competent to proceed, and then he's proceeding on that behalf. So
yes, but there's a way. But Steve, you know damn well. Well, let me put it this way: as a trial attorney, I know damn well that even though a judge has ruled against me at every single step, what I am sitting here saying is, I am looking at my client and said, Your Honor, I've discussed with my client. I can't acknowledge whether or not she does fully understand what has been explained to her. If the court would like to have the colloquy, the court's free to do so, and the court's free to make a finding in consistent therewith. With regard to the Fifth Amendment issue on the waiver of privilege or not, what I would have done is I would have said, Your Honor, I have engaged in a colloquy with my client. I explained from my vantage point and given my knowledge of what this means to her and to her case. I have explained that, and while I don't fully know whether she has comprehended it or not, I understand the court has ruled that she is capable of standing trial. If the court wishes to engage in a similar colloquy to advise her of her right, I am happy to try and illustrate that to the extent that I can. But if the court it's the court's prerogative to make this finding. That's what you do.
I'm saying you guys are assuming a lot, and I think what you're assuming is that she's actually incompetent. I think it may have been a pro forma motion for him to test. He knows. I mean, I've dealt with a lot. We'd have a lot of incompetent clients, right?
I'm not assuming.
Well, but you're saying that that's an appellate issue.
I agree. I'm going to have to agree with Rob here, because what you want the court to do the heavy lifting, because your position is that she's incompetent. That's the position that you're putting forth out there. And
you lost. Yes, and you lost
and
that
you
issue.
lost.
You did.
But it's like when you say, thank you, Judge, but I'm going to reserve my objection still, and keep moving forward. If the court decides that she is competent, and then like Rob said, when you do the Fifth Amendment thing, if your position is still that she's not competent because you're not giving that up for the purposes of appeal, you have to have the court make the record, not you.
Yes, if that's an issue that the trial lawyer believes in, but I don't think this trial lawyer believed that issue, and so he was willing to waive it.
He didn't. He was willing to waive it, but that's what I'm saying.
But what if that's true? What if the fact is that he felt that she was competent, she was assisting with the defense?
Well,
should he lie to the court and say she's not competent when he feels that she is?
No, I'm not saying that, but there was enough evidence that you gathered. That was your position. That is your client's position. That is the best position on behalf of your client that you can articulate and advocate for the court. The court ruled against you. That doesn't mean that you were wrong, whether you personally believe it or not. Steve, my personal belief as to what my client told me, true or false, if I don't have actual knowledge that what my client has told me is false, I have to disregard everything about my intimations, what I believe is true or false. If I don't have actual knowledge,
what if you do a suggestive incompetency and the competency report says that she's competent?
So what? That's one piece of evidence that's contrary to mine.
But Steve, let me ask you this: as an appellate attorney, right? Yeah. You're going to appeal based on the competency alone, right? You're going to appeal. Let's just assume that you file the appeal. The court's going to see the transcript where you conferred with your client on Friday, where you conferred with your client regarding her Fifth Amendment. You expressed that you conferred with her on the record. Is the Court of Appeals going to say you abandoned that claim?
Nope. You missed one. It goes one further. You acknowledged that in the discussion with your client understood the discussion that you had. They understood their right. That's what he did on the record.
Yeah,
that's my point.
I don't see that as a problem like you guys are seeing it. I'm seeing it as he's operating as I just don't see that issue. I mean, it's like he's he is acknowledging that she's competent, but I mean, but it's like if he feels that she's competent, that he acts on that behalf. If like, and I'll play the corollary, because we have a case. In fact, I had talked about it today with one of our lead attorneys, who we have a genuine competency issue with a client. And if that is our issue, if you feel we're going to drive that all the way home, like just like what you're saying, but if it's not an issue, then we don't make things up to create appellate records on issues that don't exist. I mean,
all I'm saying is you just preserve the ability.
Preserve it.
Yeah, you preserve it. And my point was
go ahead.
My point was that would, in that circumstance, do you believe the Court of Appeals would come back and say you didn't preserve that because you expressed that?
Yeah, it could be. Yes, it could be. I think that is evidence to support the finding of the trial judge, which the appellate court would affirm. When the trial judge says, I have observed your demeanor, I've observed you consulting with your attorney, and that is a basis for me to rule that you are competent. That is correct. I agree with that. I'm just saying that you don't make bad faith arguments as a defense lawyer.
But that's not a bad faith argument. Just because a judge says that you were wrong, that does not make it a bad faith.
If you have to make an independent legal assessment of your client's competency. If you feel that she is competent going forward, that's different from insanity. Competency is different from insanity.
But no? Steve, here's the thing. Until and maybe this is the trial attorney in me, because I have.
Well, I'm actually a trial attorney. I do appeals, but
you do appeal work. But you can't tell me that as a trial attorney, it has not been driven into your head that it's not just about making the objection; it's about preserving it. Because you miss that preservation.
There's something to be preserved.
I will wait. I will push that issue until a court tells me, Mr. Morton, move on. When a court directs me, Mr. Morton, move on, or Mr. Morton, we've resolved that issue.
Well, okay. Well, let's see. And I don't know this law in this jurisdiction, which is Wisconsin. Natalie's, and maybe she can enlighten me. But we will find a suggestion of incompetency on suggestion of incompetency, and we will make the doctors go back and back and back when we as the public defender's office feel that we have a client who's not competent. I mean, we'll do that over and over again every time that we say this client's not helping, this client's not. And the state's trick is to sneak them under the radar so that they got a competency eval, they're competent, and they get them to trial and they force them into prison, and then they're incompetent the rest of their life. So we deal with this all the time. But the question is we don't raise this on issues that we don't genuinely feel that they're incompetency issues. So I think in this type of case, it's a major first-degree murder case. You're going to want to have her assessed for competency. But when the doctor comes back, she's competent and she's helping you with your defense, you don't have an issue.
Be mindful that he had a doctor that, yes, the judge found that she wasn't credible, but he did have a doctor that supported the contention of his client that she was not fit to stand trial. He did have a doctor. That was the doctor that testified in the NGI proceeding. And that's what I'm saying. If you have that doctor there, that doctor is presented as willing and has testified. And it was until the judge basically said, I don't believe her, I preserve that issue going forward. And maybe that's just
feel there's a real issue there. If you feel there's a real issue, if you don't feel, which I think this lawyer, she was helping him, she was competent in his eyes. He went through the motions to test her competency because he's required to. Once the doctor came back and she's helping him with the defense, it's not an issue for him because it's not real. So preserving something that's not real is a pointless endeavor. I get it. If it's a real issue, she really is incompetent, she's really not helping him, he should have been filing motions he should have been suggestion of incompetency at one after the other until that's not resolved. Because look, she's not helping me, and she would have made a big storm about that in court. We do this all the time in the public defender's office because we have clients that they want to put in prison for long periods of time that can't help us, that are actually incompetent. But she looked to me to be very competent the whole trial. And I don't think that lawyer recognized that as being any kind of issue that he needed to ride into the sunset with, because he would have been wrong.
Stages. It was two stages. Okay, there was the first stage Friday, the second stage is the second one. No, this is the thing. We can agree. We can reach this conclusion. We can both argue it to the point, and we can both basically say, I stand by my position. Steve stands by his position. I don't view him any lesser than I did before.
Maybe
and that's the great thing about attorneys, by the way. So I have so many attorneys, and this is a weird thing because I'll show up in court with my client, and I have friends that might be opposing counsel, or or at least colleagues that I'm friendly with that are opposing counsel. And I always feel odd about being sort of nicey nice with opposing counsel in front of my client, because they're like, oh, you want an attack dog, that sort of thing. But you can go in there, you can argue your point, and then your friends again, you go, grab a beer or go golfing, whatever. And so that's the beautiful thing about attorneys. We can rise above.
Well, wait, that's all we do is we argue and disagree, and we got to go on to the next issue.
We all have
That's how we
opinions,
do.
right?
Well, and there is
great
a
transition. Next issue.
What's that?
Sarah Boone. So Sarah Boone's October 2nd. No way in hell it's going to happen. Let's talk about Sam Bankman-Fried, our favorite fraudulent criminal.
There's a cat on that unicorn.
It's not riding a unicorn. We can embrace this without understanding it. It's how the life works. So, Mr. Samuel Bankman-Fried, how many of you are familiar with Mr. Bankman-Fried and the criminal charges that he faces in the federal court in the Southern District of New York?
Well, one less today, right?
Well, one less earlier, but that's really not where I want to start the discussion. Oddly enough, the place where I want to start the discussion is about, well, Mr. Bankman-Fried and his behavior. Because Mr. Bankman-Fried likes to talk to the press, and he has for quite a while. Despite the government's intentions and best desires to get him to stop. So July 20th, the federal government, the DOJ, and the prosecuting attorney writes a letter to Judge Kaplan. Dear Judge Kaplan, the government writes regarding the defendant's recent extrajudicial statements and attempt to interfere with a fair trial by an impartial jury. Specifically, the defendant has sought to publicly discredit a government witness by sharing her personal writings with a reporter so that these private documents would be featured in a New York Times article published today. As such efforts to have potential to taint the jury pool and could have a chilling effect on witnesses, the government respectfully requests an order that limits extrajudicial statements by parties and witnesses likely to interfere with the trial. So here's the background. Carolyn Ellison, who was a organizer, operator of this grand FTX enterprise, FTX Alameda, all the different companies that existed. Carolyn Ellison flipped. She went state's evidence. And this is very, very common in criminal cases where the first one to basically make the deal, all the other deals are off the table, right? So the feds knew who they wanted. They wanted Sam Bankman-Fried. And you make a deal. Carolyn Ellison did. She is going to be one of the chief. She's going to witness in the case. She was on the inside of all of it. So the New York Times writes an article on July 20th titled "Inside the Private Writings of Caroline Ellison, Star Witness in the FTX Case." The article quoted documents that offer new insights into Miss Ellison's psychology during the final months of FTX and described the writings as personal and raw. As described in the articles and the writings, among other things, Ellison describes feeling overwhelmed by her job at Alameda, the pain associated with her romantic breakup with the defendant, and her professional insecurities. The article does not indicate who provided the documents to the article's authors. Well, I'll give you three guesses. Yes, Caroline Ellison is the ex-girlfriend of Sam Bankman-Fried. Now, feds were really, really pissed. The defense.
I was muted. Sorry, I was going to say, I always find it odd that these guys that go down or gals that go down, there always seems to be dating their, right-hand guy or right-hand gal.
Always.
It's always. It's bad business move. Don't do it.
So what we learn is that it wasn't just private writings. There was essentially Google documents that he had access to that she had written. We don't know whether they were that he had less than savory access to, as in came across them by means he shouldn't have. But we do know that they didn't show up on any of the government subpoenas for Google when they turned them over. So he leaks a bunch of internal communications, and the defense comes back and says, on behalf of our client, we write in response to the government's letter filed Thursday evening in regard to Mr. Bankman-Fried's communication with a reporter for the New York Times and seeking an order prohibiting certain this is a night, man. Extrajudicial statements by parties and witnesses. The government has taken a set of circumstances where nothing improper or impermissible occurred and has unfairly recast the events as a nefarious attempt by Mr. Bankman-Fried to discredit Caroline Ellison and, quote, taint the jury pool. Okay. But Mr. Bankman-Fried did nothing wrong. A reporter contacted Mr. Bankman-Fried and asked if he wanted to respond to an article about Ms. Ellison that had been in the process for months, for which the reporter already had other sources and which was about to be published. Mr. Bankman-Fried spoke to the reporter and shared certain documents that he had obtained prior to his arrest and that were not produced in discovery, in an effort to give his side of the story about topics that have already been reported in the media. Okay. All right. We're okay with that. We like the First Amendment. We want people to be able to communicate and talk. I do see some flaws because he was supposed to have a contact log that showed every person he had contact with as part of his bail conditions. I don't know if this person was listed. I don't think this person was listed. And he was supposed to have very prohibited access to a computer. He has training wheels on his computer, Steve. Training wheels. He is allowed to access, I think, 3 applications and like 10 websites. That's it. Because he kept on trying to get information. And
Well, as long
After
as one of
indictment.
them's law and lumber, then it's okay.
no. Well, Mr. Bankman-Fried, if you want to have a chat with me, I would very much entertain the dialogue. I promise I have no well, I've read too much. I have a position. I've read too much. You can persuade me otherwise, but it's going to take a little bit of effort. So it has not been hyperbole to say that there's been a deluge of media coverage for Mr. Bankman-Fried's case in the last several months, including more than 1 million news articles, YouTube videos. Hey guys, look at us. And podcasts about FTX and Alameda Research since November of 2022 when they filed bankruptcy. Among them have been over 33,000 news stories mentioning Ms. Ellison and over 150,000 stories mentioning our client. Well, they discussed the articles and everything else there. The problem is that it wasn't just a few things that he shared. Apparently, he gave over, I think, a couple thousand documents, and he sent out tons and tons, literal tons of information to all these different media outlets, to the point where during, if I can't.
Is there a gag order?
I'm pulling that up. Rather, I'm pulling up the last time he got in trouble. Because this is not his first rodeo. By
the way, I don't like gag orders. Constitutionally, I don't like.
Yeah,
Oh, no.
I agree with that.
I don't either. What's interesting, though, is the means by which he is communicating with a lot of these people while he is on. So he's been granted bail in this case. The bail terms that he has been afforded are, and we're well past 2 hours. I shit you not, they're fucking ridiculous. They're ridiculous for the crimes with which he is charged.
Is the gag order contained in the bond conditions? Or is it like a separate
There was another one. The judge had previously warned him. I'm trying to find it. Bankman-Fried. There's the indictment. Because we already have so many of these things. So this is the third.
Have you been following this case from the beginning? Because I've only just recently started looking into it when I heard about the whole Bahamas treaty thing and the release of the one claim, the dismissal of it, which I feel like was more of a move to hide and keep discovery limited than anything. But I don't know
which one. Explain that one more time.
The dismissal of the it was the securities charge the other day because they're going to honor the treaty with the Bahamas or something. I don't even know what the nature of it is.
This was the weakest argument they had. Honestly, it was a stretch given the Supreme Court's position. What was the one the Supreme Court case came out with on control of the finances as being the instrument of the fraud? And if all you had was demonstrating control, that wasn't enough. It was this term. But this was
what I
their
read
weakest
was that wasn't
argument
the reason why it was being dismissed. It was being dismissed because of
because they were recognizing a treaty with the Bahamas.
Yeah, but I don't understand that. And I'm wondering if that was just sort of a, let's say why we're doing it.
So here's the thing. The judge had already bifurcated it
Okay.
So the judge had bifurcated it. The judge heard the arguments on determining, because they filed the superseding indictment that added the 2 additional charges, right? And defense counsel files a motion to dismiss the superseding indictment saying, you added new facts, you did all this other stuff, we want it thrown out. The prosecution goes forward and the prosecution says, Judge, if we want to talk about these other charges, let's talk about them a different day. They have nothing to do with the underlying the initial charges. And the judge says, fine, we'll bifurcate. So judge already bifurcated it, and this was going to be a separate trial in and of itself. As a prosecuting attorney, understanding that you have discretion in what you want to pursue, the judge has already bifurcated it. That's 2 separate trials. You've got everything you need in this one trial. This is the one you want. It's extra use of resources. Does it make sense? I can see that judgment call being fine. I don't have a problem with the dismissal of the campaign finance. Now, everyone's up in arms about this. The campaign finance, I'm getting sidetracked. Hang on. Campaign finance charges. Everyone's up in arms. They're all saying campaign finance is dismissed. What were we going to find out? What were we going to find out?
Yeah, that's what I heard. Like, that would have been a treasure trove of discovery kind of thing.
The bankruptcy case. We already get it in that. There's adversarial proceedings left, right, and center. We have more information in the bankruptcy case than you could ever imagine. Plus the debtors who have access to all internal communications, financials, and correspondence between FTX, including all of the members and the board members and all third parties. They have all of that. So in large part, they're just waiting for the criminal matters to wrap up before that proceeds to try and claw back all that money that was given to the various donees, people that received them. So it's pretty fascinating. So Bankman-Fried, the judge, this has been the second instance where he kind of skirted it. The last time where he skirted it was not a blanket do not talk to anybody, but he had accessed a VPN after he had been released on bail. He accessed a VPN, and his explanation was he just needed to watch the Super Bowl. He wanted to watch Rihanna dance. So the Super Bowl was the basis for the VPN, and the government finds out that he has this access and is out communicating with testifying witnesses. They get pissed off. They don't want him communicating directly because he was communicating via Slack and Signal with auto deleting functions in their text messages. So government says, nope, not with our witnesses, please. So they bring him in front of the judge. Judge says, nope, we're going to put training wheels on your cell phone. Your cell phone cannot access the internet. It can only call. There's only a landline in the house. There's no smart TVs in the house. There's no computers in the house except for one computer that he can access his law firm stuff, New York Times, and other stuff.
What's he trying to communicate? Like, what's he trying to do?
He's trying to throw everyone under the bus. So he's his last email correspondence to the former in-house counsel for the company was, we need to get on the same page. We all have an interest in this. We need to make sure that we are in line with what we're saying. It was literally, it was the 2 witnesses, or the person facing charges going to a witness and saying, hey, so I need to make sure that you're going to tell me, or you're going to tell them the same story I'm going to tell you. I'm going to tell them. So yeah, the government didn't like it. So the judge says, here's your training wheels, your last warning. And then with this one, he goes and leaks this information that had not been produced to the government via their subpoena. So the question is still outstanding whether Google just missed it, or whether this existed in some other Google document or Google Drive or something he has that's outside of the subpoena, or if he accessed Carolyn Ellison's Google. Then the judge enters this particular order. Where was it? Today's order was this. And yes, I know that I've got to get super chats. We'll get caught up in just a second. That was the letter from the defense. Judge issues this order. The parties in this case, their attorneys or agents, are prohibited from publicly disseminating or discussing with any public communications media anything about the case. And the judge struck out the caveat, which could interfere with the trial, because he's had an issue. He's had it up to a lot with Bankman-Fried, because Bankman-Fried plays on the caveats, including statements about the identity, testimony, or credibility of prospective witnesses. So here is the official gag order. Prior, it was, we're going to give you training wheels, don't F up. Then it was, here's the gag order. So information not deemed admissible at trial, statements intended to influence public opinion. So this is your gag order. It extends to
Wait a minute.
the
It gagged them
attorneys,
from issuing statements.
everybody.
Wait. What did you say about public opinion? To
So-
sway public opinion?
Yep. It is
That's
basically
the reason why I hate gag orders to begin with, because I believe
correct.
that is absolutely a violation of his First Amendment rights. Now, I can understand not communicating with witnesses that might taint their statements and things like that. Fine. But communicating to the public at large, that's a problem.
The alternative is that he can agree to pretrial detention.
Okay.
The judge is giving
He
him.
gets to talk from the jail cell. You're good. Okay. Well, first of all, I believe that this is a federal case, right? Yeah, so it's a federal case.
Yes.
So what's the standards? I don't do a lot of federal criminal stuff. I haven't done it in like forever. But what is the standard for bond conditions in a federal case? Can they revoke it just
Yes.
because?
The judge basically, from what I have gathered, the judge can find good cause to revoke the bond. Like you have engaged in behavior that means that we can reevaluate bond and bail.
By exercising his First Amendment rights.
He did more than that, because there's a lot of question as to whether he was exercising his First Amendment rights or he was leaking private confidential information of Carolyn Ellison that he didn't have the right to have access to.
Private and confidential how?
As in, it was from a Google Drive, and there's a question as to who owns the Google Drive or who owns the documents.
Okay.
It's essentially Caroline Ellison's diary that she kept on Google
So he's
Drive.
essentially. How would you put your drive or your diary in a Google Drive to begin
Don't
with?
look at me, man. Why are they communicating via Slack and giving themselves thumbs up emojis to approve billion-dollar trades? I am not this generation of folk. This is ridiculous.
Okay, so this is a good example of where you can talk about the shenanigans that people get themselves into. It doesn't matter how much money you have. People are still going to be stupid. This could be two people working at a McDonald's talking about the meth deal that's going down.
Uh-huh.
It's the same dynamics. People are people are people.
Yep.
What fools these people are.
Yeah. So, like, the judge is like, here are your training wheels, and then you arguably go and access things that you don't own or have right to and release them to the New York Times, among other media publications, in thousands of document dumps. And the judge is like, dude, I gave you an inch. Like, I gave you an inch. What are you gonna do? Like,
yeah,
I
and
can't
federal
trust you.
judges aren't afraid to just slap somebody upside the head
No.
with whatever they want to do.
No, they're the king of their domain, and they don't care what you tell them. So he extend this to everyone. And then he interlineates this lovely one. This order shall remain in effect to and including what is it? The dissemination of the government's oral application to detain the defendant unless extended by the court. So basically, I am taking their oral motion to detain you under advisement to the extent that you decide to F around and find out with this particular order. That
was
oral
a power move by the judge. That's when your client gets set in the jury box and he's like, listen, you're going to sit there in custody while we finish this hearing.
Yep.
And we're going to finish this hearing and I'm going to enter this order and you're going to go, wink and nod, but just remember, I have the power to set you down in these cuffs right now.
Well, no, it's even worse. So the order remains in effect. So this is the gag order. It remains in effect to and including the determination of the government's oral application. So the government filed an oral motion to detain him. That oral motion, from what my reading of this, is being held under consideration. Like, I'm going to hold on to that motion and hold that one in my back pocket. This is my F around and find out paragraph to this order. You want to play around with the other provisions of it? That motion's open.
Yeah, I'm just thinking back to a divorce case I had post judgment where the guy had to sign over power of attorney to sell the marital home, and he just refused to. And the judge was like, "All right, we're gonna sit you down in the jury box," cuffed him, and said, "We're gonna finish out the rest of these hearings. We're gonna come back to you, sir."
Yes, exactly. Yeah, it's a power move, but it's
Yeah.
and I love that the judge interlineated himself. Like he interlineated this.
Yeah.
I've had this happening too. I think it's a
1 second.
great move for a defense lawyer. I mean, for a judge. We had a client in court once who was getting a little out, getting a little mouthy, and of course he just says, "Mr. Bailiff, would you sit this person over in this box, and we will take this matter up at the end, and I will find out if you are in contempt after we get done with everybody else in the hearing, right? The other 300 misdemeanor appellate people in the court."
Yep.
And then, of course, they went over there and they're sitting there and they're watching people, go away to jail and get off, walk away, and they're sitting through this whole boring court process, cooling their jets. And then when they come back down, of course, everything's blown over, and they don't even consider it because the person has gotten a little dose. Just they're like that far away because they've been sitting there watching people go into the jail. When they get put in cuffs, they plea, and then they go put in cuffs, and they go walk back in the jail. So it's a very good, I think, a disciplined judge who has this in their bag of tricks to keep control of their
knows
courtroom.
when to use it.
When
Like,
and not because it's I'm going to hold you in contempt and hit you with a big hammer. Sometimes the person just needs to cool their jets a little bit, and that's a good way to do it.
Yeah. So there was a judge in General District Court in Fairfax. I don't know if he's still there, but he had a practice of basically he would take the docket on criminal traffic motions or criminal traffic days, and he would explain what you need to do or not do. He would always take like third offense DUIs as like the first case on the docket. And you would hear him, he would call out verbally so that everyone in the courtroom could hear it. "We need a runner." Every attorney knows what that is. That is one of the bailiffs that is coming from the detention center that is walking through the hallways in the back to escort someone who's about to be taken in custody right there. And he would proceed with that case first. And it was always the third offense DUI guys, because they're the ones that, I don't know why, they never quite seem to get it until that particular moment.
Well,
but
they
he would
are
do
third
that
offense
first.
DUI.
They would do that first to teach a lesson to everyone else in the courtroom.
Well,
like,
on
this
the other,
seriously.
I will follow that up by saying, I don't know if you've ever been to arraignments, or I mean, at first appearances. We have to cover first appearances as drudge duty, right? And it's like 150 people arrested Daytona Bike Week on a Saturday, so it's like hours and hours of first appearances, and what'll happen is you get. They come through. It's a cattle call. It's just cattle call. It's one after the other, and there's very little legal process that goes on. It's basically a bond setting hearing, and then one person will get a bond, will get an ROR, because and then everybody behind him has exactly the same excuse, and they all say like, "Well, I have the same thing that guy that got the ROR," and it's like, well, because they hear it, it's almost like just back off. We know. And it's always, everybody always, I have a job starting Monday. And if I don't get out, I've been out of job for 10 years, but I just happen to be hired. And if I don't get a job on Monday and I don't get there, I'll get fired. And it's going to be your fault, Judge. Right. So it's all, these are all like, you see this stuff over and over, and judges see it over time. And I think it's good to develop alternative skills for controlling your courtroom other than just the big hammer, right?
Oh yeah. Yeah, absolutely. It's a skill that a lot of district court judges don't often employ. Usually they like the big hammer. And I appreciate when they use clever mechanisms instead of that.
Yeah, but a lot of district court judges too get that, was it black robe fever? And
federal judge. Could you imagine being a federal judge?
Don't get me started like that. Like I 1000% agree with you.
But what I like are the ones that don't have it, that are cool, and they're sometimes the scary ones because they're like just you
That
just
don't
go
have the
sit over
what?
there. That don't
Black robe
have that.
fever.
They don't have that black coat or the black robe fever where they're not king of their castle. They're subtle about it, and sometimes they're the scarier ones because you don't know when you kind of push them too far, because you get that judge that's, you know, like you're trembling just to go in front of them, even as a practicing attorney. You at least anticipate it, right?
Yeah, right. When the nice judge gets hostile. Well, I had a great judge named Judge Attic. Sharon Attic was her judge. It was my first judge that's in front of him, county court in Flagler County, and she did misdemeanors. And I remember we had this one guy come in. I was prosecuting at the time, and he was drunk as a skunk. You could smell him as he went by. And he's like, he gets up there and he says, Sharon, he's calling the judge Sharon. He says, Sharon, we know each other. I've seen you a lot. I've been in court a lot. We get to know each other. So, I'm just like, we're starting to we have a rapport. I'm sensing we got something going, right? And Judge Attic was one of the nicest judges, and she was never held anybody in contempt. And I'll tell you, it was a wake-up call. She'd lean over a bunch. She says, "You're about this close to going to jail right now. It's Judge Attic to you." That was so yeah. So it was very unusual to see somebody who's generally nice and very kind, but it's not a good system if you're a criminal to say, "I know you by first name, Judge. I've been in front of you so much." Right? That's not a winning argument.
No, generally that one loses. I do want to catch up on 2 super chats, but I also just pulled a motion that was filed by the government at the end of today, like that literally was just filed this evening in that case, that expounds upon their request for an order of detention. So I'd like to take a look at that if you guys are willing.
Yeah.
Yeah, let's do super chats. You've got a lot of good.
There's a couple. Yep, and there's some that I have to catch up at the very end after I let you guys go because they take a little while. Katie Cotton, thank you so much for the super chat. My dad passed away on Wednesday. It's now with my mom. He gave me the silly nickname, Katie Cotton. That's not a silly nickname. That's a fantastic nickname. And I also see that your profile picture is a picture of you and Emily. That's fantastic. He was a litigator, and FNF is just like being with him when my father was arguing with his friends. Thank you. Tonight is very therapeutic. Well, Katie, that means a hell of a lot. So cheers to your father. And hopefully he has some very good litigating buddies up in heaven and is, causing some chaos around a table. So cheers.
I need to get
You get to get a sidecar, Steve.
He's gonna get a cocktail. We can't do too many cheers because Steve doesn't do a whole lot of the cheers things.
Did you see his pass out on the keyboard?
No.
Did you see that? Steve was on with Vices. They were doing a stream. It was like a Friday night stream, and they were doing some fundraising for his new book. Steve? Oh, okay. He's got water. Thank God. No passing out on the keyboard.
Oh, no. Come on. Cheers.
Cheers, my friend.
Cheers
to your father, Katie Cotton.
That was unusual, but Vices did me right on that. He got my children's book fully funded. And
yeah, no, it was well deserved.
Well deserved. So I said, I owe you. And stinking Vices, that guy's got a liver of iron. And I was telling him, I was like, you tell me when I can drink, just like, because I was thinking that $100 super chats was his thing. And he's like, next dollar super chat. Like, you're not putting much of a limitation on this.
You can't go toe to toe with Vices. I have finished this FNF stream. I don't know if you guys ever saw that one where I did the defense of Jason Statham.
No.
Don't ever try to find it. It's a disaster. It was trying to get him to land the plane after he had been going for like 20 hours straight. It was 4 a.m. my time. And I had been on a stream since like 8 p.m. So I was dead. And we started talking about old litigators of old and how they just don't make litigators the same way anymore. Where you used to have the charisma and the character and the people that would argue to the death every point, but they were so eloquent in the way they did it. Like the jury was captivated. Well, that led to me defending legal vices as if he were Jason Statham, because they are both bald-hatted men. It was
All right.
oh,
All right.
it was
Well,
That
you're
was
right. Don't ever go toe to
disaster.
toe with vices. That would be my first bit of advice. That guy,
Yeah.
I'm a lightweight,
he is not, and I can hold my own, but no,
I feel like
Jeff
feel
does
like-
damage.
Yeah, I feel like now. Remember that you ever see the episode of Seinfeld where George has got the cool friend? See, I'm going to be like, yeah, tell me more, Rob.
It's when the hair goes like really wonky that so we can unleash the hair. The hair is we'll just do that because it feels better. Okay, so here is the letter that was filed this afternoon. Dear Judge Kaplan, the government writes in further support of its motion for the defendant's bail to be revoked and for the court to enter an order of detention. The defendant's attempts to tamper with witnesses and interfere with the government's and public's right to a fair trial in the due administration of justice and his pattern of circumventing his bail conditions in that pursuit demonstrate that no set of pretrial release conditions can adequately assure the safety of the community, and the defendant is unlikely to fully abide by any conditions of release. Basically, you messed around too much. Factual background. We got the bond. Then he tries to access the VPN, encrypts communications, communicates with potential witnesses via self-deleting app. This is the email he wrote. I would really love to reconnect and see if there's a way for us to have a constructive relationship, use each other as resources when possible, or at least vet things with each other. Both parties acknowledged that communication occurred. That was with a potential key witness to the government's case. Then Signal becomes a constant back and forth here because every communication he has is set to auto-delete. So they basically say, no, you're not allowed to use that anymore. So the court enters an interim order that limited the defendant's contact with the former FTX and Alameda employees. Don't talk to our potential witnesses, and please don't use self-deleting message applications. At a subsequent bail conference, the court pressed the parties on whether these modifications were adequate and whether the government was focused too narrowly on the ephemeral messaging applications, when witness tampering could be achieved by other methods. Well, the judge has apparently warned the prosecution that maybe you'd like me to issue a stronger admonition here. So, quote from the transcript, I'm far less interested in the defendant's convenience, given the record here and his preferences, than I am in avoiding what the government's proffer indicates to me is a very real risk of misuse. Well, government, you didn't push hard enough. Shortly after this conference, the government learned the defendant had used a VPN on January 29th and February 12th. Well, now we're watching the Super Bowl. As set out in the government's letter, the defendant's use of the VPN prevented any third party, including the government or pretrial services, which are tasked with monitoring his internet activity per his bail conditions, from obtaining evidence of what websites the defendant had used and what data the defendant sent and received online. Bear in mind, one of the allegations is that he tried to access FTX after the bankruptcy filing to try and transfer funds, and that he tried to, or he actually did advise the Bahamian government on how to backdoor into the FTX wallets and transfer, I think, $86 million to the Bahamians to hang on to. So he has the keys to all of the backdoor systems, and the allegation is he used them. The defense asserted the defendant was used a VPN to watch football. But given the nature of VPN, this assertion was unverifiable, albeit still concerning.
Those two things don't really go together, do they? He transferred wrongfully $89 million, and he watched football.
Yeah, As the court noted, the football games the defendant putatively watched using the VPN were otherwise freely available to everyone, i.e., the effing Super Bowl.
So who gives a wink? I mean, why would you put that? I gotta say that I would not cloud my motion with that type of trivia. Would you? If I were to government?
Well, yeah, I don't know. The judge knows damn well. Then the court goes, so what he was doing was sitting in California in the United States using the VPN to create the impression he was going to use this international subscription from somewhere outside the United States and getting the service from the provider of the programming by using the VPN to deceive as to the location. This was his argument, that he signed up for NFL Game Pass while he was in the Bahamas, that he needed to use his VPN so he could access his NFL Game Pass so he could watch the Super Bowl from his Bahamian account.
It doesn't make any sense.
While
I
under
mean, who
supervision.
cares? You know, tampering with witnesses, transferring illicit funds, those are things that I care about as a citizen of the United States. But watching the Super Bowl,
The argument is, but Steve, the argument is that he was using a VPN at the time. That's what he said he was doing. The VPN use extended for several dates where we're not sure what the hell he was doing because the VPN, by nature of the VPN, we won't ever know.
Oh, I see. Okay. See, you got to catch up. Sometimes I'm slow on these federal cases. You're following. You're into this. You know this stuff, don't you?
I've followed this case from the bankruptcy filing. Like this is. As a result, the government proposed a tighter set of bail restrictions, with the court questioned as nonetheless putting an awful lot of trust in the defendant. The judge has been lecturing you, prosecutors, like he's telling you, come on. We're dealing with somebody who, on the basis of your proffer anyway, has done things that suggest to me that they may very well be probable cause to believe that he either committed or attempt to commit a federal felony while on release, namely witness tampering or attempting witness tampering. Why am I being asked to turn him loose in this garden of electronic devices?
I see. Excellent. All right. So that makes more sense. See there, you got to catch up the slowpokes here.
Yep. The government responded in part that it was attuned to finding a solution that is narrowly tailored under Bail Reform Act. Well, apparently you're not very attuned, you idiots, because he literally goes and leaks information in the New York Times under your nose. Oh. So then this is the laptop with the, there we go. Limited access to phone and internet, laptop that has the training wheels, etc. Then we've got the publication inside the private writings of Carolyn Ellison. Article doesn't identify. On the day the article was published, the government moved for an order prohibiting prejudicial extrajudicial statements by the parties or their attorneys. Scheduling conference, instructed the parties to come prepared to address the adequacy of defendant's bail conditions. So the judge has basically said, when they wrote this letter, the judge says, no, bring him back. I want to talk about bail. Defendant submits a letter asserting he had done nothing wrong by responding to the New York Times request for comment amidst the toxic media environment, yet agreeing to an order governing the statements and arguing that the bail conditions otherwise required modification. Prior to the conference, the government analyzed data from a pen register on the defendant's phone and email and learned that over the last several months, the defendant had sent over 100 emails to members of the media, had over 1,000 phone calls with members of the media, and had over 100 phone calls with one of the authors of the articles, many of them lasting approximately 20 minutes. But feds, why didn't you access the pen register earlier? So many of the communications occurred prior to the publication of the articles about Ellison, including by the same author. Oh, God. So government moves for his detention, supported the argument that he did nothing wrong. Defense counsel asserted these were documents not part of discovery. I think it's 1 page, maybe 2 pages, and he didn't give them to the reporter. He let the reporter look at them. So these are now assertions on the record by the defense counsel.
Do you think
maybe
this
2
motion
pages.
is going to get granted based
I
off
don't
of everything
know.
I've seen?
I don't know. This judge, based on this motion, I have heard and I've watched reports out of this courtroom that the judge is pissed. This motion is supporting that assertion, and the quotes are supporting that assertion, where I was kind of viewing it skeptically. Like, yeah, they say the judge is pissed, but how pissed?
Where's this court at?
Southern District, New York.
Okay, of course it is.
I know, and they love being kings of their castle.
Mhm.
Like of all the district courts to be in, I don't want to be there. I don't want to be in EDVA, which is where I am. That's just me. It sucks. No, judges are great.
Judges are wonderful. They don't do anything
They are
wrong.
fantastic. Absolutely. Defense counsel further claimed, again, I love these quotes, just someone who's trying his best to protect his reputation, believing that he can. It was therefore undisputed that defense communication with the media were intended to affect the public. Oh, that's kind of a shady argument, prosecution. That's a crappy argument. Like,
Protect the public.
you protect the public. So you just come on. He can talk to the public.
Yeah, absolutely he can. That's the part I don't like. Again,
Yeah,
influencing witnesses, telling them what to do, fine. All right. We can't allow that
Well,
to some extent, but
why make
influencing
the
the public?
argument here? The judge has said, I will tighten bail restrictions. I will tighten bail restrictions. Am I being too loose in bail restrictions? And now you're making the argument here that he can't be allowed to talk to the public. Dude, it's just a little bit late.
Now, having not followed this case, like, can I ask a dumb question?
Yeah.
Is this FTX deal? Is this a like a pyramid scheme, as in Enron, or is it simply mismanagement?
It's
so much bigger.
It was cryptocurrency, right?
Cryptocurrency, but was there a real business here, or was it designed to fail from the beginning?
They took out several loans that were basically no paper backing them up. The defendant's father received $10 million. That was a loan taken out from Alameda with no paper backing it up. $170 million loaned to Sam Bankman-Fried to purchase other things, including real estate. Essentially, it was a lot of really, I'm not going to say it was Ponzi, because Ponzi has a very specific definition.
Right. Well,
it was money laundering. It was laundering. It was 100% laundering.
Interesting, because I would think that there would be real problems with control on cryptocurrencies. And it seems like that's a very speculative type fund.
Yeah. What is the actual charge? Is it fraud, or is it
fraud? Various types of fraud, money laundering, wire. And you know where the feds like to do it, the wire transactions, wire fraud.
How much money are we talking about in this?
Hundreds of millions of dollars, billions of dollars.
Billions, really that high?
Yes.
You can put as many zeros behind it as you want, I guess, to make it interesting. At the end of the day, he's essentially lying to investors and getting loans without paperback, without any documents supporting it, and not paying them back.
Oh, I forgot the eugenics part.
Oh,
yeah,
eugenics.
Because they were talking about how, because this is one of these ESG, this is effective altruism. So one of his big business models was taking money and giving it out to pet projects and people that he agreed with and liked. And wouldn't the world be great if we're all of a sudden in a place where no one, where everyone who disagrees with us is no longer there? And yeah. And then the money to Tom Brady and all of these different athletes who are being sued left, right, and center. Tom Brady,
but that type of irresponsible money being thrown around by leaders, that sounds to me like a Ponzi type scheme, because that's typical of a Ponzi leader. I've
similar.
Yeah, because they feel that it's their own personal slush fund rather than trustees of a of a corporate entity, of an actual investment. And especially when you're talking cryptocurrencies, which are rather new and speculative, and that was somebody to come splashing in, it's like the sexy thing, right?
And he was playing on that too. He was basically manipulating markets. So he was manipulating markets, driving up the value or the implied value of his coin and of his company. Basically created this fictitious valuation of a company that he backed with a lot of financial disclosures and documents that were just bullshit.
And then
bullshit
what you're
upon
talking
bullshit
about,
upon
like
bullshit.
Celebrities getting money and hanging out with those people, that's another typical
and advertising on behalf of them. The Super Bowl was sponsored by FTX.
Oh my gosh. So that's a lot of money.
Well, that's why you wanted to watch it.
The Miami Heat arena, the Miami Heat arena was named the FTX arena. They had to abandon that in the bankruptcy proceeding. This company was purchasing influence everywhere. They donated, I forget how many millions to, I think it was $80 million to campaigns on both sides, Republican and Democrat.
How political do you get on your channel?
Not very. I like to say that I hate every single politician because they're all the same.
Well, I think that let me just say that I think we have a problem in this country with corporate governance generally.
Yes.
And as and because and I'm as much of a free market capitalist as the next guy, and I believe in the free markets, but we don't have free markets when corporate management is so strangled by management that is unaccountable to anybody. And as an example, I will give you Disney, which is a corporate company that they have like halved their value in the last few years based on corporate decision making, and they re-up the guy's contract. There's no accountability, responsibility from the stockholders. This guy that's running that company into the ground.
Well, and that's not really that, and that's why I try not to even make that political, because it's not political. That's just business decision making.
The object of this company is to make money, and this guy, this CEO, is making decisions, is cutting that value of that company in half. And that's my money. That's stockholders, those are investors, retirees, trust funds. So where is the account? If you've had that kind of performance, like, look, we need to get rid of this management and get this place on track, figure out what's going on, because you guys aren't doing it. But instead it's like, no, reward him, give him more money. It's this little incestuous group at the top. And this is an example, I think, that it spreads across the corporate culture, that you don't have, our big corporations are not responsible to the people, the country, to anybody but their own little elite groups. And here's a good example. You've got this company that's just, who's watching the hen house with all these billions of dollars?
No,
I don't know. You just kind of pushed me a little hot button.
I know, that's fine. I agree with that button. David is dying. David is exhausted. He has just he's gotten 3 hours sleep in the last 22. So we're going to let David jump.
Thank you very much for having me. We need to do something together, because Danny and I have been talking about bringing you in, because we all do family law.
Of course, absolutely.
Steve, it's always good to see you.
Yes,
my
I
senior
loyal
correspondent or reporter or whatever.
Senior reporter for MLS.
Senior reporter, yes. Right. Thank you very much, everyone in the chat.
Everyone, please go check out MLS Law Show.
Yeah, MLS Law Show right there. Check it out. We got some good stuff. Take care. Good night, everybody. Have a good weekend.
Good night.
Night, bud. So let's get to the end of this one, and we'll wrap up tonight's live stream, because it's a little bit late. 4 hours and 16 minutes. Not too bad. Apparent instance, he did so not by asserting innocence, directing the reporter to information in public record, or making other fair comment, but instead by funneling Ellison's diary entries that were not public but were in defendant's possession to the New York Times, intending to portray a key cooperating to testifying witness against him in a poor and inculpatory light without attaching his name to the article as a source. Well, that part's kind of odd. Like, I'm going to hide behind anonymity, so materials, but give you private diary entries, so the public can't really adequately assess that I gave you the materials that are making you write this article that look bad for her. The court basically says on the 26th, you have the admission the defendant has a strategy here to counter what he puts forward as being extremely unfavorable public publicity about him, so that there is essentially an avowed intention to influence the perception of the defendant by the public at large, which includes prospective jurors and prospective witnesses. That's essentially admitted, as I understand the argument. Here's the problem with that. These gag orders are supposed to go both ways. The government always leaks.
Right. That's a very good point. Yes, that is a very good point.
Government always leaks.
We're bound. We deal with that a lot too, because they go in the media. We have a murder case that comes along, and we're the public defender's office. We represent the murderer, accused murderer, right? And we're ethically obligated. We're keeping our mouths shut. We're following the law. We don't talk to the press. And meanwhile, they're holding press conferences with the police officers talking about, we're glad we solved this crime. We're going to put justice, and they're out there, blah, 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 blah. It's like, well, wait a second. What's going on here? Yeah.
Yeah.
It should. Good for the goose is good for the gander. But it's like, what do you do about government leaking? Nothing. Yeah. Is anybody ever held accountable for that? No.
No, never. Government makes an argument that I expect them to make, which is honestly a lot less bold than I thought they would have. I just want to be clear, the defense is permitted to have a strategy. Well, nice of you, government, to say. And this isn't a First Amendment issue. Also nice of you to say. And having contact with the press alone is not witness tampering. It's not a violation of bail statute. Okay, fine. But here, where the strategy for rehabilitating his reputation was built on discrediting and blaming Caroline Ellison in a national and international publication that is read by many prospective jurors in this district, it crossed a line towards improperly influencing those prospective jurors, intimidating a witness, and sending a message to other prospective witnesses. I'll leak shit on you too. Interesting. And against the backdrop of the prior admissions, the other indications of evasion, including the use of VPN, blah, blah, blah. So we basically need to detain him. So defense counsel indicated the government that the reporter reviewed only certain portions of the documents, but didn't indicate which portions. To date, the defense has not asserted one way or the other whether the defendant shared these or any other documents with other members of the media. Interesting, including the other journalists who had visited the defendant's home. Government asked defense counsel for which documents were shared with the reporter in their original form, which arguably would have been in Word format, but has yet to receive a response. See that part. Kind of got to turn that over. Like if you're, I think they have a right to that. You've just disseminated it to a third party. So, application of law. I don't really want to go that far into this because this is all new. Discussion. Detention is warranted. Twice attempted.
This is a very interesting case, actually. The more I'm looking at it and listening to you talk, the more you talk, the more interested I become. It's fascinating. I don't usually do federal stuff. I don't do federal stuff except for U.S. Supreme Court certs.
It's the interplay of the bankruptcy with the federal prosecution has been remarkably fascinating to watch.
Wow. Yeah, this is a deep dive, boy. If you've got a quite an intelligent fan base if they're into this, because this is not the type of stuff that normally. This is like hardcore legal education right here.
Oh, some of them tune out, but we have a lot of fun.
This is fascinating. It really is interesting.
Well, because it's chase the money. That's where it is.
Yeah, lots of money.
It's chase the money. So now they're asking for pretrial detention. They're not going.
And I have, like, having dealt with Ponzi scheme people, people who on all sides of it, actually, I'm always, it's amazing. You talk to these people and it's like, do they really believe what they're doing? It's incomprehensible because, people say, well, I would know. They're very good salesmen and they believe what they're saying, or at least it appears they're very good deceivers. Well, of course they would be. If they were obviously liars and obviously crooks, nobody'd be giving them millions of dollars, right? So they're very convincing, but it's like they convince themselves. Have you seen
a photo of him?
Of the guy?
Sam Bankman-Fried?
No, let's see his picture.
Hang on. So Sam Bankman-Fried. So one, he was viewed as a credible source testifying before Congress.
Right. Well, and they're
cryptocurrency matters.
That's why I prefer my friends to have a little edge with them, because they're not trying to shine me. And this is the thing. When somebody's too smooth and too convincing.
He wasn't. He would play video games during conference calls. Like people would be calling him. He would be testifying.
What is the source? Who is investing in his company?
Everyone. I am not kidding.
Why were they investing?
Everyone.
What's the appeal? Why would I give him millions of my dollars?
He spoke in complex language about a lot of ESG and effective altruism. Our company isn't about the almighty dollar. Our company is about doing good for humanity. But you can still make a profit because cryptocurrency is cryptocurrency. It is amazing. So he did press conferences with, he sat next to Janet Yellen, Bill Clinton, and various others on a panel testifying about the state of the U.S. economy. This person was viewed somehow as a trusted source. So I don't know.
Yeah,
and
it boggles me. And this is the thing. I see good people out there, and we have hardworking folks that are working very hard for the little money that they make, and nobody wants to listen to them. They're flyover country. We're looking down our nose at you, and then we get Janet Yellen sitting in her ivory tower, bailing out big banks and shuffling money around, billions and billions of dollars around like chess pieces on a board. And they want us to respect them.
Oh
Right.
yeah, no. So his parents were also, so his two parents were Stanford law professors. One of them was deemed to be one of the preeminent tax scholars in the entire United States. That's the father who has that $10 million that went to pay for his house. Of which it really is, it's disgusting. And when you
Yeah, well,
read
and
all
there's
of it,
this Ivy League incestuousism, right? Which
oh,
is this elite, this
guess who
group of
posted
elite.
his bond?
What's that?
Guess who posted his bond?
Uh-oh. Oh, no. Well, who posted his bond?
So his parents put up their house as collateral. By the way, the house sits on Stanford University property, so it's a land lease. So they own the structure, but not the
Right.
land. So it's not worth anything what they said it was.
Uh-huh.
And then two other individuals put up surety bonds. One of them was the former director of research at Stanford. The other one was another Stanford professor.
Yeah, it's these Ivy League that think that they're better than us.
It's
And
really,
I mean, I don't like this guy is a freaking criminal. Where's the oversight? Okay, you brilliant eggheads. Where's the oversight on these companies? You know, and this is, if they're making billions and people are investing, and they're sitting there telling us what we're doing and what they're doing. They're controlling the bank and they're taxing us, taking our money and shuffling it around to benefit, and they're bailing each other out. I mean, we really have a problem with elites and corporate governance and a lot of these Ivy Leagues. There's an elite versus.
and this is why I don't talk politics, because it's not political when I come down to it, because my position is that they are all looking out for one person only, themselves. Self-interest is the only thing they know.
Well, I mean, is that a political? I mean, it is an observation on the state of our political economy, and I'm not throwing aspersions necessarily on either side. There is an elite group that thinks that they're better than us, and it really that's one thing I love about coming on these channels and talking with people in our chats and everything, because you know, when I vacation, I don't go to these places, and I don't want to talk to. I want to talk to real people who have real jobs, who are honest, who have opinions, who can stand up for themselves. And you know, we really, I mean, this is a problem because they're taking the money. Tax dollars are taken out of my pocket by the barrel of a gun, right?
Mm-hmm.
If I don't pay my taxes, I get locked up, and they're taking that money and giving from grandma and grandpa and fill in the coffers of these big elites and these big corporations. I mean, I sound like a commie or a lefty here, but I'm not. I'm the other side. But it's a mutual problem, right? We have a problem.
It just exists.
Huh?
Yeah. This was the other part. Opposite of Amnesia is reminding me. He scammed Kevin O'Leary. He scammed Shaquille O'Neal, Tom Brady, all the Golden State Warriors, Miami Heat basketball, the NFL for the Super Bowl. He scammed every single one of them. He also, the entire company, FTX, the multi-billion dollars that were moving in and out of that company on a daily basis, they use QuickBooks as their accounting software. I shit you not.
You know, I don't know. You know, it's hard for me to. Well, I have dealt with this, and it's sort of incomprehensible to me. But it's it's like crime. There are these crimes. Like, does this guy know he's ripping people off this bat? Did he start out with some idea that?
No, Steve, it's if you read through any of his communications or anything this guy says, he is the embodiment of the people that you are describing, that you don't understand. Like, you just don't understand. That's his mentality. Like, you might think I'm doing wrong, but you know what? You little people, you just don't understand.
But see,
you just don't get it yet.
That arrogance of the elite, which is like, we're stupid. You're the ones, and in fact, that's people are getting, and that's a big problem throughout our society. And that is that people get off on being better than others, and by identifying, you know, I'm superior to you because you're everything that I don't like. Therefore, and I project everything onto you, and it's this projection that makes me feel good about myself. I don't know. It's a problem. I don't know. I have my theories and prepare, which I have explored pretty deeply. But well, anyway, I'm sorry. I'm interrupting your stream.
No,
you have,
not at
you
all.
have a wonderful group of chat. You have some people that are following this. I respect you because this is some interesting stuff. And I I have my own little world. It's over here in the death penalty world and the crime world. And then when I go, I want to read fantasy novels and not this sort of depressing stuff. Because this is our country. This is trust funds. These are people who work hard, and their money is being taken from them and given to the powerful.
Mm-hmm. The Ontario Teachers
There's no
Union
political justification for that, on the right or the left.
Yeah, it's pretty remarkable. But all right, Steve, I got to catch up on super chats. You gonna stick around, or are you gonna peace out?
I'm sticking around. I'm having fun. This is energizing. I really thank you very much for letting me on your show and talking. It's an honor.
Of course, I'm loving it. Joshua, thank you very much. Thanks again for another great FNF. Have a wonderful weekend, everyone. Thank you, Joshua, for tuning in and hanging out. Private Island Eugenics Mass Unaliving. Steve, I'm going to traumatize you with some of the filings at some point in time. Dude, look into them. I'm not kidding. And it's not remind me later. I will share a Google Drive where I have a bunch of the bankruptcy filings saved. If you are ever interested, it's pretty freaking interesting. The bankruptcy documents are where you get most of it, because the prosecutions, they don't divulge a lot before trial, but bankruptcy, yeah, you get a lot. Diamonds and Henna. Steve knows how to party.
Diamonds and Henna, good people. I know them. I met them down in Miami.
Susan Ferrier, thank you so much. So sorry I'm late. I was at a Hollywood Vampires concert. That's awesome. We'll catch up tonight. Enjoy the weekend. Susan Ferrier, I hope you had a wonderful concert, and I hope you got to wave to Johnny Depp and say what's up. The Lauren, can practical jokes be illegal if they cause harm? Yes, they can. In New Orleans, someone put a flashbang in their car to deter thieves. We talked about it earlier today. It was effective in the moment. I think it might subject someone to liability in the future if something were to go awry in the flashbang going off. Crazy Cat Queen, would a surströmming bang be considered criminal? Yes, surströmming in any fashion that explodes in a vehicle is criminal. Crazy Cat Queen, grand jury equals a jury made up of grandparents. Close. Ryan Man YYC, Catco v. Briney. Oh my God, why do I not? The gun trap. Yes, this is the spring gun case.
Yeah, spring guns. Yeah, we all studied that in law school.
Northwest Reporter, 2nd, 657 from Iowa, 1971. Yes, it is the spring gun trap. You're right. Spring guns are indiscriminate. Booby traps are indiscriminate. However, there's the spring gun argument, and then there's the putting hot sauce in a sandwich so it doesn't get stolen argument. That one might not be unlawful, but there's this world in between, and we're not sure where that flashbang in the car ends up. Ashley Duchamp, thank you very much. Off topic, I asked Peter when we were getting a golf charity event with the two of you. Let's make it happen. I agree. I need my golf game to get better. His is on point. I don't agree with him in one bit. I believe he probably shot very well. Tammy Lee, can't handle the testosterone in the room. LOL.
That was when Peter was here, not me.
Oh. Steve, come on. Give yourself more credit, bud. Joe Lloyd, great job, Rob. Thank you, Joe. Professor of Logic, if anyone wants further info, Steve has written 3 articles on every section of this already. Yes. Steve loves to research and write. And he's a wealth of knowledge, and I love his contribution to these live streams. Whether he's on with
I do. I mean, these are all my books back here, and I've got more coming, but yeah, it's a long story, and I won't bore you, but thank you. Yes, please do go to stevegosney.com and look, and there's a book there for you. I'm sure I've written something on it that you might like.
Tons of material, wealth of knowledge, and a great contribution. Just me, $500 to Captain Corey. Thanks, lawyer. That's amazing. The contributions I've seen given out have been really impressive. Tina Critchen, appreciate your deep dive on the grand jury, gents. Thank you very much. Much appreciated. Nola Diva, thank you very much for the super chat. Crazy Cat Queen, if this indictment is thrown out, how does that affect the speedy trial issue?
That's actually a good question generally, but on murders there's really no speedy trial on a murder. Well, there's really no statute of limitations on a murder. There would be a speedy trial, but I think your speedy trial,
it would start upon charge.
Okay, I'll back up. Let me just say,
the charge trial.
There's so many exceptions to the speedy trial rule that it basically doesn't exist. The only thing speedy trial is good for doing is forcing the state to bring you to trial. Very, very, very rarely does anybody ever get a case dismissed because it ran afoul of the speedy trial rule.
They don't.
You
They just
don't.
not with prejudice.
There's
Without
a case
prejudice
out there. I'm sure you can say, well, what about Iowa versus so and so? Where it happened and it was on a petty drug theft deal, on a murder
Yeah.
charge. The courts will find a way to defeat your speedy trial rights. The only thing it's good for is for the defense to force a case to trial if they want
to push the prosecution to move it. Yeah. And to hope that they in the process thereof screw up with discovery deadlines, because then you might have them behind the 8 ball on something. Because it's not the trial date they're afraid of, it's the deadlines that lead up to it, and making sure that they've got all their ducks in a row leading into it. And you might catch them in missing a document, a disclosure, an expert, something on the side. But yes, Joshua Ten Hag, thank you very much. Can we get Rob to 200K soon, please? I would love that. For those of you that are here, please like the stream. And if you enjoyed the content and the panel and the discussion, please consider subscribing. And as well to my friend, Steve Gosney. Joshua, thank you for that double super chat, 200K. I very much endorse this. MLS Law Show is great at master legal studies.
That's a good. He was talking about.
It's not bad.
Good. Master legal studies, like it.
Yeah. Bob it. All of LawTube. It's Friday. Let's go to Rob's place.
Yeah. For a while there, you had like everybody here, man.
Everyone. Let's go. What's going on in the chat? And it was just wild. But yeah, that was fun. That was great. Crazy Cat Queen. If a Sov Cit hires Steve Gosney, are they even a legitimate Sov citizen?
They can't hire me. I'm appointed.
Oh, but then they would fire you. You know they would fire you if they were true Sov Cit.
Oh, I don't. I've got stories.
Mary Coppola, hide and seek in a suitcase. Who does that? Long letter. That case is just, it's wild. And it's going to trial.
My wheelhouse. That's in my wheelhouse. So I'm looking forward to that one.
And that's going to trial. And that
she's not
defense counsel is going to be bashing his or her head against the table, trying to convince her not to testify. Oh, I can't even. That dialogue.
It's going to be another Schabusiness trial. I mean, she's a train wreck. She's guilty. She's going down.
It's worse because I cannot see a defense counsel convincing her not to testify. At least defense counsel Schabusiness had her basically said, "There's nothing that goes well by this. Nothing goes well by this."
Good. From a LawTube perspective, from a perspective of an observer and a chatter and somebody. Everybody was rooting for Schabusiness to take the stand. They were like, come on, take the stand, take the stand. I'm like, look, you guys have your own vested interest.
So. I know the lawyer in me hurts to see that. I can't watch it. It just hurts. Crazy Cat Queen. What if Sarah Boone's defense can't find an expert to testify to her battered spouse defense? That does. That happen.
I will tell you, I know more than I need to let you know. This is exactly the problem that's happening. And what the problem is how long. Well, see, this trial will be drawn out as long as the judge has patience with the defense. At some point, he's going to run out of patience with the defense and say, I don't want to hear excuses. We're going to trial. Here it is. And it's just a matter because she's trolling. She's not going to find somebody. The first expert, they don't write a report because they're retained in the report. If they said, here's my findings. And if they do a report, they have to disclose that to the state. Well, if they're saying, look, your person's screwed, then the defense attorney says, don't write a report. You're just my advisor.
And here's what happens. Defense attorney is meeting with the professional. Professional says your client's screwed. Defense attorney goes back to the client and says, you're screwed. They said no. Client says, I haven't seen it in writing. Defense attorney says, I can't put it in writing. Client says, I don't believe you if it's not in writing. Defense attorney says, I can't put it in writing. It's discoverable.
And
client
it would be malpractice to
you're
do that.
Wrong. Exactly.
Oh gosh. Stories. Well, we got stories, but yes, this is exactly the problem. And clients, they want to, well, we had a case, a guy, he wanted to ask the expert, the question that he did not want to ask. And he fired his lawyer in court on a first-degree murder charge because he wanted to ask the question whether he was competent. And the conclusion of the expert was, yes. Yes, he was saying, right? But he's like, you got to ask him the question. And we had all this predicates, and we're like, we are not asking that question. You're going to get the wrong answer. We know it because we've discovered it, right? Oh, no. He's just so insistent he wants to ask that question, so he fires our office.
Mm-hmm.
So I mean, it's like I don't know.
It happens.
You can't. There's no
It
fixing
happens.
stupid.
But you do the damn best you can to prevent them from their own stupidity from harming themselves. That's what you do. You try to prevent
if
them.
people come in with a big cancer on their neck, and you try to excise them and preserve their life as best you can, and sometimes the cancer is terminal.
Yep. Peggy Reardon, if she is correct that her attorney hasn't seen or heard from her attorney in that length of time, that is a problem. She has the right to participate in her defense. Yes. I think that there's probably there's her story, his story, and a place in the middle that's probably the truth. And that's kind of where we might be.
Although
there might be
when you
communication,
have 6 or 7 attorneys that are all saying the same thing, and you have her writing incoherence and the level of intelligence that we know that she's revealed, I think that there's the credibility issue is on the other side.
And Peggy follows up. There's correction. A couple of attorneys had conflicts due to prior representation of the boyfriend. One for sure was moving in on 1 week to another area. So there was a couple of the 6 or 7 that have been conflicted out. I know that I think 2 or 3 of them have had issues to the point where they had to seek withdrawal for this reason in particular. But yeah, the attorney has to communicate. And the judge has done a good job of preserving her rights here. The judge has done a great job of continuing the pretrial conference to allow the defense ample time to consult with the expert.
Judge Wooten, right?
Yes.
Yeah. I do. Our jurisdiction used to be Orlando. We just traded Orlando for Jacksonville. So I know Wooten. I've done a lot of appeals out of his courtroom because he's a felony judge in Orlando. So yeah, I mean, we'll see.
It's a tough call. We don't know. We don't know because there's this, and the truth is somewhere in between. So Rosalind Duke, thank you. Bouncing. Thanks for thank you, panel, for sharing your knowledge bombs. Thank you very much, Rosalind. Sarah, thank you. I love these debates so much. I do too. They're fantastic. Ryan Man YYC, not bad faith. How do you know what your client understands or doesn't?
Oh, that was yep. Okay, this was our disagreement. Well, you're making judgment calls all the time as a trial attorney. And it is that's what your job is. Your job is to make judgment calls. And that one of, I mean, I know when a client is able to assist in the defense or not. I mean, you've done enough trials, you've dealt with enough clients when they're helping you, when they're communicating, when you're dealing with it, right?
Yeah, but it was a debate. It was a good debate. I like having that. I think that each time we get that, we get to argue the issue out to just because we don't reach an agreement at the end of the debate doesn't mean that either one of us are wrong.
Well, and also it's also for the benefit of your people that are watching. I mean, we're fleshing out the issues on either side to show that, like, look, this is not clear cut. There's not a right and this wrong in these things. Sometimes there's 2 bads and there's 2 goods, or sometimes it's sort of in the middle and you don't know. And that's why you have these discussions to try to flesh out, like, to game it, because we try to bring out the best in each other, and ultimately, you decide, or there's processes by which these things are decided. We're just opining our opinions, right?
Yep. Crazy Cat Queen, why does Sam Bankman-Fried get so many chances? Anyone else would be in jail by now. What the actual fuck, man? This is just the judge saying stop, or I'll say stop again. I don't know. We'll see. Judges are, and it depends on the judge, but a lot of the benefit of the doubt is extended where it's possible. Is that done unfairly? Yeah, a lot of times. Is it based on money? I'm just being honest with you, kind of. Like, the person who has the resources can generally make the arguments to keep themselves out of jail. It's kind of bullshit, but I do what I can to argue against it, or at least make it known. That's the part. It's the information. How many people would know about this if we weren't talking about it? Crazy Cat Queen, isn't Coburger's defense still trying to force discovery of the genealogy that led to this arrest? I thought they had 6 months plus 34 days for speedy trial. They got a pause to challenge the grand jury indictment. This is the challenge to the grand jury indictment. I don't know how long it's going to last. I will do this. It is 12:48 a.m. in the morning. My mental ability to remember every detail about this case is about at its very, very outside limits. I'm going to say that Andrea Burkhart has covered the ever living hell out of this case.
Yeah,
a
she's
phenomenal resource when
she's
it comes
great.
to Coburger.
Brilliant lawyer. And she's right there and she knows the jurisdiction. Well, let me add on. I'll give this thought on the speedy trial issue. There's so many ways that you waive your speedy trial. So they're saying, okay, we are demanding speedy trial. But then you say, are you ready for trial? The answer is no. Have you demanded discovery? Have you participated in discovery? Do you have outstanding motions? By doing a lot of these things, you're actually waiving your speedy trial rights by acting. Okay, so there's so many ways out of the speedy trial box. People think that, oh, he's going to walk because they violated his speedy trial rights. That's what all my clients think, and they're all wrong. We talk about that. All a speedy trial can do is force a trial. That's what it does. And the getting away with it, no. Rabbit, Rabbit knows my website. Come on, Rabbit. So I'm interacting with your chat. I like your chat. You got a good, you got a great chat. I judge a person by their chat.
You're welcome anytime. You're welcome anytime, my friend. The Lauren, how/why did you decide to become a lawyer? It seems to take a level of patience that some don't have. Thank you for F&F. Enjoy your weekend. Well, I don't know. I kind of always argued a lot of points. I was raised by engineers, and I had a chemistry professor who always thought I was going to be a lawyer. I decided originally to follow my parents' path, pursue engineering, stop seeing the numbers, but was still arguing the point. Several years later, when I actually graduated law school, I went to a bar with some friends and ran into that chemistry teacher from high school. And he looked at me straight in the face and said, "Did you become a lawyer yet?" And I said, "You son of a bitch, I took the bar last week." Like, it was literally after I had just taken the bar. I don't know. I just always kind of liked to make the point, and I didn't like to be wrong, but I liked making the contrary point. I loved debates. I would pick the opposite side of every argument and try to make it. So I don't know. Do you have a similar story, Steve?
That's a long and winding road. We'll talk about that some other time. I will say that I was a latecomer. I did nonprofit association management. I used to be the executive officer for our local home builders association.
Oh, wow.
So we'd run the parade of homes and do legislative lobbying and things like that. Did that for about 3.5 years. I'd worked for realtors for 3.5 years, and then went to law school because that's just the thing to do. And then went into civil litigation for 6 years, and then didn't do enough trial work. So I went into the prosecutor's office for another 6 years. And now I've been in appeals for 13 years.
Jeez. you find something, and you realize that what you do matters, and it means a hell of a lot to you, and it exhausts the hell out of you. It beats the hell out of you. It takes a part of your emotion. It takes a part of your soul. It takes a little bit of you every day. But when you're asked if you could imagine doing something different, you kind of go, no.
Well, I appreciate the job that I have now. I think I'm very well suited to it, but I think I'm good at it because of the background and the fights that I've done in my other career paths that were not as easy for me as the person I am. I think that the job that I'm in now, doing criminal appeals for the public defender's office, is almost perfectly suited for my personality. But to be good at what I'm doing now, I had to go through all those battles and fight all those fights. And in the road. So there's no easy. It's like if I had gotten this job right out of college and went to law school immediately, then got it, it wouldn't be the same. I wouldn't be the same person. So you have to follow the muse. You have to follow the life path that God gives you. And sometimes you're wrong. But that's okay. It's your life. And you just got to make the right choices for yourself.
Yep. Find where you fit, make all the mistakes, get back up, try again. Crazy Cat Queen, thank you very much for the very generous super chat. Thank you, Rob. You're the best. Sparkle farts forever. Sparkle fart, sparkle fart, sparkle fart. Emojis.
Crazy Cat Queen. I love the name.
It's fantastic. And then a follow up for you, Steve. Thank you, Crazy Cat Queen. Thanks for joining, Steve. Loved your input very much. If you like exposing bank financial fraud, consider Panic in Paradise and Panic in the Loop. My professor does a lot of digging, still working on stuff to expose further. Interesting. Okay. There you go. There's a recommendation.
Thank you for that kindness, and I love the picture. Beautiful cat. I love cats. I'm a cat person. My dog was around here earlier, but my son is really, really allergic to cats, so we can't have a cat. But I love kids.
Rachel Mills asked me this question a while ago, and I needed to answer it. What happens when you try to seek a divorce when someone's in jail or prison? A comité is appointed. It's essentially a guardian ad litem, except for the estate. The comité is a third-party attorney that represents the person who is incarcerated because they are under a legal incapacity. They are not actually capable of serving as a defendant in civil suit without a representative. The comité represents the defendant's interests while they are in the divorce litigation. It becomes complex, but it is possible. So it's just a different set of rules. It's just a new box of law within a new box of law. So I have done those cases. I get one every now and then, pretty rare. Kristen M96 EDB said, tell the Wood Daddy Stack story, but it's late. Steve Gosney, if you are ever bored, just type into YouTube Wood Daddy Stack and you will find yourself in a realm where Emily D. Baker, myself, Richard Hogue, and Ian Runkle were all on a live stream together, and Emily Baker in her chat got hashtag Wood Daddy Stack, which was referring to me, trending #1 on Twitter.
Wait a second, I got to write. Hold on, hold that chat up. I've got to write this down because I always write notes to myself. Here we go. I have little yellow stickies. This is the way I operate. I write these things down. So, okay, Wood Daddy. See, I've got to know. I got to clue into the memes that you guys are bouncing around.
It's like a 10-minute. It's like a 10-minute little. Someone has clipped a 10-minute video of everything together. It's wild. It's really funny. JR, I want to be a lawyer until I realized I was basically just writing research papers all day, every day, forever. So much respect to both of you. There's a lot of writing.
Well, that's what a criminal appeals is. People ask how I do the book so fast. That's all I do.
It's a lot of writing.
Yes, it's writing. But, it's sick, but I really enjoy writing. You know what I do is I come home, I'm writing a fantasy novel on with dragons.
You're out of your mind. Really? Voluntarily?
Oh, yeah. I've got a children's book coming out, and I've got a fantasy novel I'm working on. It's right here, actually. This one here. See, this is how much I've got. It's about 30,000 words right now, and yeah, I need to get about 100,000. But I know where I want to go with it. But I come home from work and I write my fantasy novel.
Good. Cheers to you, my friend. Better thee than me. Wow, that is ambitious. I have to highlight some gifted memberships because StreamYard doesn't show them to me. So Jeremy Morton, thank you for gifting 10 memberships. Then there was I'm missing one. No, I'm not. Yes, I am. Wanted to thank Vez for gifting 5 memberships. Brentwood Chic for gifting 20 memberships. Lori Leanne gifting 5 memberships. Thank you very much for that. Rabbit, 5 memberships. Crazy Cat Queen, 20 memberships. Thank you. Joshua, 5 memberships. For all the gifted memberships and for those who sent member chats, StreamYard will one day fix that where I can pull that up and find that. But thank you guys for being here. For those of you who were gifted membership, we do shop streams where I go through the different things that we are working on in the shop, including things we're throwing on the lathe. Like what do we got? That's the blank I made last night. So that's going to be.
Ooh, that's cool.
Yeah, that'll be. There's a chunk of wood in there, but that'll be a.
Oh, that's right. You are log lumber. Well, we got so much to talk about. We can come on and just talk stuff. I mean, I'm a big fan of beautiful wooden guitars, beautiful wooden furniture. Like I collect stickly furniture.
I wish I could be a luthier, man. This is so freaking hard, but it's so cool.
Do you ever been to the Stickley Furniture Factory up in Mount?
No, I have wanted to go though.
We went up there and it was great. I'm a big Stickley fan, and I collect arts and crafts movement furniture.
Very, very, very arts and crafts. It's arts and crafts origin. It's just basically that's the design. So.
Right, mission style. Everybody's asking in the chat this is my website, stevegosney.com.
stevegosney.com.
So books, and there are ebooks, there's audiobooks, there's hard books, there's soft cover books, there's music too. There's actually my music available, but that is secondary. If you're gonna, death penalty debates, ideas and answers in law, prepare. There's my summer friend, which just came out, which is an adolescent story about living on the beach, mostly true. Oh, look, advices. You should turn out some pipes. Oh yeah. He tries this. Do you ever do pipes?
I've got kits for them, so yeah, I can make you a pipe, bud.
I'm not a piper.
No, I can make him one.
He wants one with Cthulhu on it,
Well, that's gonna be tough. That's turning and engraving. Hempland, Texas. Isn't it easier to divorce someone in prison than someone you can't find or someone being an arse in the divorce? Yes and no. However, in Virginia, there is a statute that says that if you are seeking to divorce someone who's incarcerated, unless they are incarcerated for a crime that is the crime of violence against you, domestic abuse against you personally, then you have to pay the attorney's fees for the person who's incarcerated. Don't look at me. I didn't write the law. Talk to your legislature if you don't believe that's right.
Are you a Virginia lawyer?
Yes.
Okay. I went to Washington and Lee, you know.
Oh, W&L.
Yeah.
The Generals. Used to play you guys in lacrosse.
Yeah, you know it.
Yep. All right. We're going to wrap things up for the evening. Thank you guys so much for being here. I very much appreciate each and every single one of you. Thank you for those who sent member chats. Thank you for those who sent super chats. Thank you for those who just engaged in the chat and asked us all the questions. Please subscribe and go and check out each and every one of the individuals that were on stream tonight. Lawyer, Peter Tragos, please check that channel out. Steve Gosney is available at stevegosney.com on YouTube, but also prefers to stream on Rumble. So please check him out on Rumble. MLS Law Show, check him out. He's on YouTube streaming as well. So, like I said, I didn't miss anyone. No. Then we had people in the chat that were chiming in. Emily D. Baker, Kurt from Uncivil Law, Legal Vices was there. Literally, everyone was here tonight. Natalie Wisco was here. Guys, it's a really cool community of a lot of lawyers with a lot of just discussion on stuff that we find very interesting. We're glad you do too. Steve equals Bookstack Daddy. That is probably the most appropriate name I have seen in a long time. So, Steve, you have been named by the chat as Bookstack Daddy. All right. Hope you all are doing well. We are going to sign off for the evening. Thank you. And we'll catch you next time.